and so forth, where the president has broad discretion, and the court has consistently held in those cases where the president's granted this broad discretion, that that's not judicially reviewable. And there's statements to that effect, obviously in Marbury itself, that they disregard pages 165 and 166 of Marbury. But even if the court doesn't accept that, there's a further layer here, which is that they've conceded this is an ultra vires challenge. And this court held last term that the standard of review in an ultra vires challenge is very, very high for them and very deferential to the president itself. It kind of, dovetails with our Dalton and Martin argument as well. In an ultra vires challenge, the burden would be on them to show that what the president did is entirely in excess of his delegated powers and contrary to a specific prohibition in the statute. So there's kind of three ways to get to the same conclusion there, which is that once the president's made a determination, it clearly does relate to conduct, fitness, ability, or competence for that office. Then at that point, there's no work for the reviewing court to do. The traditional discretion to the president's determination would kick in.
Counsel, were any of these questions, except the constitutional question, decided by the D.C. Circuit?
The D.C. Circuit, in its stay opinion, relied exclusively on the sort of
notice and an opportunity to be heard. That's what it said the Constitution required, correct?
It said that, yes. It said there's a property interest in this office under Loudermill.
That's the only issue it addressed. It did not address all of the things you've talked about today. What the definition of cause is, including whether it includes pre-office conduct and how much or what nexus there has to be between pre-office conduct and post-office conduct. One could imagine that what would constitute for cause during office would be different than what would happen pre-office. Even yourself below said if something was known before confirmation, you likely can't rely on it. You haven't quite said that up here, but logically, pre-office has a different temporal connection. Then the court didn't address whether the president's determination of cause is reviewable and under what standard. Ultra vires seems to me to be whether or not another, and that's what all our cases have ever said about ultra vires situations, whether another entity, another adjudicatory entity has jurisdiction or we do. And three, whether Cook has a right to notice and hearing under the statute and what that means, and what remedy, if any, Cook can seek now or finally in the case. You ask us today in this emergency application to provide, to finally decide these issues. I want to know why. Meaning, the president, by your own admission, cannot fire someone for disagreeing with his policy choices. You've conceded that, correct?
Correct.
All right. So it's not as if keeping her is going to thwart any right he has to run the department, because he has none. He's conceded that. On policy, he does not. Now, it's not as if she's been incompetent, negligent, or committed malfeasance while in office. This is something pre-office. So keeping her in office is not causing an immediate harm to the agency. Number three, we know that the independence of the agency is very important, and that independence is harmed if we decide these issues too quickly and with not due consideration. So waiting, to me, to have at least the lower courts look at these issues first makes the most sense to the public's confidence and to the world's confidence about the due process of law. Explain to me why the president's harm is greater than the public's, greater than the Federal Reserve, who deserves to have people acting that have been in office. And number three, why we should disrupt, as we said in Boycott, the disruptive effect of repeated removals and reinstatement of officers. Why shouldn't we wait till the end of this case, where all the issues are clear and where we make a final decision as to whether she should have been removed or not?
Let me start by addressing that last point. We are seeking a stay of an unprecedented preliminary injunction restoring a principal officer of the United States after being removed by the President of the United States.
112 years, and it's unprecedented that any Federal Reserve officer has ever been removed. So the unprecedented nature of this case is a part of what the president did, not what Ms. Cook did.
I think that statement has to be qualified by the recognition that there have been situations where governors have been credibly accused or found to have engaged in financial improprieties, and those governors have resigned. Financial improprieties that are quite analogous to what is at issue in this particular case. But I want to make the fundamental point that in Sawyer, this court held that a preliminary injunction was not available to restore an officer. Sawyer was a preliminary injunction. It's a preliminary injunction against the...
That's true, but weeks later in Drago, we permitted an officer who was still there to stay. So that was a case of reinstating someone. We have plenty of cases that say keeping someone in place who hasn't left yet is different than issuing a preliminary injunction.
I think the court's referring to the Delgado case, and in that particular case, it was a writ of mandamus to an inferior there, the clerk, to recognize the de facto officers when there was dispute about who had been validly elected to be the city commissioner or whatever the statute was. And this court said you could grant a final judgment in mandamus to say you have a ministerial duty to recognize the de facto officer. That is totally different than issuing a preliminary injunction. Keep in mind, there is no such thing as final mandamus. And in fact, Judge Friendly once described that as the starkest of solecisms. Sorry, there is no such thing as preliminary writ of mandamus. Judge Friendly described that as the starkest of solecisms. What this court held in Sawyer is there is no jurisdiction to issue a preliminary injunction restoring a public officer to office. And that's a holding of the court.
She never left. She's still there.
She is reinstated. What the court framed its holding as, there is no jurisdiction over the appointment or removal of inequity of public officers. So it does not turn on whether or not she's sort of, stoutly staying in office or whether or not she's gone and then sued later. That it doesn't, nothing turns
General
out.
Sauer, can I ask you a question that's also related to the stay factors? Justice Sotomayor brought up the public interest here. And we have amicus briefs from economists who tell us that if Governor Cook if we grant you your stay, that it could trigger a recession. How should we think about the public interest in a case like this?
Yeah, two things to say about that. One is, if you look at what actually happened here, she was removed on August 25th and the stock market went up for the next 3 days. So we've already had a kind of natural experiment, so to speak, about whether or not the predictions of doom will really be implemented. And surely that if investors are jittery or whatever the argument is, you would have seen that on August 25th and you did not see that. In fact, you have these surprised.
Well, I'll interrupt you there to say that I don't want to be in the business of predicting exactly what the market's going to do.
I agree, and that's why I think the court ought to consider all those amicus briefs and their sort of, predictions of doom with a fairly jaundiced eye. What the court has to do is weigh. Essentially, you have those amicus briefs a reflection of very elite opinion that
but there's a
happened.
risk, General Sauer.
Yes.
I don't want to be responsible for quantifying that risk. I'm a judge, not an economist. But if there is a risk, doesn't that counsel in the stay posture when the equities are at stake caution on our part?
I think the court has to weigh that risk against the risk that there will be a permanent damage to the Federal Reserve's credibility from allowing an officer, a governor, to remain in office who's engaged in this kind of behavior before she takes office.
Well, do we also engage in some weighing of our own about how serious we think the misbehavior was in the stay posture? And I'm not talking about once the case was here on the merits, but if she were accused of murder or something like that, if we're talking about something that was really an infamous crime, should we take the nature of the crime into account in the stay posture in the weighing of the equities?
I think what the court ought to take into account is the close nexus between the conduct at issue here and the duties of this incredibly powerful position that has sweeping, powerful authority over the entire United States economy. The governor set interest rates for ordinary Americans all across the country. And here, there's the appearance of having played fast and loose, or at least been grossly negligent in getting favorable interest rates for herself.
So it's appropriate
What's the
to take
message to
notice.
ordinary Americans that comes out of that is the question for the court. And how do you weigh that against the elite opinion that's reflected in the amicus briefs? Obviously, President Trump's voice speaks to that concern of ordinary Americans. I think when the balance the equities, what the court ought to do is look at the merits, which are extremely strong for us, and then look at its traditional and can stay factors. The court says when the government is a party, the irreparable harm to the government merges with the public interest. And here we have traditional irreparable harms, injuries to the president's ability to remove a principal officer of the United States. When you look at, for example, the original evidence we've talked about in the decisions of 1789, when everybody said, or both camps were saying, of course the president can engage in suspensory removals, and we have a preliminary injunction that is conspicuously non-existent, in your words, in CASA, for 225 years of American history.
Mr. Sauer,
that's how it should be balanced.
General Sauer, excuse me. I guess I think you may have to be a little bit more specific with respect to the irreparable harm that you are alleging, because really, as Justice Barrett sort of indicated, we are in a stay posture here. So the question is, to what extent do we believe that the president or the public is harmed by allowing Ms. Cook to remain in her position for the pendency of this case? I'm not sure that we have evidence here that Ms. Cook is an immediate threat to the public, that she's been in this position for a long time. The kinds of things that you're pointing to, as Justice Sotomayor indicates, are not related to conduct while in office. So it would seem to me that on the stay factors, you would have to say more about the harm of leaving her there for the next however many months while this case is being litigated.
We have a remedy here, which is a preliminary injunction. This court squarely held in Sawyer there was no jurisdiction to issue.
Yeah, but
So
I'm not
stop
talking about
framing-
I'm not talking about the court's power to do it. I'm talking about assuming we have the power for the moment. I appreciate that you say we don't, but assuming that we do, the question is, what is the harm of allowing that injunction to remain because she's in office now and would just continue?
Among other reasons, we assert grievous, irreparable injury to the public perception to the Federal Reserve of allowing her to stay in office. They argue that this is going to cause the markets to tank.
And you have
When he was
evidence
first removed,
related?
They didn't tank.
You have evidence related to the public perception, or is this just the president's view?
The president has made that determination. It's reflected in the language of the dismissal order. And as I
Did the
discussed in my
president
opening,
make
there's
that?
this close
Did the
link.
president make that determination based on evidence presented to him in the context of some kind of hearing related to Ms. Cook's conduct?
The Federal Reserve governor who sets interest rates for the entire country appears to have engaged in improper behavior.
No, I
Paid
understand.
favorable interest rates for itself.
You're
Race
repeating,
ipso loci.
Counsel,
You're
please
repeating-
allow the justice.
I'm sorry.
you're repeating the allegation. What I'm asking you is the evidence that supports that allegation. Traditionally, when an allegation is made about someone's misconduct or whatnot, there's an opportunity for that person to present evidence, for the other side to present evidence. And even if the president was the final arbiter of this, one would expect that he would do so on the basis of evidence. So what I'm trying to understand is, what is the evidence that has been presented and considered with respect to Ms. Cook's alleged misconduct?
Well, the removal order addresses that because it.
What is the removal order? The Truth
it's
Social post?
No, it's the August 25th letter. I think it's Doc 1-4 in the district court. But the removal order addresses that. The evidence is you have mortgage applications within 2 weeks of each other that make clearly conflicting representation.
Was Ms. Cook given the opportunity in some sort of formal proceeding to contest that evidence or explain it?
Not a formal proceeding. She was given an opportunity in public because
In
she
the
was
world,
notified.
like she was
Yes.
supposed to post about it, and that was the opportunity to be heard that
Yeah.
you're saying was afforded to her in this
Yeah,
case?
yes, and she's had plenty of opportunities in the ensuing months where we've had ongoing litigation where there's never been a personal statement addressing that or justifying.
General, let's just suppose with me hypothetically for the moment that the court read the act to require notice and a hearing. I assume everybody has notice now. Here we are. What would that hearing look like?
I would point to what the court has said in Vermont Yankee, which this court is very reluctant to dictate procedures to even federal agencies. And here the court would be dictating, or a court would be dictating procedures to the president. I think they rely heavily on Loudermill. Obviously, we dispute that there's any notice and hearing requirement, but Loudermill requires only very minimal flexible procedures.
That'd be calling Ms. Cook into the Roosevelt room, sitting across a conference table, listening for I don't know how long, how much evidence is a lawyer required, and then making a decision. Could that suffice, you think? What would be required?
It would probably be if the court were to conclude that, it would have to be entirely dependent on the executive to decide. And that's what the case law indicates. Certainly, I think the question points out a great weakness in their argument, which is that the word cause does not include notice in a hearing on its face. Congress knows how to provide notice in a hearing. It did so in the NLRA 1 month before it reenacted the for-cause restriction here in 1935. And because it's not there, the court has nothing to provide guidance on that point. And if the court were to conclude that, it would be up to the executive's discretion.
Just a meeting across a conference table finished with you're fired? I mean,
all Loudermill says is that you have to be told of what the basis is of the allegations against you and give a chance to tell your side of the story. We believe that was provided in the 5-day window between the Truth Social Post and the removal letter.
and then you mentioned on remedy that there's no such thing as a preliminary injunction for mandamus. And I just wanted to hear you a little bit more on that. You mentioned Judge Friendly. Please, thoughts.
So the contention in the amicus briefs is that you could rely on Delgado to sort of bypass the holding of Sawyer and say that mandamus can provide essentially the same relief as a preliminary injunction. I guess the argument would be you'd have to mandamus everybody, so all the members of the board to treat her as if she's still a governor, all the staff to treat them as if they were still a governor, because Delgado held where there's the city clerk who can't decide who is validly elected city commissioner. The court held you could mandamus that clerk to recognize the de facto officer in the interim. And that doesn't work for a couple of reasons. First of all, this is a preliminary injunction. Mandamus would have to be a final judgment. And that's what Judge Friendly said. There is no preliminary mandamus. That's the stark as a solecisms.
Do I understand you, General, going back to Justice Gorsuch's first question, to continue to maintain that in fact there is no requirement for notice and opportunity for a hearing? Is that right?
Absolutely, yes.
And why is that? Just because it's not stated in the statute?
It's not stated explicitly in the statute, and Congress knows how to provide that because it did so a month earlier in a similar statute and has done so in many, many statutes.
It doesn't do that. Yeah, I thought that with respect to the neglect and efficiency standard, you do recognize notice in a hearing for that, but not in this statute. Why the difference? Because neither is stated.
Yeah, two reasons. In both Shurtleff and Reagan, this court expressly recognized that that phrase INM or specified causes would bring with it notice in a hearing. And that's part of the court's holding in Shurtleff as I read it, because there it was an INM standard,
right,
and there's a removal with no notice or hearing, and the court held, well, clearly this wasn't for INM because it was notice in a hearing.
Your reasoning would be that that was a mistaken holding, because since it's not stated in the statute, there's no need for notice and hearing.
Not exactly, because the old soil argument that we reject as to just simply cause is, we admit, much stronger when it comes to specified causes. So we don't think the court necessarily got it wrong in Reagan when it said specified causes mean that notice and hearing are provided, because the case law, it's the one point in which the sort of background case law does seem to be unanimous. On the other issues where they contended, the case law all goes in one direction. You have their own sources saying they're all over the map, they're directly contradictory.
But the outcome of your position is that in this case, where you don't have the inefficiency neglect standard, the president need not provide any notice. The president need not provide any hearing. The president just really has to say, Ms. Cook, you're fired.
He has to provide a cause. We contend that there has to be a cause, something that relates to conduct, fitness, sufficiency, or competence. We concede it cannot be for policy disagreement or for no reason at all or at will.
General Sauer, if you're correct that courts do not have the authority to reinstate a removed officer, why are we wasting our time wondering if there's cause or not? I mean, because even if we say, yes, there is cause, shouldn't have removed her, but we don't have the authority to order her reinstatement. How is that consistent with the time and energy being spent on determining if there's cause?
We agree that that's an alternative basis. As we say in our brief, that's reason enough to rule in our favor, and we have a holding of the court, Sawyer. We also have this tradition I was referring to earlier of recognition that runs from the decision of 1789 to all the opinions in Myers, it's alluded to in Wiener and so forth, recognizing the president's power of interim or suspensory removals. So we agree that's an alternative, that's an independent basis for us to prevail.
Well, it's an independent basis. I guess it's not independent in the sense that if that's right, the other one is irrelevant, right? It seems to me that if there is any level of cause, and you indicate that there is some level of cause, right? Well, then you can't be right about the idea that courts can't order anybody who's been removed to be reinstated.
There is a traditional remedy to reinstate we don't dispute, there's a traditional remedy to reinstate wrongfully removed officers, which is mandamus. But they don't argue mandamus here, and the reason they don't argue mandamus is they face a number of insuperable obstacles to prevailing in mandamus. One is, of course, going all the way back to Marbury against Madison. You can't mandamus the president, his discretionary acts. In addition to that, there is no preliminary writ of mandamus, as Judge Friendly pointed out, and the Seventh Circuit has held. In other words, and keep in mind that the standard in mandamus would be clear and indisputable right to relief. And in fact, this is an ultra vires challenge where the standard is exactly the opposite.
So there's a circumstance in which a court can order the reinstatement of a wrongly removed officer.
But there is a traditional remedy, mandamus. Here, obviously, it'd be quo warranto if there were two competing claimants, but where there's just the one, that would be mandamus. And they have not argued mandamus. They're trying to find their way around mandamus because the standards to prevail under mandamus are insuperable, and they clearly cannot meet them.
But General,
Thank you. I'm sorry, Justice Thomas? Justice Alito?
Is there any reason why this whole matter had to be handled by everybody, by the executive branch, by the district court, by the DC Circuit in such a hurried manner? You began by laying out what you claim to be the factual basis for the for-cause removal, but no court has ever explored those facts. Are the mortgage applications even in the record in this case?
I know that the text of the social media post that screenshots to the mortgage applications is in the record, but I don't recall if the paperwork itself is in the record, in the district court's record.
So when this was before the executive branch, it was handled in a very cursory manner. The district court decided the case on the ground that for cause doesn't mean anything that happened before the person took office. And I'll question Mr. Clement about that when he stands up. The DC Circuit decided it on two grounds, the same as the district court, and that there's a property interest in holding the position of governor of the Federal Reserve Board. Am I right on that?
Not exactly. The DC Circuit stay panel relied only on the property interest, did not rely on the pre-office misconduct, and that's insupportable.
Well, did it not hold that that's what for cause means?
My recollection is that the DC Circuit, the Garcia opinion in the DC Circuit relied solely on Loudermill and the due process property interest, which is baseless for the reasons we say. And now the district court relied on the twin grounds, both that Loudermill rationale and also the.
All right, I stand corrected on that. But those are the only two issues that were decided by the lower courts.
That's correct.
Justice Sotomayor?
I have a couple of follow-ups on Reagan and Shurtleff. You're relying on those two cases for your proposition that cause could be whatever the authority decides. But Reagan and Shurtleff were very careful in holding that the only reason that was true was because there would be life tenure involved otherwise. It was very careful to distinguish its holding from cases in which there were a tenured position and there was a for-cause provision. So you're extrapolating, correct?
I disagree with that. We read Reagan differently. If you have those two key paragraphs.
We can both look at it.
Don't talk about fixed term at that point.
I think but the court recognized the rule, and I'm quoting from the case, quote, where causes of removal are specified by statute, as also where the term of office is for a fixed period, notice and hearing are essential. Here, you need for cause, and there's a fixed period of tenure. And Reagan very clearly said, notice and a hearing are required. So if I move on from that, I go back to Justice Alito's question of you. I thought, and the chiefs, I thought there was a factual dispute. As I understood it, Ms. Cook's letter, her attorney's letter, and quite frankly, I've never understood that a letter from a lawyer wasn't a representation by a client. This is a new standard I've never heard of before in an informal proceeding. If the president can go by social media and one believes that that is adequate notice under law, I'm hard pressed to think a letter from a lawyer is not notice from the adversary, but we can move on from that. The letter from Ms. Cook says, the Michigan bank gave me permission to rent because I got a job in Washington. I had to move from New York when I got my job in Washington. And frankly, I renovated my apartment the year before, thinking I would be in New York for the rest of my life. Things change, and the bank in Michigan, at least they represent, will say there was no deceit of them. As to the mortgage issue in Atlanta, Ms. Cook's lawyer represents that the paper submitted to the bank disclosed the fact that this was a vacation home. So they may not have experienced deceit. If they didn't experience deceit, then you're left with gross negligence, and the question becomes, is it grossly negligent to make a mistake on a mortgage application? And I don't know that gross negligence has ever risen to the level of a mistake. So there is a factual issue. Now the question is, who resolves that issue, the level of review of that decision, and those are all questions, as Justice Alito pointed to, have not been addressed below, correct?
What was addressed below is, I think, exactly what
Just a
said in
due
exchange with
process
Justice
right to
Alito.
notice in a hearing by the circuit court, and for cause being something, it has to be only what's at the time of in office. I do agree with you. Common law did permit pre-office conduct to be considered, but only if for an infamous crime. I don't think this rises to an infamous crime.
If I could say two things about that. First, on the narrow point about whether or not a letter of counsel can create a factual dispute in this context, that's the holding of this court in Codd against Velger, where the court said that suggestions of counsel are not enough. It's the party who has to do it. So there were representations of counsel there, and the court held that that wasn't
That's
enough
in
to
a
create
legal
factual.
proceeding. This is an informal proceeding. Legal proceeding.
Yeah, the point was there had never been any representation by the party in any context, formal or informal, and that's exactly what we have here. That's the one point. I can't remember the second point I was going to make in response to that.
Thank you. Mrs. Kagan?
General, can I take you back to the Chief Justice's question, the remedial question, the last one? Because in response to him, you said kind of no worries because there's a traditional remedy of mandamus. But then pretty much in the next sentence, you said, but of course, mandamus doesn't apply here because it's the president. So, I mean, when we're talking about the president's removal powers, you're essentially saying that the only remedy doesn't apply. And that brings you back to the Chief Justice's question, which is, well, if there's no way to reinstate, like, what does this cause requirement amount to?
Well, Congress adopted a policy choice to impose on the president a cause requirement and not an I&M requirement. As Justice Alito pointed out in the CFPB funding case, this was a hard-fought compromise.
No, but I think there's
influential
some
camps.
kind of cause. It doesn't have to be inefficiency, neglect, malfeasance, but there is some kind of cause that's necessary. You said that yourself in response to my last question, that the president has to state a cause. But if then you're saying, well, even if he flunks whatever that requirement is, there's no way to reinstate the person. There's no way to use the mandamus route. What does it amount to? It seems pretty, it seems non-effectual.
it is if it is non-effectual, which we dispute, we think it's very effectual, and it's proven to be effectual in history because it provides the governors with the most important protection, which is that Congress apparently wanted to give them, which is protection against removal for policy disagreements. And governors have not been removed for policy disagreements. That has been
Except
respected.
there's no way to test that. There's no way either that the person can come in and have that meeting in the Oval Office or the Roosevelt Room or wherever else, saying, I think you're really getting rid of me for policy reasons. There's no way for a court to evaluate that. The president just has to say, I'm removing you for cause. You committed gross negligence.
And there's no question, for all the reasons we discussed in our briefing, that confers broad discretion on the president. Now, there's an outer perimeter that is subject to policing by judicial review, policy disagreement, no cause at all, and so forth. But that confers broad discretion on the president. But even if it was de novo review here, gross negligence in a very important financial transaction that has this close nexus with what a
Does the
governor
president
does
have to say
would satisfy it.
Does the president have to say what the gross negligence is? Or can the president just say, I'm removing you, it's not for policy, it's for gross negligence?
So we have, I think, conceded in the briefing that sort of determination would be subject to judicial review because he hasn't specified the cause. Now, the case law, that's a borderline case. The case law goes in different directions on that. Garland, one of the cases that we cited in our brief, kind of goes the other way in a way that'd be stronger for us, but we haven't disputed that in this case, that if there was no cause provided at all, then that would be subject to judicial review and likely an invalid removal.
Thank you.
Justice Gorsuch.
Just to follow up on Justice Kagan's questions, I think in them was the question, if you think mandamus doesn't apply to the president at all, ever, how could you ever test the things you say can be tested? He has to remove for cause. He can't remove for policy disagreements. That might be one. The president says, I remove you for policy disagreements. He's open about it, let's say. Could happen. You would say still mandamus is not available, I think, wouldn't you?
I think we would. Now, that might be a closer case because the mandamus standard is clear and indisputable right when we have conceded that policy disagreement would not be available. Actually, that might be a case where mandamus might be available with the caveat that how would Marbury apply to that? Marbury says you cannot mandamus the president in a discretionary decision. And so baked into our jurisprudence from the dawn of this court is the notion there's going to be some things the president does that you can't dispute.
Would you say that's not a discretionary decision? If the president says, I fire you for policy reasons, that would be outside of his discretion and therefore subject to mandamus.
Essentially, the argument would have to be that'd be ministerial within the meaning of Marbury. And then I think that standard in Marbury kind of gets ported into the standard in Cheney, clear and indisputable, right?
No, so it would be clear and indisputable and therefore could run against the president in that case.
Hypothetically, I'd have to do a lot more study. We're taking a firm position on that.
Justice Kavanaugh.
For present purposes, you accept the constitutionality of the for-cause removal provision for the Federal Reserve, and that is what protects the independence of the Federal Reserve. What, in your view, is the purpose of that independence?
It protects the governor, exactly reflecting the plain text of the statute. It protects the governors for removal for policy disagreement or for no reason at all.
What is the broader purpose of that?
To preserve the independence of the Federal Reserve.
And what is the broader purpose of that?
Well, there's a number of reasons that are discussed by their amici, and I think not disputed by us, which is that there is a long tradition of having this exercise of monetary policy be exercised independent of executive influence, and we don't dispute that that's what Congress was doing in that statute. And again, we have not disputed the validity of the for-cause removal restriction here.
And why is that independence important in your view?
We don't dispute the importance of that for many of the reasons that their amici say, but we emphasize that there's a balance struck here. This is not a ironclad, you can never be removed. There is a cause removal authorization.
But on that, your position that there's no judicial review, no process required, no remedy available, very low bar for cause that the president alone determines, I mean, that would weaken, if not shatter, the independence of the Federal Reserve that we just discussed.
We disagree with that, and I would point to the point that the point you made, that this is a low bar for cause. in a sense, it's a very high bar. It's a very strong protection because it does protect them from the one thing that Congress was apparently most worried about, which is a removal for policy disagreement.
But it would be in the view of the president who might have a policy disagreement and there's no judicial review and the president can just define it on his or her own. Right?
One of the strongest traditions in this court's jurisprudence is the sort of presumption of regularity to the president's action that has applied to this provision, I think, effectively for 112 years, and it continues to do so.
Let's talk about the real world downstream effects of this. Because if this were set as a precedent, it seems to me, just thinking big picture, what goes around comes around. All of the current president's appointees would likely be removed for cause on January 20th, 2029, if there's a Democratic president, or January 20th, 2033. And then we're really at will removal. So what are we doing here? What is, we started, that's why I started with what's the purpose of the independence and the for-cause removal. If we accept all these, no procedure, no judicial review, no remedy, that's what's going to happen, I think. And then where are we? So do you dispute that is, the real world effect?
I can't predict what future presidents may or may not do, but the argument strikes me as
well, history's a pretty good guide. Once these tools are unleashed, they are used by both sides, and usually more the second time around. And I think that's what we have to make sure we're, again, that can't drive the decision necessarily. We have to be aware of what we're doing and the consequences of your position for the structure of the government.
2 points there. I dispute the characterization that these tools have been unleashed. The president has always had this tool to remove governors for financial improprieties. Now, the history is, including twice in the last 4 years, governors who have been credibly accused of financial improprieties have resigned. They haven't forced the president to remove them. And I think the more sort of fundamental point is that cause is a standard that is quite deferential to the president. Congress consciously adopted that instead of a more restrictive standard like INM that was, by all appearances, a legislative compromise between two camps, one of which wanted to give the president complete control.
I agree with you that there's a balance here, and so I understand that. I'm not saying there's no interests on the other side here. I get that. But again, thinking about the real world and the brief of the former governors of the Federal Reserve, your position, again, because you say, well, the president can't say it's for policy reasons, which may be what's really, again, in not talking about the current situation and other situations in the future, what's really driving it. It incentivizes a president to come up with what, as the Federal Reserve former governors say, trivial or inconsequential or old allegations that are very difficult to disprove. It incentivizes kind of the search and destroy and find something and just put that on a piece of paper, no judicial review, no process, nothing, you're done. I mean, again, what are we doing when we have a system that incentivizes that and leads to that? Now, again, you can dispute that you think it's going to lead to that. And again, I'm not talking about the facts of this case. I don't know the facts of this case. So I'm taking no position on that.
This court has, since Martin against Mott, running all the way through Trump against United States, Trump against Hawaii, a whole host of decisions, consistently afforded the president the presumption of regularity in his action and consistently declined to probe a president's actions for their subjective motivations. And so in the hypothetical question that you pose, that hypothetical future president should also be afforded the very same sort of deference and
that leads, I mean, that brief, that amicus brief cites Justice Scalia's dissent in Morrison, which is always a good place to look for wisdom, and the concern that you're putting all these resources, because you can't say it's for policy, put all these resources, let's find something, anything about this person. And then we're good. And by the way, there's no judicial review, so we're really good. And there's no administrative process.
And again, I disagree with that. I think that that argument, that presumption, when it applied to the president, contradicts some two very strong strains in this court's jurisprudence that go back to the founding.
And what's the fear of more process here? In the sense that process protects you, in the sense of helping you make better, more accurate decisions, and process helps you then convince people on the outside that you've made a considered, thorough, appropriate decision. What's the concern about more process?
I don't think we think that process is necessarily bad. In this case, there's two reasons why process is not the right answer, among others. One is in Vermont Yankee. This court said we're not going to dictate procedures to executive agencies. For sure, I should dictate procedures to the president. Our contention is that there already has been a process. There was a social media post that said, look, these two documents contradict each other. And the response was defiance. So there was a chance to tell, in the words of Loudermill, to tell her side of the story, and it wasn't adopted. And in fact, there hasn't been for months since then any clear explanation other than it was an inadvertent notation. It's just the kind of inadvertent notation that ordinary people can be indicted for.
And again, none of my questions or comments are about the facts of this case. I don't know the facts of this case, but thank you.
Justice Barrett?
I want to pick up on that question about why, and Justice Kavanaugh said, why are you afraid of a hearing, or what would there be that would be wrong with process? I mean, you spent a lot of time litigating the case. It's gone up from the district court to the Court of Appeals, and now we're here. And if there isn't anything to fear from a hearing, and if you have the evidence, why couldn't those resources have been put into a hearing? I understand you think that you don't have to provide one, either because of the statute or because of the due process clause, and that's fine. But in thinking about irreparable harm to the government, if one step you could take to reduce your irreparable harm, to show that there really was cause, is just to have a hearing, why not?
I don't think it's a question of resource allocation. It's our position that adequate process was already provided. So if it's a question of the district court's ordering us to go further and then go further and go further again, all without any legal or constitutional authority, in our view, we think that imposes irreparable injury on the executive.
Well, they told you to go farther, but not that much farther. I mean, okay, so there's the Truth Social post, and then, burden on her to come back in 5 days. I understand that's your position. But, Justice Gorsuch posited sit down across the table in the Roosevelt room, where the president provides Ms. Cook, Governor Cook, with the evidence and waits to hear what her response is, gives her a chance to defend herself. I mean, that just wouldn't be that big a deal, it seems, if that's enough.
Again, it's an intrusion on the executive branch to dictate what procedures it ought to provide.
So it's standing on
Certainly
principle.
The president, and our position is he has provided process. He's provided adequate process. And if the district court said, well, that wasn't quite good enough, try again, and then we try again, and the district court says, nope, that wasn't quite good enough, try again, we are gone left Vermont Yankee way in the rearview mirror.
Do you concede that if the statute was an INM statute, then under Shurtleff you would have to provide process?
Notice and hearing, yes.
Yes.
We don't dispute that.
And I want to go back to one of Justice Kagan's questions. She said, well, in Shurtleff, the statute itself didn't say that you got notice in a hearing for INM, but the court said that you did. Here, the statute does say cause. Cause isn't as specific maybe as INM, but it does identify the grounds that the president must have for removal. Why shouldn't we do the same thing that the Shurtleff court did and say that, well, as we said in Shurtleff, when a statute specifies the grounds for removal, there must be notice in a hearing given?
Because the case law, presumably Shurtleff, when it said that as to INM, you get notice in a hearing, was relying on what we don't dispute is as far as I can tell, pretty consistent strain in the case law that's what that means. It gives you specified causes like that. INM give you notice in a hearing. The case law on cause is the opposite. I mean, look at the lower court opinion in Reagan, in the Court of Claims opinion, where they say cause does not mean you get a notice in a hearing. And we cite a strong line in the background case law as well. Now they dispute, they say there's some cases going the other way. However, the notion that they are making an old soil argument. They're saying, oh, in order to prevail on that, it has to be so well settled and clearly established that there really wasn't a dispute about it. And you look, I can't emphasize enough, what, for example, the Tuttle Michigan Law Review article from 1905 that's heavily relied on, for example, in the Manners amicus brief that they rely heavily on in their supplemental brief. It says the case law is all over the map on all of these issues. That treatise says the courts differ on almost every conceivable part of this question. The only point of consistency is that specified causes INM, which also, as we can see, is a holding of the court in Shurtleff. Whereas cause just doesn't mean that. We cite all these cases they dispute, and there's this battle about what did the 19th century case law mean. Keep in mind, in the context of that battle, they bear the burden of making the old soil argument.
Justice Jackson?
Just following up really quickly on that point, isn't the case law all over the map because the statutes were different? I mean, I understand the Manners brief, which they rely upon to really drill down on the various statutes related to removal and to have identified ones, for example, that have a fixed term but allowed removal only for cause, or had a fixed term and provided for removal at the president's discretion, or didn't have a fixed cause, a fixed term, et cetera, et cetera. There's like a series of permutations, and in those different circumstances, courts, which asterisk were actually reviewing this, so that in the first instance makes me question your view that courts couldn't review it. But setting that aside, we have a bunch of cases that come out different ways because the statutes are different. Professor Manners says that when you drill down in this situation with respect to fixed term and removability for cause, as of 1913, it was well established, everybody agreed that that required at least notice and an opportunity to be heard. So what is your response to that? We're looking at a particular statute that does two things, fixes the term and has for cause. She says everybody said, got to have a notice in a hearing. So why is the government saying different right now?
Respectfully to her, that contention is plainly incorrect. So if you go to our supplemental brief, page 9, footnote 4 in the accompanying text, we cite Ulrich, and then 13 more cases in that footnote for the proposition that for cause does not require notice in a hearing. Her argument is
No, I'm talking about the combination.
Yes, the combination.
Combination,
right?
for
Of those
cause
four-
and a fixed term. So when I look at those cases, I'm going to find that combination, and people are all over the map, you say?
By our count, in 7 of
Okay.
those 14 cases, it's a combination. There's also a fixed term. So that argument just, again, that brief, read the Tuttle article that it relies so heavily on, and you'll see this argument. They're nowhere near meeting the burden of an old soil argument.
right.
And that's what they need to change the plain text of the statute.
Well, let me talk about the plain text of the statute in light of its purposes. You explored with Justice Kavanaugh, and I appreciated this, that Congress put the for-clause provision in there for a reason. And you conceded that the reason was to try to ensure the independence of the Federal Reserve, that Congress had decided that this particular agency, because of the sensitive information and policy determinations that it has to make, needs to not have the pressure of having all of its governors be fireable at the whim of the president. So in goes for cause removal for that purpose, and you agree. So I guess what I'm trying to understand is how does reading the statute to give the president broad discretion, which you've said many times, with respect to his removability of these governors, how does that further the aims of the statute?
It directly furthers the aim of protecting them for removal for policy disagreement, which would be the key protection.
No, but you've conceded that the aim is actually broader. The aim is to ensure that this institution is not being pressured by the executive branch, by the president, with respect to its determinations, that people can't just be fired because the president wants them to. And so what I'm now asking is, if we read for cause to ultimately reduce to the president can pick some fact that has nothing to do with their actual tenure in office, something that happened way before, and use that and say that's cause and it's not reviewable, and he doesn't have to show any evidence and doesn't have to give the person a hearing. Basically, the president is just making the determination that Congress apparently didn't want him to have the power to make because they put for cause in the statute. So how do you reconcile your vision of presidential discretion with a statute that was clearly designed to limit the president's discretion in this regard?
It was designed to limit the president's discretion just as far as the plain text of the statute goes. The statute was a hard-fought compromise between two influential and insistent camps, as Justice Alito recently wrote. One of them thought there should be complete presidential control of the Federal Reserve. The other thought it should essentially be a private entity. They met in the middle with a removal standard that protects governors from removal.
But it only protects them insofar as the president's determination about cause is reviewable and based on actual evidence that has been established. It doesn't protect them if the president can just make it up.
It also provides a legislative determination that governors could be and perhaps should be removed if they engage in financial improprieties that undercut the Federal Reserve's credibility in the eyes of ordinary Americans.
All right, one more question just about this idea of the district court's power. You've talked a lot about mandamus being the remedy, but as I read the cases in the law, mandamus was the remedy for courts of law that were being asked to reinstate removed officers. And this was back at a time in which courts of law and courts of equity were separate. We now have a fused system. Courts of equity could always be asked to step in and prevent the removal of this person. To the extent the person was claiming that they were not removable, say because the statute says they could only be removed for cause, a court of equity could be invited through this claim to come in and pause the circumstances, not allow this person to be removed until the courts of law had actually litigated the claim of removability. I think that's the world we're in. This was the very first question that Justice Sotomayor asked you. And so can you just explain why you're insisting that mandamus is the only thing available to the district court in this situation when this is an equitable decision in the interim in the way that I discussed?
It is, the preliminary injunction is an equitable determination, and it's one that the district court plainly, under Sawyer, plainly lacked jurisdiction to enter. And again, I also, in addition to the holding of this court in Sawyer, that a temporary restraining order purporting to restore a public officer.
Right, my question posits that we're not talking about restoration. We're talking about Ms. Cook's application to the court before she was terminated to prevent being terminated because her claim is that I'm not removable. That's an equitable determination. It's being made in the interim. She's not yet been removed because the court prevented that with its preliminary injunction. Courts of equity did that all the time. So I don't understand why you're saying it's inappropriate for that to be done now.
Sawyer, in addition to that, as I alluded to before, there's this strong tradition of recognizing the president's authority to engage in suspensory removals pending the final determination. And that alone is enough to point out that there's no power to do the preliminary injunction that was entered here.
Thank you.
Thank you, General. Mr. Clement?
Mr. Chief Justice, and may it please the court. The Federal Reserve is a uniquely structured entity with a distinct historical tradition. Part of that historical tradition is an unbroken history going back to its founding in 1913, in which no president, from Woodrow Wilson to Joseph Biden, has ever even tried to remove a governor for cause, despite the ever-present temptation for lower rates and easier money. Even in this case, the president recognizes the unique status of the Fed by neither arguing that the removal restriction is unconstitutional, nor asserting the ability to remove a Fed governor without cause. But despite that recognition, the sum total of the Solicitor General's arguments would reduce the removal restriction in this unique institution to something that could only be recognized as at-will employment. No procedural due process before removal, no judicial review after removal, no preliminary injunction to preserve the status quo, and a conception of cause so capacious that apparent misconduct or gross negligence suffices. That makes no sense. There's no rational reason to go through all the trouble of creating this unique quasi-private entity that is exempt from everything from the appropriations process to the civil service laws, just to give it a removal restriction that is as toothless as the president imagines. But if that removal restriction has real substantive and procedural bite, then this emergency application should be denied. There is simply no reason to abandon over 100 years of central bank independence on an emergency application on a preliminary record. I welcome the court's questions.
But if there was such concern for independence, could the removal statute have been written, as others have been written, to require a hearing and review?
So it could have been, Justice Thomas, in the realm of interpreting statutes, could have, should have, would have, right? But I think that you have to give faithful interpretation to what Congress actually did. And I think if you understand the original public meaning of for cause in either 1913 or 1935, I do not think it was as capacious as my friends suggest. I think it probably meant INM plus ineligibility, and in the context of the Fed in particular, it probably picked up Section 244, which prevents a federal governor from also serving as a director and an officer of a bank. So if there were a Fed governor that insisted on being a director of Chase Manhattan, I think that would be removal for cause. And then on the context of the hearing, and I think Justice Kagan already alluded to this, but there are all these statutes about INM that don't mention a hearing, and there are many statutes that talk about cause and don't mention a hearing. Now, it's true that the NLRA, which was passed a month before, did specify a hearing. But I think it would be a mistaken statutory interpretation to make that one express reference to a hearing sort of disable all the other old soil arguments with respect to all the other institutions, where I think there's a very strong old soil argument that whether it's INM or for cause, that means that you get notice and an opportunity.
With that said, what would the hearing look like, and what would the review look like?
So I agree with General Sauer that the president would have a fair amount of discretion in how he or she wanted to fashion that hearing. I mean, one example we have historically is President Taft, and he sort of gave the removed officials the full Taft, and it was notice, opportunity for a hearing before an impartial tribunal that serendipitously included future Justice Frankfurter. And then so that's kind of the maximum that the president could give. But we're not suggesting that you need to give the full Taft. The president would have a lot of flexibility on that. I think you asked what the review would look like, and I think that actually sort of gets to the heart of where the president's incentives would be. I think the more process that the president provides, the less room there's going to be for judicial review and judicial second guessing of factual determinations. So if a president wants to give the full Taft, I think the scope for review of factual determinations by that kind of tribunal would be very narrow, but I do think there would be legal review.
I'm not sure I understand exactly what you want a hearing for. If your argument is inadvertence, it doesn't seem to me that there's much you can say factually other than that. You can't say, well, this is why we did it and this is okay and all that. It's just an inadvertent mistake. Now, there obviously are a lot of legal questions to be addressed, but again, those are questions for the court, and not the basis for a factual hearing. You don't have anything. You have one sentence to say. It was inadvertent mistake.
Well, I mean, Mr. Chief Justice, I think in a case where the president's going to say that it's an inadvertent mistake is enough, and the potentially removed official is going to come in and say it was an inadvertent mistake, then you're right. I think the hearing's not going to matter that much. Now, in the real world where you have no precedent for this kind of removal, I think if there were notice and opportunity for a hearing, there might be an opportunity to not just present the factual evidence, but to also make the case. And given these particular facts about this particular inadvertent mistake, that isn't a basis for removal.
Well, I think you're talking about the legal arguments, though. The arguments we're hearing today.
I think that's right, Mr. Chief Justice, and I do think those could be made in a preliminary way in the process that was provided by the executive branch. But as I alluded to, I do think on the substantive question of what's for cause, there needs to be judicial review. And I think there needs to be judicial review of that question for all the reasons that were alluded to in the various colloquies. Because if there's no judicial review, then this is all kind of a joke. I mean, we can sit here and posit that, well, this would be for cause and that would be for cause, but none of it would matter because there'd be no judicial review.
Well, on the question of what is for cause, what the district court held was that it must relate solely to in-office conduct. And you defend that with one caveat that if the office holder is indicted while in office for pre-office conduct, then that might be cause for removal because a person under indictment wouldn't be able to devote full attention to the job. But other than that, you defend the district court's holding. Is that correct?
We do defend the district court's holding on that, and I would understand that is the rule for all the statutes that have INM.
There's nothing when under a for-cause removal standard, there is no pre-office conduct that could constitute cause.
That is my frontline response. I happen to have a backup argument, which is if you pick up the common law, then you would pick up.
Well, let's take your front line argument first and see how far you're willing to go. Suppose that the office holder was permitted to resign from a previous job under a non-disclosure agreement based on long and egregious pattern of sexual misconduct. That would not be for cause. That would not be cause for removal.
So what I would say, Justice Alito, is I don't think that would be INM. And so if I'm going to stick to my frontline position, then that would not be for cause. It would certainly be a basis for impeachment. And I think in understanding why we've had INM for at least 90 years.
All right, I understand your position. How about if after the person assumes office, videos are disclosed in which the office holder is expressing deep admiration for Hitler or for the Klan?
I can only imagine where these typos are going to eventually go, Your Honor.
Well, yeah, because your position.
I'm going to stick with my position.
Well,
of course, I'm going to stick with my position. And I'm going to say that's an official that would be impeached in a heartbeat. And the fact that they would be impeached in a heartbeat is going to cause them to resign in half a heartbeat. And this has not proven a problem. I mean, for better or for worse, whatever you think of Humphrey's executor, we've had 90 years
Mr. Clement, what's your backup argument?
My backup argument is the common law standard. Justice Sotomayor alluded to it, which would be that there's a removal basis for an infamous crime of the kind that is disabling for public office. And and at common law, it also required a conviction. So it's an exception. It helps me with a couple of these hypotheticals.
No, it doesn't help you.
It's not going to help me with the Justice Alito.
It doesn't help you.
There's no conviction for the Hitler video.
You have a backup to the backup.
Impeachment. It's the ultimate backup here. This is not a situation where you're being asked, you have to tie yourself to the
argued in the past that impeachment doesn't cover private conduct. You obviously disagree with that then.
Well, I certainly see, but this actually kind of makes the point about judicial review, right? I mean,
I'm not saying I agree with that, by the way. It's just been argued.
Right, but what I absolutely agree with is the Walter Nixon case says that there's no judicial review of the impeachment determination in the end. So whatever the House and the Senate ultimately determine, I mean, they can make constitutional law too, and they can determine whether private conduct is or is not out. And if they say, and with these hypos, I mean, and we can go down the road of the hypos and they'll get worse. I'm
backup
confident.
to the backup, to use Justice Gorsuch's term, would be the infamous, but you don't need a conviction.
Right. No, absolutely. And of course,
that seems to solve answer a lot of the difficult hypos, correct?
Correct. But the reason I want to spend at least a moment answering some of the hard hypos is not because I'm a masochist. It's just because those are got to be the answers under INM.
Your answer is that those are funneled to the impeachment process.
That's right. And that's the way INM has worked for 150 years. And I think it would continue to work. It hasn't proven a problem in practice. But I'm not resisting very hard the backup to the backup on that because I don't think we're close. And of course, look, all of these are hard questions, which is all of the reasons why it's kind of crazy to decide this on an emergency application.
Yes, well, there are a million hard questions in this case, and it is an emergency application, and very difficult questions, either no precedent or very conflicting or very uncertain body of precedent. But there are two things were decided by the lower courts. One, that what I just explored, the district court said it's got to be in-office conduct, nothing that happened before person took office counts. And then the DC Circuit said that your client had a property interest in her office, and therefore a due process right. Is that right? She had a property interest in being a governor on the Federal Reserve Board?
So I think there's a perfectly reasonable argument for that, but I also think that there's a better argument that's a constitutional avoidance argument. And what the DC Circuit did in a per curiam opinion is sort of an example of what happens when you're trying to rush all of this, which is you jump right to a constitutional holding when there may be a perfectly good constitutional avoidance statutory holding there. And I think we've now had a couple of months and a bunch of amicus briefs to ventilate some of these things. And I think you get, with that ventilation, you get an understanding that there is a very good statutory argument. And I do want to talk about
why
best reading a shirt lift.
why wouldn't that be a basis for sending it back to consider these arguments in the first instance? If you aren't prepared to defend the due process argument and perhaps your frontline argument on that things that happen before employment are categorically and always off the table. If those two decisions, which to be fair were of course issued under a time constraint, might have some flaws, why shouldn't it go back to reconsider it? You've advanced a lot of new arguments here, so have your friends on the other side.
So it should go back. It should just not go back with an emergency stay being granted, which is an extraordinary relief that depends on my friends on the other side showing an extraordinary burden of irreparable harm and showing that they have a likelihood of success on the merits. And I think likelihood of success on the merits in this context doesn't mean just a likelihood of showing that the two grounds that were seized on in the quick briefing below are wrong, but that they're actually right. And I think the briefing here has done two things. I think it showed that we're right. I'm not abandoning my frontline arguments, but I love my backup arguments. I think they are very strong. And I think it shows the sort of, the problems that happen when you try to decide some of the most important issues of constitutional law in this kind of rushed way.
Can I ask you about the mandamus question? Why isn't mandamus the appropriate avenue here?
It is an appropriate avenue at the end of the case. Even at the end of the case, though, I think, and this is consistent with what Professor Bray says in his article, even at the end of the case, I don't think you have to leap to mandamus. I think you can have a declaratory judgment.
Well, let's put the declaratory judgment issue aside because we can talk about mandamus for a second. Assuming there is such thing as a preliminary injunctive relief for mandamus, which I'm going to ask you if that's a thing, first of all. And second, if it were, wouldn't the standard that you'd have to show likelihood of success be the likelihood of success under the mandamus standard?
So a couple of things. I mean, I don't like hearing preliminary mandamus any more than Judge Friendly did.
No.
I don't think it's the right way to think about it. I think it's preliminary relief to preserve the status quo, or if you want to be more specific, preliminary relief to preserve a de facto officer in their office while the case proceeds. And that is a relief.
Why isn't that preliminary injunction or mandamus? I know what those two buckets are. I'm not sure I'm familiar with the third one you're describing.
What I'm describing is a preliminary injunction. I'm just saying it's not a preliminary mandamus. It's
wouldn't it have to be, though? If your cause of action were mandamus, and let's just suppose that's what it is, it would be preliminary injunctive relief because you have the likelihood of succeeding under the mandamus standard, I would have thought.
Well, perhaps, I mean, two things about that. One is, I'm not sure in this kind of mandamus posture, I don't think I agree with General Sauer that the standard is the standard you would have in like a Cheney situation. I do think this kind of original mandamus as the remedy in this particular situation, I would resist the idea that that's sort of the standard, more appellate mandamus standard. That's a debate, even with all the briefing we've had, we haven't had a good chance to really duke it out on that. But I would say that's part of the reason I resisted the idea that you have to go to mandamus, because I do think you would have declaratory judgment. I do think declaratory judgment.
I asked you to put that aside for the moment.
No, and I tried to as long as I could.
All right.
But
then I give up. Okay.
Then to answer your question, I really had to get to declaratory judgment. I would like to say this is an issue the DC Circuit has thought a lot about. And there's a particular case worth reading, the Swan against Clinton case. And that's a case where they kind of wrestled with this question about, would you have mandamus against the president at the end of the day? Can you direct the president? And there's a great concurring opinion by Judge Silberman where he basically says, look, the judiciary is creative and clever enough to figure out a way to fashion injunctive relief against the lower federal officials. And that solves the problem about having the relief run against the president. And the reason that the DC Circuit has wrestled with that in a couple of contexts, and I think the Chief Justice alluded to this, if they were really right about that, then you'd have to wrestle with this at the beginning of the case as to whether there's any redressability at the end of the case. And in the Swan case and even in the Severino case, the DC Circuit has said there's not a redressability problem. We can figure out a way to direct the relief at the lower government officials, and that will be sufficient unto the day.
And that happens at the end of the case, right? After the whole thing has been litigated and some court, perhaps even this court, decides the removability question. The president does not, we would say, have the right to remove her. And then we go to remedy. And the question is there a mandamus or not? The reason why I thought mandamus wasn't on the table right now is because we're not there. We're in the middle of the case. No one has made a definitive determination about the president's right to remove her. The question now is just in the interim, while that issue is being litigated, what happens? And that's about the equities. That's about whether it's going to be more harmful to leave her in the position than not. That's what I thought this motion was about.
I mean, I think that's right, but it's specifically about whether you can get some sort of preliminary injunctive relief to preserve the status quo and keep the de facto officer in place. And I do take Justice Gorsuch's question, which is at the end of the rainbow, all there is mandamus, and you can't have mandamus against the president. Then at this point, you'd say, what's your likelihood of success at the merits? And you would say, there's no likelihood of success in the merits. But I think, as I alluded to, even before that, you'd say, is there any redressability here?
But wait, I'm sorry, why would that be a merits issue? You'd have no likelihood of success on the merits. You just have no remedy. You would win on the merits. The merits are that the president wasn't supposed to remove you. But you would lose because there's nothing to lose ultimately in terms of not having a remedy, right?
Well, I mean, you could draw the distinction that way. I think if you have no remedy at the end, you probably have the redressability problem at the front end, which is why the DC Circuit has addressed this on a number of bases. These are not emergency application decisions. These are decisions of the DC Circuit. They obviously don't bind this court, but they are the considered judgment of a court that's dealt with, with all the removals there've been, and there haven't been a lot of them, but with respect to other officers. So, I think that's pretty good authority.
What would judicial review in this context look like? I mean, this is not a question about what the standard is. It's more a question about, is there a kind of deference to give to the president? How does that deference operate, whatever the standard is?
Sure. So I would divide between sort of factual questions and legal questions. As to the factual questions, I would say that there's going to be a degree of deference, and the degree of deference depends on the degree of process that's provided. So if the president wants to go full Taft, I don't think the courts are going to be in a position to second guess the factual determinations. If the president wants to do something more informal, he's entitled to do that, but then I would think there'd be more of a scope for, having more hearing, more process in the judicial forum. On the legal question, I would say in a post-Loper world, there's no deference to the legal questions, and the courts are going to have to decide ultimately what are the boundaries, the metes and bounds of for cause. And the only other thing I would add is I think that you're going to want to erect meaningful standards of cause because, there's kind of two options here. You could either have judicial review that spends a lot of time looking into pretext of the president, and that just doesn't seem like a good thing for the courts, for the president, or anybody. Or you could erect relatively demanding standards of cause, and that's going to, I think, obviate the need for that kind of pretext inquiry.
Yeah, so General Sauer's version of cause, which is it's not policy, it's something other than policy. Why isn't that the backup to the backup to the backup?
Well, because it would kind of destroy the whole point of having an independent central bank in the Fed. And it just seems to me like at some point, we're all here on the assumption for this case that the Fed is a uniquely structured institution with a distinct historical tradition. And so if that's true, and then you tick through the statute and you see all the things that Congress did, including, Congress wasn't just trying to take the Fed and keep it from sort of being unduly influenced by the president when it came to rates right before an election. It did the same thing to itself by limiting the power of the purse over this institution. And then you go through and, just every provision of the statute is trying to treat this unique institution differently. And then at the end, you have for cause, which, could mean what General Sauer says. But if it means what General Sauer says, then the whole enterprise was a lot of trouble for nothing.
On the future judicial review and what that looks like, would the witnesses testify in court, or is it done on the record established by the executive branch, or does that maybe depend?
I would say it depends on what kind of process was provided by the executive. And look, I agree with General Sauer. This court's not going to dictate, like, here's Robert's rules, have at it. But I think this court can do something useful, which is essentially to create an incentive for the executive to provide something that's a little bit more protective, a little bit closer to Taft than something incredibly informal. By basically saying,
That sliding scale is extraordinarily unhelpful. What is the minimum that the executive, in your view, has to provide? The minimum type of hearing that you think is required by the statute?
so the minimum hearing, I think, would have three components. One is notice, and that's really not much of an issue here. I agree with that. The second is an opportunity to provide evidence to the decision maker, and we don't think that happened here. And then the third thing is some effort to keep the final decision maker from prejudging the issue. And part of the problem you have in this particular case is that I think the president was proceeding on the understanding of the statute that's faithfully represented here by the Solicitor General, which is he wasn't acting like a removing authority that was subject to any due process. Because if he were sort of subject to that, he wouldn't have said in his opening tweet, "You must resign." And he wouldn't have said 2 days later, "Resign or be fired."
So does that mean it has to be a body of disinterested decision makers?
No.
People who are not part of the executive branch and can exercise independent judgment that way? No? Then
No.
what does it require?
It requires just what I said: notice, an opportunity to provide evidence, and a decision maker who hasn't prejudged the issue. That decision maker can be the president. I mean, I'm not sure I necessarily recommend it as my choice A, but
How can it not be the president? The statute authorizes the president to make the removal decision. How could it be anybody else?
Well, look, I mean, if you believe in the unitary executive theory, then anybody that makes the removal decision is acting on the president's power. I think it would work. I think the way it worked for Taft is the tribunal made a recommendation and then Taft executed.
Right.
So it was the president making the
The
decision.
president has to make the decision, right? Or delegate it to somebody who he wishes to make that decision,
Yes.
who's reportable to him.
Yes.
Okay.
At will.
At will. Yeah.
Right. Absolutely. I mean, so, and the president can be the final decision maker, but if he's going to be the final decision maker and there's a due process right, and I mean that statutory or constitutional, then, he needs to be a little bit careful and say, these are the allegations. He can't start by prejudging the issue by saying, resign.
Mr. Clement, your understanding of for cause, you went through hypotheticals with Justice Alito about how it doesn't cover pre-office conduct. What about conduct in office that doesn't relate to the discharge of the office? Like, what if you take some of Justice Alito's examples, but it's like Nazi videos while the governor is in office, or things that would be misdemeanors rather than infamous crimes like shoplifting, stealing things, domestic abuse. Would those things be cause for firing, or they don't really seem like impeachable offenses necessarily?
So I don't think those would be removable offenses under INM.
Okay.
And so I don't think they would be removable offenses under for cause properly construed.
So there's nothing that the president can do to get rid of someone who does those kinds of things while in office?
So, I mean, some of the things we're talking about, seem like better grounds for like an intervention than for removal. And
Well, I mean, I could come up with others, but
I mean, absolutely.
But sorry, keep going.
I'm going to fall back on my answer, which is that's my understanding, and I think it's actually everybody's understanding of how INM works.
But it doesn't say INM. And so, I mean, I appreciate your argument that INM and for cause are one and the same, but you also kind of pull in and you fall back some sort of like gerrymandered things like infamous crimes, but you don't have to have a conviction. I mean, so it doesn't say INM.
So a couple of things. One is, I'd resist. I mean, gerrymandering is generally not a compliment. So I would sort of say that what we do is we bring in the common law. And that's what we do. And I really didn't try to gerrymander it beyond that. But let me make the argument, which I really.
Can I just ask one clarifying question? I thought the common law, though, required conviction.
It did, and that would be our sort of frontline backup position, if you will. I mean, but the happy thing for me, I think, is at this stage of the case, we win under all these variations, and ultimately, some court, and it may be this court, is going to ultimately say these are the metes and bounds of for cause. Now, I think I have some pretty good arguments that it really is just I&M plus ineligibility as kind of informed by Section 244. And let me just give you like my best shot at it, which is this is the very unusual situation where, we know that Congress was literally waiting for this court's Humphreys executor decision. And then it gets Humphreys executor's decision, and this court in Humphreys executor at least 3 times uses for cause and I&M interchangeably. And then the senators themselves in the debate, I got to look at debate, but I think even Justice Scalia looks at debates for original public meaning. The senators in the debate use the terms absolutely interchangeably. And so you have 2 of the 3 branches of government, original public meaning, saying for cause, different words, but what it means is I&M. But I do think it must, you got to make sense of Section 244 of the statute, which does provide a very specific eligibility requirement. And as I said before, I think if some Fed governor was insisting that they also wanted to be a director at Chase National, they could be removed for cause for that.
Okay.
Do you think that there's a way at this posture of dealing with this case so that we don't have to confront the question of exactly what the for cause standard means?
Is there a way to deal with it at this stage without having to ultimately say that? I mean, sure, there'd be a lot of different ways to do that. You could say that for cause, one way to come at it would be to say, at a minimum, for cause doesn't mean apparent misconduct or gross negligence. And I think that would be sufficient to decide the case, at least at this juncture. And I think you could say something more. I mean, obviously, if you took my position and said it means I&M plus ineligibility is informed by Section 244, I think we'd be done here, because I don't think there's an argument, at least that I've heard at this juncture, that the conduct that's at issue here is either I&M or ineligibility.
Couldn't we also resolve it by not even going to the likelihood of success on the merits element? I mean, you have the president would have to have all of them to get a stay, and we could do it on harm, right?
Sure. I mean, look, it's an emergency application. You could deny it without opinion. I mean, that would be a little strange at this juncture. But it is an extraordinary application made on a preliminary record. And so, you sort of have a lot of optionality at this point. But I will say this. I mean, I do think the briefing in this court, which was, sort of unusual. You had the application briefing, then you had a MIKI, then you had this supplemental briefing. I think it's been incredibly helpful in excavating some of these difficult questions. I mean, I've looked at almost all of these common law cases. I have a different view than General Sauer on some of these questions. And, in particular, I think it's very important, and I want to get this out, that if you look at Shurtleff, one of the things at Shurtleff, there's a line there that says that where Justice Peckham is invoking the common law, and he says that as long as there's certain causes, statutory restriction for certain causes, that's the term he uses, then there's notice in a hearing. He cites 7 common law cases. Now, if you look at those common law cases, 3 of the 7 just say for cause, and 2 of them say good behavior, which is even less, and then 2 of them have a more specific cause. So that's, to me, the best contemporaneous evidence that we're actually right about the issue, that if it just says for cause and it doesn't say for a particular kind of cause, you get notice and an opportunity for hearing. But that's the kind of thing you can excavate on full briefing on the merits that I don't think you can in an application.
Thank you, counsel. I guess I get back to where I kind of started, and all this description, these are all sorts of legal issues. You don't have anything more to say on the facts, right? It was an inadvertent mistake. I don't see how you can say anything more. We've had a broad range of discussion on the legal issues. Now, it's very helpful for us to have lower court decisions on those, and maybe that's reason enough. But again, I guess I don't quite understand what sending it back would be for, other than airing of the same sort of issues that we've been airing this morning.
Well, I'm not going to resist too hard you deciding this on a more substantive ground that gives my client sort of relief that's more enduring at this stage. But I will say that, another one of these like great common law cases is the Street Commissioners of Hagerstown, which happens to be the case that Black's Law uses for its definition of cause. And one of the things it specifically says there is, like, even if you don't think the due process, the notice in a hearing is going to amount to much, it's still an error not to give it. And we're still going to essentially not allow this removal to happen because there wasn't notice and an opportunity for a hearing.
So it may not be an error to go through the process of your client coming in and say it was an inadvertent mistake. Since it was inadvertent, I don't have much more to add to that. And the argument on the other side being what the president said, well, I think this is a serious enough mistake, and so that's why I'm removing her.
There's only so much I can say to resist the idea that, we think this was at most an inadvertent mistake. We would have liked a more, a sort of opportunity to do that and present our actual evidence, which would have substantiated that. But we also think at the end of the day, inadvertent mistake isn't like very close to for cause, particularly when you understand the unique nature of this institution.
What is your actual evidence that would substantiate the fact that it was an inadvertent mistake?
I think the fact that there's an attachment to one of the applications that describes it as a vacation home.
Well,
and that's not.
We've got that too.
I understand, but the president didn't. And it seems to me that, usually when there's a procedural omission, one doesn't say, well, at this point we got everything we need, so forget the procedural omission. Again, I'm not really going to resist that, especially if you're going to, say you're with me on the substance. But it does seem to me if you want to reserve judgment on the substance or you want more briefing on the substance, you could say, and this is that whether it was constitutional due process or statutory due process, I think this is the gist of the DC Circuit's decision, is like at a minimum you didn't get the process you were supposed to, so the government doesn't get this extraordinary emergency stay.
Justice Thomas?
Just so I'm clear, for you to prevail, we would have to say cause is the equivalent of INM.
No, I don't think so, Justice Thomas. I think you could really take any definition of cause that we've been sort of batting about, with the exception of General Sauer's definition, and we would prevail. I think the only, and I do think the definition that's presented to you by the president is a pretty extraordinary one, because General Sauer's a very careful lawyer. So in his briefs, he doesn't talk about mortgage fraud, he talks about apparent mortgage fraud. And when you're talking about apparent misconduct as opposed to actually found misconduct, that A, doesn't get for cause, and B, it sort of is advertisement that you have a process failure. And so the fallback then is or gross negligence. So one way to think about this is if the standard of for cause is more demanding than gross negligence, then we certainly win. And we didn't even get a chance to sort of argue about gross negligence.
What is your, if it's not the equivalent of INM, what are some of the other standards that you would apply that would be sufficient for you to prevail?
So I think the single best reading of the statute is INM plus ineligibility as informed by Section 244 of the statute. I think then my fallback would be then you pick up the common law, and if the common law makes you uncomfortable because of Justice Alito's hypos, you could tweak the common law. But you would then be tweaking the common law. And that's why, honestly, at the end of the day, although it's uncomfortable for a few moments to answer some of those hypos, you always have impeachment as the backstop. And we had, 90 years, plus if you go back to the Interstate Commerce Commission in 1887, almost 150 years with INM, and this didn't really pose a problem in practice.
Justice Alito?
Do you think that we should decide this case on the factual ground that what is shown by the materials that are before us shows nothing more than gross negligence, which is insufficient? Should we make that factual finding in the first instance? I understood your answer to be, you should do that if you're going to find in favor of me, but you shouldn't do it if you're going to find the other way.
I'll stand by that answer.
Really? That's your answer?
That's my answer. I think it would be a little irregular, but this whole case is irregular. And if that seems to be the path of least resistance to decide this case in a way that is going to essentially obviate the need for this court to decide it again in a couple of years, that seems like a perfectly reasonable way to decide the case.
Thank you.
Justice Sotomayor?
This whole case is irregular. Starting with the Truth Social notice, or thinking of it as notice at all, certainly didn't invite an opportunity to be heard. But that's where we are. Now the question becomes, and you answered the chief and said, I don't have more to present. I don't know where you presented anything. You have a letter from you that basically says that the application included notice that this was a vacation home. But that's never been given to the president. That's never been filed with a court, or no one's ever seen it. It's just statements being made. So I don't know why a factual hearing would be irrelevant. So assume, as I do for the purposes, that she did fully disclose this was a vacation home. So now the question is this what she did negligence or gross negligence? Does cause include just mere negligence? I think that you have a very strong argument under any reading of cause that mere negligence pre-office would not qualify, correct?
Correct.
All right. Because it would seem extreme to think that something separated from the functioning of the office, unrelated to the work of the office at the time it's done, that mere negligence would be enough. But the president called it gross negligence. Who decides that issue? Meaning, who decides whether something should be called negligence or just gross negligence?
So I would think that ultimately that's a mixed question of law and fact that would be ultimately decided by the court on judicial review, assuming you're with me that there's judicial review. I do think there would be an logically anterior, purely legal question of whether gross negligence is sufficient for cause. And just as I think I have a pretty good argument that negligence pre-office is not a sufficient basis for cause, I think I have a pretty good argument that gross negligence pre-office is not a sufficient basis for cause. And, in some respects, I think in the long run, it will be better to make clear that in the context of this unique institution with this distinct history, that for cause is several steps north of gross negligence even, because that's going to make it really something that the courts aren't going to have to get dragged into on a routine basis, where I think the lower the standard is, the more likely you are to have removals in the future, and the lower the standard, I think the greater is going to be the judicial temptation to think about pretext. And I'm not going to say that there's no role for a pretext inquiry, but it's not a happy sort of scenario for the courts to be considering pretext in the context of presidential decision-making. And it seems to me the way to solve that is to say there real procedural and substantive kind of bite to this term sort of for cause. You do have to do some kind of notice and opportunity for a hearing. I mean, even if it's an hour in the Oval, that's a big imposition on the president's time, and that's going to keep some presidents from removing somebody. And if they know that it's going to be judicially reviewed, then that's going to deter most presidents most of the time. And so I think kind of, it's like, what is it? High walls make for good neighbors. I mean, I think this is a situation where you do want to have those kind of meaningful legal requirements.
Justice Kagan?
What do you understand the government to mean by gross negligence?
I mean, I don't really know. I don't think they've offered sort of a theory of gross negligence. And that's why I don't think
You think it's just a label that they've put on this particular set of facts?
Sure, and if heaven forfend we end up with a whole common law of Fed governor removal, then we might eventually be able to sort of piece it together. But it seems to me that you could label an awful lot of things gross negligence, and that seems to be inconsistent with not just the for cause provision, but the whole structure of the statute. And I mean, Justice Kavanaugh alluded to the Morrison dissent and Justice Scalia creating this beautiful picture of some independent counsel with nothing to do but to find a crime on somebody. But if all the independent counsel has to do is find gross negligence, then I don't think the independent counsel would need more than a couple of hours with most of us. I mean, that's such an elastic standard. And I just can't imagine that's consistent with all the trouble Congress went to make this unique entity insulated from kind of the political pressures of the day.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
A couple things just to talk again about the standard. I mean, getting the definition of for cause right, which we may not have to do in this posture, so I take that, is critical because on the one hand, you have the independence of the Federal Reserve, which we've talked about. The other hand, we have people have committed, again, not talking about the facts of this case, but serious ethical or other wrongdoing, digging in and remaining in office. And it seems like your two answers to that, when you said your frontline positions, I&M, were intervention / resignation. And I'm not sure that really works with some people who are going to just dig in, you know, they're not going to leave. And then the other was impeachment, but of course, with the 2/3 requirement in the Senate and the time constraints of the House and Senate, I'm not sure that's available as often as you say, all of which is getting me to the point of, I don't see how the frontline position really can be the final position without making kind of tilting the balance here too far the other direction from where the Solicitor General is. You just want to tackle that at all? I mean, you've covered it, but I want to get it out one more time so you can succinctly answer it.
Sure. I think the best thing that I haven't said already that I could add is I think in the unique context of this particular agency, you want to strike the balance more in favor of keeping an official who maybe in a perfect world would be removed, because this is the opposite of the situation in essentially all of the other situations, with the possible exception of like the tax court and the court of claims and the court of military appeals. Here, I think it's less important that the president have full faith in every single governor, and it's more important that the markets and the public have faith in the independence of the Fed from the president and from Congress. And in this regard, I think this is not a situation where unlike Myers, which is the ultimate example, where the president's trying to arrogate some power away from the executive. This is a situation where Congress, political animals, one and all, knew better than anyone that the short-term temptations to lower interest rates and have easy money was a disaster in the long term, but was going to be irresistible. And so they tied their own hands by taking the Fed out of the appropriations process. And they tied the president's hand. And I think they tied the president's hand in a pretty significant way. And I understand the concerns about the balance, but I would say in this one context, it probably makes more sense to, and maybe you want to bring in a little bit of common law, and that's fine with me. But I do think you want to strike the balance so that the ultimate imperative is that the markets don't think that rates are being lowered for political pressure. When rates are lowered, the markets are going to understand that that's actually prudent financial management of our monetary policy.
In your colloquy with the Chief Justice about what a hearing would look like within the executive branch with the president or with the president's designee, just want to make sure I have this clear. In that hearing, you could make legal arguments as well, I assume, not just factual arguments, but legal arguments to say, we don't think this rises to the level of for cause. Basically, the kinds of arguments that you've made here, you could make to the president in the same way in an impeachment proceeding. People make legal arguments to the Senate about what exactly is high crimes and misdemeanors, correct?
Correct. And obviously, the nature of the hearing is going to inform the scope for that. If it's just half an hour with the president, I don't know how much you're going to get into sort of legal briefing. But if you did do anything like Taft, or you just said, well, we got a couple of ALJs lying around, we'll have one of them just sort of hear the evidence on this. I mean, then I would expect there to be presentation on both evidence and law.
And just for the kind of simplest way, and this Justice Kagan was asking, to decide this case, I think one way would just be say there was insufficient process and therefore we at this juncture deny the government's application. Thoughts?
I think that would be a very simple way to decide this case. I think perhaps the defect that was alluded to in the colloquy with the Chief Justice is that probably is also, the way that probably maximizes the chances that it gets back here on the merits. Whereas if you decided to go a little further and say something substantive, it might bring all of this to an end. And there's probably some virtue to that. Certainly there's some virtue to that from my client's perspective.
Thank you.
Justice Barrett?
I want to ask you about irreparable harm. You were just talking to Justice Kavanaugh about the uniqueness of the Fed and its need for independence. And the government, because it has not challenged the removal restriction, for purposes of this case, I think we're all operating on that assumption. When the president, if you're thinking about the unitary executive, when the president has untrammeled authority to fire a subordinate, keeping that subordinate in office, I think inflicts maybe a different kind of irreparable harm than the argument that the government would be able to make here, because the president doesn't have the same control over the Fed, at least based on the assumptions we have in this case. What do you think about that? And what kind of an argument would you make for, what is your best case argument that the president is not suffering irreparable harm by the inability? Let's assume that he has the ability to remove Governor Cook. Let's assume that some of your merits arguments are going to lose. They still have to show irreparable harm. So what's your best argument that he's suffering none?
Well, I think my best argument that he's not suffering irreparable harm in those circumstances, that he's not suffering the unique indignity of having sort of pure executive power exercised by people that are removable at will outside of his control. And that maybe that's a little circular in the end, but I think it's kind of why this case is, I think, problematic for the government, because, you know, they could have come in here and said, you know, Fed Schmed, it's not that different. This is just like the FTC. And so we're suffering the same irreparable injury as in those other cases. But when they come in and say, no, we're going to accept that the Fed is different, at least for purposes of this case, and that we can't remove somebody just for policy disagreements, then having somebody continuing in office just because you have a different conception of for cause than they do, or than you've been able to persuade a court so far about, doesn't strike me as irreparable harm. And then on the other side of the ledger, I think there are enormous irreparable harms here that really don't have an analog in most of these other situations. I don't mean to denigrate any other agency, but, you know, there's a reason that monetary policy has been treated differently for, you know, these many years, and there's a reason that the markets watch the Fed a little more closely than they watch really any other agency of government.
Justice Jackson?
So you've had a couple questions about what good is a hearing? What would a hearing do in the situation where Ms. Cook has made a statement through her lawyer about the allegations? I guess I'm wondering, setting aside for a moment the standards for cause, don't we have to have a circumstance in this kind of situation in which the facts are established? In other words, I thought the work of the hearing, even in this situation, would be to establish when these applications were signed, what she thought she was attesting to, what actually was going on with respect to these documents that the president is pointing to that says, and he says they establish her deceit and gross negligence or whatnot. And I think before we even get there, we have to know what the facts are related to this. Isn't that what the hearing would be about, at least in part?
I think it would be, and maybe though, to try to defend my, you know, heads I win, tails you lose answer to Justice Alito, I mean, you know, you could think about this by analogy. I mean, there's certain circumstances where you essentially grant a motion to dismiss for one side. You basically say, look, we didn't have a hearing here. That was a mistake. But even on sort of the best reading of the evidence, this is at most an inadvertent mistake. And so there is no for-cause removal, in which case my client would win. On the other hand, if, you know, normally you have that kind of evidentiary hearing, and that is to establish sort of the facts, and then you then apply the law to those facts that have been established. But there are circumstances where you sort of don't need any more facts.
But then you're in Justice Kavanaugh's world, which is you would still at the hearing then go to the legal question of whether or not what you agree happened here counts as gross negligence. You would say it has to be at least that in order to satisfy the for-cause standard. The other side would say no. So there's some work to be done in a hearing.
Absolutely. And what another way of putting it is, look, the denial of the hearing to my client, if she does indeed have a right to a hearing, cannot be harmless error. Like, it just can't, no matter what you think of the facts. On the other hand, if you agree with us on the law, you could still resolve this case in her favor on the grounds that, there were two mistakes here. One, she didn't get a hearing, but we don't have to remand for a hearing or any of the rest, because even on the facts kind of most, in the light most favorable to the government, this isn't a removable offense.
Can I go quickly to the standards? Because as I read the sort of what happened here, it wasn't as though the district court just sort of made it up in terms of what she thought should count as for cause. My understanding is that she was looking, as you've said several times, to the common law and what courts have traditionally said. And I see, for example, a Maryland court, Board of State Commissioners of Hagerstown in 1903, which is around the same time as the establishment of the statute, that said, quote, "The phrase for cause must mean some cause affecting the ability or fitness of the incumbent to perform the duty imposed upon him." And other similar courts at the time talked about pre-tenure conduct and said if it was pre-tenure, it can't be sufficient cause unless it was serious enough to undermine the job performance. A mere allegation was not enough back at common law. It had to have been tested and proven, like through a conviction. So these standards that were used here to determine, at least at the district court level, whether cause was satisfied came from somewhere. Is that right?
Absolutely. And, I love that Hagerstown case, because not only is it a very helpful common law case, but it's actually the basis for the definition in Black's law that the government and Judge Katsas below relied on. I mean, Black's law is an unusual dictionary. It just doesn't sort of, pop out the meaning from Noah Webster's mind. It cites cases for particular concepts, and the case it cites for cause is that Hagerstown case.
And so all the hypotheticals, I mean, we see them and they might be problematic, but they would be tested against the standards that the courts have applied, right?
Absolutely. And if I could just elaborate in one respect, I mean, if you think about pre-office conduct, there's only two kinds. One, there is pre-office conduct that was disclosed to the Senate in the confirmation process. And as to that, even the government sort of says, well, you probably shouldn't let the next president sort of relitigate all of that. And then the second kind is stuff that was undisclosed. And if it's as serious as we're talking about, that's essentially the nominee, defrauding the Senate. And so I actually think in that respect, impeachment is probably a more fit remedy than it might be in some other circumstance, because you're going to have whatever the conduct is, plus you're going to have the Senate being pretty darn vexed that was withheld from them in the confirmation
Final
process.
question. I took you to be conceding that there was notice here, and I guess I'm a little concerned about that. I mean, are you conceding that a posting on social media is sufficient notice in a situation like this when the president is seeking to remove a governor for cause?
So what I would say is, I think.
I know it happened. She got notice. We live in a world that is connected, but I guess isn't notice a particular thing in the common law?
Well,
put
it this way, I don't sort of resist the idea that the Truth Social post is notice, because I think it's also fundamentally defective notice, because it's also indisputable evidence that the president prejudged the matter. And
right,
so it's not the kind of notice.
So hypothesize he didn't say you are fired or you should be fired. Hypothesize he just said, I have this information and I intend to fire the governor. Why wouldn't he have to send the letter to her? How is it that we can assume that she's on social media or has looked at the news, or that that's sufficient notice, even if she did turn on the news and he's saying that? I don't know why that would be enough.
Look, I might make that argument, but that doesn't seem, if he said on Truth Social that, look, here, I have this allegation and I'm going to convene a hearing at the Roosevelt Room at 4 p.m. tomorrow. Please bring all your evidence.
What if she doesn't have a Truth Social account? She doesn't show up. Is that enough notice?
I think under those circumstances, probably not. But I think as a practical matter, in most circumstances, the president puts it on Truth Social. Most people, most of the time, are going to consider that to be notice. Again, part of the reason I'm not resisting is, or I'm sort of moderating this, is because this notice isn't the kind of notice the common law envisioned, because the common law would envision notice that didn't prejudge the matter.
Thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Turning to the question of whether or not in-office or pre-office misconduct can constitute cause, I want to make a statutory point, which is that the INM standard is, on its terms, limited to in-office misconduct, and Congress did not adopt that here. They adopted the more capacious standard, as this court recognized in Collins against Yellen. Cause gives the president more discretion and provides less protection to the officer than the INM standard does. And even if we were in a situation where you're looking at the 19th century case law and so forth, they disregard a series of cases that hold that pre-office misconduct is sufficient cause. For example, in Ray Gooden, which from New York in 1902, which involved an officer who engaged in a kind of shenanigan in order to get the office in the first place. There was a corrupt agreement to appoint somebody to a position if they supported that person politically. Iowa against Walsh, which was pre-office embezzlement. Gill against Watertown, a case they rely heavily on. It was said in dicta, at least, that gross frauds committed before office would constitute cause to remove. So there really isn't support anywhere for this notion that pre-office misconduct can't be considered when it comes to a cause standard. And related to that, I thought it was very telling that Mr. Clement was saying that if it does come to pre-office misconduct, impeachment would be the only remedy that would provide it, which, if taken to its full extent, would make governors of the Federal Reserve have the kind of tenure protections that the Constitution affords to Article III judges. That is not what this statute says. That is directly in the face of the statutory language, which says cause with no further restrictions. Clearly, Congress envisioned that they could be removed for a good enough reason. And on that point, I just want to emphasize, there's this colloquy about whether it should be sent back or decided now in the merits. Whichever way the court comes out on that, the court should send it back with an emergency stay. And I want to emphasize two reasons there. This court, no court should hold that the misconduct that's alleged here, which is at least gross negligence, at least an inadvertent notation that is a grave misrepresentation on a mortgage document that's designed to determine the governor's interest rates, is not cause to remove a principal officer of the United States who sets interest rates for the entire country. So all the discussion of what are the outer bounds of cause, where is judicial review, on that fundamental court, neither this court nor any other court should look at this and say, this is likely not cause. That sends the wrong message to the markets. It sends the wrong message to the American people who have to make correct representations to their banks when they're getting their mortgage interest rates. And the second point I would make is the remedy granted here, a preliminary injunction that runs against the president, reinstating a principal officer of the United States, is something that has never been granted before 2025 in this court or in the nation's history. And in fact, contradicts a clear holding of this court in Sawyer that a preliminary injunction is not available in equity. Those two reasons alone clearly suffice to send it, if there is going to be a decision to send it back with the emergency stay that we've asked for. And then if the court decides to sort of send the case back to have many more of these issues that we discussed today to be aired, we would urge the court, and I think Mr. Clement wouldn't disagree, to direct the lower courts to proceed very expeditiously here. We are in an emergency stay posture. The executive has been suffering irreparable harm since early September, and the sooner that these issues are resolved, the better. Thank you.
Thank you, counsel. The case is submitted.
Tax because it regulates arms-bearing conduct. As such, the burden is on Hawaii to justify the presumptive ban with relevantly similar historical analogs reflecting a national historical tradition of firearms regulation. Hawaii comes nowhere close to carrying the burden. Its presumptive ban defies a national tradition of allowing people to carry onto private property open to the public unless the owner objects. Hawaii's threshold position that this court should adopt a state-by-state community standard lacks support in this court's precedent, and Hawaii's argument the laws of the Kingdom of Hawaii should determine petitioner's Second Amendment rights is completely without merit. The presumptive ban is inconsistent with our national historical tradition of firearms regulation. Hawaii attempts to show a national tradition by relying on black codes expressly passed to discriminate against African Americans in anti-poaching laws. These types of laws are nowhere near relevantly similar, because nothing in our nation's historical tradition begins to support Hawaii's effort to thwart the exercise of a fundamental right Hawaii's law cannot stand. I welcome this court's questions.
You argue that this law prevents access to about 97% of public areas. How do you arrive at that?
We're not arguing this specific law is banning 97%, Your Honor. The overall package of laws passed by Act 52 bans, presumptively bans carry on 96.4%. And we arrived at that figure by having an architecture firm go through the public records of the County of Maui to determine which areas were regulated by this package of laws, Your Honor.
So that 94, I think it was 94, 97%.
96.4, Your Honor. Justice.
That includes all the areas the law bans, correct?
Yes, Justice.
I understood that much of Hawaii is state parks and state property, correct?
A portion of it, yes,
A
Justice.
pretty sizable portion. So that 94 is over-inclusive of private property, correct?
It includes parks and beaches, yes,
All right.
Justice.
Now, and there are other areas, sensitive government areas, et cetera, correct?
That is correct, Justice.
All right. So you say that there is a constitutional right to carry a gun on private property?
Yes, Justice.
I've never seen that right. I mean, I understand that there is a right to carry a gun on private property with an owner's consent, express or implicit, correct?
The Second
My
Amendment.
question is very simple. Is there a constitutional right to enter private property with a gun without an owner's express or implicit consent? The answer has to be simply no. You can't enter an owner's property without their consent, correct? Express or implicit.
Correct, because that would be a trespass, Your Honor.
All right. So if we start from there, then I start from the simple proposition. You want to say that there's a custom that permits you to go on private property without the owner's express consent, correct?
Yes, Your Honor.
All right. So Justice Scalia said that every statesman at the founding knew that you could not enter private property without permission. It's a trespass, correct?
It is. You're not allowed to come onto private property where you don't have permission to go to.
All right. So if we're looking at a custom, I thought under McKee, Justice Holmes looked for evidence, quote, that a practice had prevailed in Missouri where the suit originated. Whether you could collect shells in Missouri depended on whether there was a custom in that jurisdiction, correct?
The custom of the nation is what McKee holds, Your Honor.
And it didn't. It looked at the custom of Missouri where the suit originated.
McKee specifically talks about the laws of a nation as being what's dispositive.
McKee, Justice Scalia did in Hardeen's, but the McKee, Justice Holmes wasn't talking about the tradition of the nation. He was looking at whether the tradition of Missouri permitted people to go onto land to collect seashells.
I have to disagree. The words nation appears in that. It looks at.
All right, well, I'll look at it more closely. But at the time of the founding, or about the time, 71, 1721, 1722, up until the founding, there were at least 3 states who prohibited hunting, as you called it, or trespassing on private property with a gun, correct? So there was not a uniform national practice.
There was, Your Honor, of carrying on private property that's open to the public. Every case that every law that you're citing to deals with prohibitions on enclosed lands. And enclosed lands, there was those laws deal with, the enclosed lands were closed to the public.
Not necessarily. Look at Mount Vernon, where George Washington lived. There was a county shop there.
By definition,
That's a closed land.
Enclosed lands, I'd reference the amicus brief of the United States. They reference a law review article by Sigmund, and it goes into express detail that enclosed lands were closed to the public.
Council, do you agree, picking up on that Hawaii could pass a law that prohibited the carry without the express consent of the owner on lands that were closed to the public, on private residences?
I do not, Your Honor.
Really? Like, so I couldn't, Hawaii can't have that law about, my house or Justice Gorsuch's house?
Step one of the plain text would be implicated because we're talking about carry. And then Hawaii would need to justify that with a national tradition. And even assuming the 3 laws, I don't think 3 laws is sufficient to demonstrate a national tradition. So
but do you agree that all of the business owners and maybe also private property owners in Hawaii could get together and say, we don't want this, and they could not give consent? Let's say the law is flipped. It says it's illegal to enter if you have been denied permission to carry a gun on the property. You agree that all property owners could get together and say, we're denying permission, and they could put such placards up in their window, and then you would still not be able to carry a gun on 97% of the property in Hawaii?
Yes, Justice. Every private property owner has the right to affirmatively put up a sign or otherwise not give permission for people to enter property with a firearm. The crux of our argument is that Hawaii has flipped that historical default from them having to affirmatively say guns are not allowed here to the current law.
But I guess my question is, isn't that historical default that you're referencing really a default that is rooted in property law and not constitutional law, not in the Second Amendment? I mean, the argument that some have put forward is that this is really a property case, not a Second Amendment case. Yes, it is about guns, but the argument goes, what's really going on here is how states treat a private property owner's consent under circumstances in which everyone agrees that consent is required. You just agreed that consent is required. And so fine, there are many states, and perhaps even most states, that say we're going to imply that a property owner who opens his property to the public is giving consent for people to carry a gun. Hawaii has said, no, what we're going to do is we're going to say, even if you've opened your property up to the public, you still have to have express consent. We are not going to make our property owners put up signs or be the one that has to affirmatively express. The person who comes on has to have consent, as everybody agreed, and in Hawaii, that consent is expressed. Why isn't that and all the cases that speak to it in the historical record really about the property interests and property rights and not about the Second Amendment?
Because here the law at issue implicates arms-bearing conduct, Your Honor.
But that doesn't mean it implicates. What I'm suggesting is that it might affect, right? And the United States was here just last term talking about how you could have rights and regulations that affect someone's interests, but they actually don't implicate their constitutional rights. And so here I'm saying, yes, gun owners are going to be affected because the property owner says, no, I don't want you to bring your gun on unless you come to me and I give you express consent. But that doesn't mean it implicates their Second Amendment rights for the purpose of Bruin.
Well, in Bruin, the court said that there's a general right to carry.
A general right to carry on public property.
No,
Justice Barrett just explored with you the fact that you don't have a general right to carry on private property.
it's a right to carry in public, Your Honor, and not
Right.
a right to carry on public property.
But you do agree that there is no right to carry on private property without the owner's consent, right?
Here, the Second Amendment is implicated, especially when you anywhere you carry in public. And here, this lawsuit, it deals with private property that's open to the public.
I understand, but what I'm suggesting is that suppose this lawsuit dealt with someone's house and it's not open to the public. Do you concede that there is no Second Amendment right to carry a gun into someone else's house?
I do not, Your Honor.
You do not
I do not. You still be dealing with carry. If someone gives me an invitation, a general invitation to enter into their home, and there's a historical presumption that you're allowed to carry a firearm with you, then if the government passes a law that says, that flips that historical presumption.
Right, but I'm just suggesting that the historical presumption is about the consent, not about your rights. We agreed at the beginning, I thought there was a general consensus that your right to carry is limited to the permission of the owner when you're talking about private property. Like you've already agreed that the Second Amendment right is I would say subordinate, but you know, in the panoply of rights, the right to exclude is superior because the owner can say, no, you can't bring this gun in here. And so once you've done that, these laws that are about licensing or, you know, implying that the owner has consented are all in the realm of property law, I think, and not in the realm of the Second Amendment anymore.
I don't see it that way.
You disagree? All right.
Yes, Your Honor.
Thank you.
Counsel, do you agree that the state as property owner could exclude someone, not this implied consent law, but let's say that the state as property owner, put aside the fact that the sensitive places here include state-owned property. Assume that that's not so. Could the state as a property owner say that you can't carry a gun onto state-owned property as a matter of consent under property law?
No, Your Honor. I think that's a different analysis because now we're dealing with direct state action.
And the state doesn't have the right as a property owner to limit who carries a gun, say, into the governor's mansion?
I think that there are certain locations that where the
So it's all a matter of sensitive place.
yes, Your Honor.
Counsel, you make an argument that Hawaii effectively destroys the right to bear arms. You discussed that a little bit with Justice Thomas and with Justice Sotomayor. And I'm wondering where you think that analysis fits into the two-step Bruin framework the court announced.
In this case, step one merely deals with the fact that the state of Hawaii, that carry is implicated here. And once we go to once we accept that carry is bearing a arm is an issue here, everything else is dealt with under step two, the historical analysis portion of this analysis, Your Honor.
So it really doesn't matter whether it was actually 96%, which we know it's not, because you're dealing with the law as a whole. There's no means and scrutiny permitted by Bruin, correct?
Interest balancing has been abrogated by yes.
By Bruin. So
Yes,
there's no interest there. So if in fact, if Hawaii has a right to regulate a custom as opposed to a constitutional right to bear an arm on private property, then tough luck, correct?
We have established in our briefing, Your Honor.
Counsel, there's no means ends. So if they overregulate or underregulate, that's irrelevant. Is there a right to carry a gun?
As we know from Rahimi, there's a general principle that dictates that you have a general right to carry. When the government violates that rights, then because it violates that principle, then the second...
That's the interesting part. There certainly was a principle of the states regulating hunting on private enclosed property. There was a history of, in at least New York, in 1763, just before the founding, that prohibited trespassing and hunting on other people's lands because trampling on the land was destroying it. So you don't need, under Rahimi, an exact duplicate historically. You just need an analogous principle. If the states could regulate there, why can't they regulate here?
Well, very simply, those laws deal with just are not anywhere close to the law issue here. The state has pointed to a number of anti-poaching laws on property that was not open to the public, whereas here they're regulating a specific type of carry for self-defense on private property open to the public. I mean, these laws are just simply
But
not.
what's open to the public and the license that you have to use that land is subject to custom.
It's subject to a national tradition that we had at the time of the founding, Your Honor. It's not, a specific custom that exists right now.
If means and ends is not a part of our equation, I don't understand what pertinence that has.
Because in order to do the Bruin analysis, we look to see whether a law is implicated by the Second Amendment right. Then we look to see what the historical tradition was in this country.
But that seems, I'm sorry. If you could regulate to not trespass, trample the ground, if you could regulate not to hunt, if it's not means and ends, why can't you regulate simply to switch a presumption that gives the owner the right it has to give you express consent to say yay or nay to carrying the gun?
Well, for two reasons, because that violates our nation's historical tradition of firearms carry, and two, it violates a principle that.
But we didn't have.
Counsel, I
Go ahead.
see that your red light is on.
Yeah, yes, Your Honor.
We've been talking about private property and public property. A gas station on the side of the highway is private property. It's owned by the gas company or whatever. Do you assume that you have the right to go on that private property even without any express permission,
Yes, Your Honor.
even though it's private property?
Yes, absolutely, Your Honor.
Is it a different analysis or the same analysis when you're talking about a dwelling along the side of the of a road?
That's a different analysis, Your Honor. You have to see whether there's some sort of invitation to come in there.
Is there, under our law, an invitation, for example, for people soliciting, for people who want to drop off pamphlets about a particular?
Yes, Your Honor, up to the doorknob or the car, there is.
Even though it's private property?
Yes, Your Honor.
Stranger can walk off the sidewalk and go up to the door?
Yes, up to the door, Your Honor.
Thank you. Justice Thomas? Justice Alito?
Under Hawaii law, are there any other objects besides guns that a person may not possess when that person enters private property that is open to the public?
Not to my knowledge, Your Honor.
Thank you.
Justice Sotomayor?
In Hawaii for 200 years, there's been no custom of carrying weapons, correct? Up until Bruin and Heller.
Up until Bruin, you could not get a license to carry a firearm, Your Honor.
So 78% of Hawaii residents and 64% of Hawaii gun owners do not think that loaded concealed weapons should be allowed into businesses at all, correct?
I'm unaware of that statistic, Your Honor.
I wasn't aware of your 96% number either. Nothing about Hawaii's customs, tradition, or culture creates an expectation that the general public carries guns wherever they go, correct?
Hawaii is part of the United States, and as part of the United States, our national tradition is that people are allowed to carry on private property that's open to the public.
This law is not banning you from doing that. It's just requiring you to get the owner's permission, correct?
And here, the law has always been that you had an implied right to enter onto
Not in
property.
Hawaii.
As Hawaii is part of the United States, Your Honor, and as
But if it's a local custom that controls,
it's not a local custom that controls. It is the
where
custom.
else in the law have we permitted local custom to create a constitutionally protected right?
Bruin was very clear here that we're dealing with our national tradition, Your Honor, is not local custom that controls in this area of law.
Justice Kagan?
Mr. Beck, the various statutes that Hawaii has cited as going to the Bruin Step 2 question, you say they're not close enough. And I guess I want to know why. I mean, I was struck by the fact that there are quite a number of statutes that do exactly what this law does. They flip a default rule as to how explicit consent has to be. You know, they recognize that you don't have a right to go in without consent. You do have a right to go in with consent. And then the question is, how do we determine consent? And what default rule do we start with? And I guess what struck me about these statutes and about how close they are is that that's exactly what each of these statutes did. So why isn't that pretty good evidence under Bruin Step 2 that this is something that states historically have done?
The state is not cited to a single case that is relevantly similar to the one at issue here. We've got basically two sets of laws. One were the anti-poaching laws that dealt with private property that was not open to the public, one. And part of that also is there were exemptions for people to be able to carry firearms onto those lands that for purposes of self-defense. So land that's not open to the public, where you still have a self-defense right, isn't relevantly similar to the law at issue here. And the other sets of laws that have been cited to are black codes. And those can't be relevantly similar. As Justice Kavanaugh said in Rahimi, you know, we've moved away from that history. And in addition, it dealt with a very, discriminating against a very small subsection of society rather than prohibitions on the general right to carry.
Yeah, so let me go back to the first thing. The idea that these are anti-poaching laws. I mean, okay, Hawaii's is not an anti-poaching law, but I suppose I'm sort of stuck on the fact that that doesn't seem to be the relevant similarity. In Rahimi, we said, you can go up a level of generality. You don't have to have a historical twin. There can be differences. In Rahimi, the essential similarity that we thought controlled was just that the guns were being used to protect against people who would be violent with their guns. And, that's a pretty general principle. And here, the general principle is sort of similar. We think that there's a danger of various injuries occurring when you go onto private property with a gun. It might have been in the old days poaching. It might be something else now. But because that's so, we are going to use a default rule that says to the property owner, if you want this, okay, but you have to say you want it. It seems to me the same. It's a different injury. It's not poaching anymore, but it seems to me the same state mechanism, the same kind of state regulation.
Yes, Your Honor, but one dealt with private property that was not open to the public, whereas this law is dealing with private property that's open to the public. And in addition to that, the anti-poaching laws also gave you a right to be able to carry firearms for self-defense. So I just simply don't see how the level of generality there would simply swallow the rule if this court were to accept those anti-poaching laws as being relevantly similar here, Your Honor.
Thank you.
Justice Gorsuch?
Your friends on the other side in the Ninth Circuit relied on two statutes in particular. One was the 1771 New Jersey law that you were just discussing with Justice Kagan. But the other one that was left unmentioned was an 1865 Louisiana statute that was adopted immediately after the Civil War as part of an effort, it appears, to disarm Black people. The Reconstruction governor later explained that this law, of course, was aimed at the freedmen. Do you think the Black Codes, as they're called, should inform this court's decision-making when trying to discern what is this nation's traditions?
I do not, Your Honor.
Well, your friend on the other side says it should, and that the 1865 statute is a, quote, dead ringer for this statute.
The 1865 law was expressly passed to discriminate against African Americans that were newly freed slaves. And I just don't see how a law like that can be used to be analogized to a modern day law, this modern day law, Your Honor.
Justice Kavanaugh? Justice Barrett?
Do you agree with everything in the government's brief?
No, I do not, Your Honor.
The United States government.
Yes,
Okay.
Your Honor.
The government that's on your same side.
Yes, I understand. I agree with
I'm not asking you to throw your case away.
I fully endorse the United States brief, Your Honor.
Okay, and then I just have one clarifying question. When Justice Kagan was pressing you on the analogies between the anti-poaching laws and Hawaii's law, one of the things that you used to distinguish it was that the anti-poaching laws applied to private property, and these applied to property that's open to the public, albeit private. But I thought you had initially told me that Hawaii couldn't do this with respect to property that was like a dwelling, a private residence either, that was not open to the public.
Well, what I'm saying is that that would simply, that's a different historical analysis. And if they were to muster enough historical analysis to justify the law, that might be true. I just don't think that they've developed enough history on this record to be able to justify that law, Your Honor.
Justice Jackson?
The Chief Justice asked you about a gas station on the side of the highway, which is private property, it's open to the public, and you said that we presume that a person can go in under those circumstances. Is that right?
That's correct, Your Honor.
All right. I guess what I'm positing is that the reason we presume that a person can go in is not because they have a constitutional right to go in under the Second Amendment or anything else. The reason we presume they can go in is because property law implies that a gas station owner who has private gas station and opens it to the public has consented for people to come in. So it really is a function of property law and the extent to which the consent is being implied or, expressed, and the state law governing that, right? I mean, it's not, you don't have a right to go into private property. You're only there because the owner has either implicitly or expressly consented.
You have a constitutional right to carry your firearm onto that specific gas station.
You do. Where is that? I thought the reason why this was all here and is because you had an implied license. I thought the historical tradition required you to have a license because you don't have a right to go onto private property. And the tradition was we're going to imply that you have a license under these circumstances.
The basis of this lawsuit is that we're only discussing private property where you have a right to enter onto that's open to the public. And we're saying that once that property is open to the public, we have a right to carry a firearm onto it.
Okay.
Unless the government.
Okay, I think I understand. Let me just ask you about the black codes. Justice Gorsuch raised it. And I guess what I'm wondering, your answer to him was they can't be and shouldn't be used. And I guess I'm wondering whether that doesn't signal a problem with the Bruin test, that to the extent that we have a test that relates to historical regulation, but all of the history of regulation is not taken into account, I think there might be something wrong with the test. So can you speak to that?
There's nothing wrong with the Bruin test, Your Honor. Just on a fundamental level, the black codes can't be used because they dealt to discriminate against a small.
No, I understand why you're saying they can't be used, but it's because we've moved away from that history, not because that history didn't exist. And so to the extent that the test today is tying us to historical circumstances, it would seem to me that all of history should be on the table. And if we start taking pieces off, whether it's because we've moved away from it or we don't agree with it anymore, I think there's going to be a problem with respect to the accuracy of our test.
Your Honor, it's not just because we don't agree with it anymore. It's that the 1865 law is not relevantly similar because it dealt with a very small segment of society that was being discriminated against, whereas here, law is a law of general applicability. So the
to people other than the people in this small segment that you're talking about, who were a part of society, but I guess you're saying that for the purpose of this test, we're not going to consider what happened to them.
No, what I'm saying is that the Black Codes dealt with a very, it wasn't a law of general applicability. It was designed to discriminate against, it was a racist law designed to discriminate against African Americans. Whereas here, the law at issue here is a law that applies to everyone. We can't use a racist discriminatory law to justify a modern day law that applies to the general public, Your Honor.
Thank you.
Thank you, counsel.
Thank you, Chief Justice.
Ms. Harris?
Mr. Chief Justice, and may it please the court, Bruin held that states can't refuse to license public carry. Hawaii can't gut Bruin by presumptively banning everyone licensed to carry from doing so at retail establishments or other private property open to the public absent the owner's express consent. That novel law offends our history and tradition. First, pretextual restrictions are by definition unconstitutional in why they regulate. Here, the law's text belies Hawaii's claim to protect property rights. Hawaii subjects just one right, the Second Amendment, and one class of people, the people Hawaii had a license to carry after Bruin, to its presumptive ban. Hawaii lets everyone else, including target shooters and hunters, bring firearms, machetes, and other things absent the owner's objection. Second, pretext aside, Hawaii can show no tradition behind its law. Its best analog is an unconstitutional Black Code. That's because from the founding, the tradition has been the opening property to the public authorizes carrying. I welcome the court's questions.
What's your best support for what appears to be your argument that a pretextual regulation is per se unconstitutional?
I would start historically with Blackstone and the meaning of the word infringed in the text of the Second Amendment. If you look to Blackstone, which is one of the main sources underpinning what the pre-existing Second Amendment right meant, the canonical example of a law that burdened impermissibly the right to bear arms was the English game laws, which under the pretext of trying to preserve game were designed to prevent commoners from hunting. And we know that was one of the animating premises of the Second Amendment from people like St. George Tucker, from Justice Story. And again, the very meaning of the word infringed in the Second Amendment shows this is part of the history and tradition underlining
The analysis that you're suggesting, Ms. Harris, is this part of the Bruin test or is it something separate from the Bruin test?
It is part and parcel of the Bruin test. It goes to why the law is regulating the way it does in Bruin's words. Or in the word of Rahimi, it goes to whether there's a permissible reason. It helps you tell whether the analog is really
You're
analog.
on step 2 of the Bruin test. You think about pretext. Is that what you're saying?
I think that's fair because step 1 is, are you regulating arms bearing conduct? And so one of the parts of whether you tell, is this part of the history and tradition? And are the potential analogs really analogs? As you say, why is this modern law regulating the way it is? And if it's pretextual, by definition, you're not going to have analogs because there is not a history and tradition of pretextual laws that negate the right.
Why do we need to make it? Oh, go ahead.
Mostly in our constitutional law. I mean, there are exceptions here and there, but mostly in our constitutional law, we've steered clear from trying to evaluate motive, purpose directly. You know, we create rules that maybe are meant to ferret out bad motive, but we kind of think it's a bad road to go down if we're going to ask about every state's, whether the state is acting contextually in doing one thing or another. And I'm just wondering why we would have a different thought with respect to this right.
Because respectfully, that's not our position. We're not saying, think about what's on people's minds. If you have bad motives, it's bad law. What we're saying is look at the text and see if there is a fundamental mismatch. If the law is gerrymandered textually, which is the case here, in such a way that belies the assertive motive.
So
that is familiar.
That seems fair, but then it seems as though that's classic means end scrutiny. You know, look at over-inclusion, look at under-inclusion. Is the state really regulating what its interests would suggest ought to be regulated? So that's means and scrutiny, which I thought Bruin was supposed to get us away from.
So 2 points on this. Respectfully, no, we don't think so. We think Justice Churchill-Lukumi in the First Amendment context is a case about pretext and not sort of means ends. It's about how do you tell from the text of the law? Is it gerrymandered in an impermissible way? That's what we're asking for here. And the Second Amendment, of all places, in terms of history and tradition, is where this test would apply. Because again, the original meaning of the word infringed in 1791, and I would point you to the Daniel Slate article on this, infringe, what included the Blackstonian concept that if you are regulating for a pretextual purpose that is belied by the design of the law, that is a classic means of infringement.
Why are we, sorry,
Okay.
why are we making it complicated? The text of the Second Amendment covers arms. Part 3 of Heller says that means what it's, Heller says it means what it says what it means. Part 3 of Heller says there's certain exceptions to that or contours on that, which are rooted, but they have to be rooted in history. Here, there's no sufficient history supporting the regulation, end of case. Isn't that kind of the straightforward way rather than getting into this whole new elaborate pretext analysis, which, as Justice Kagan says, sounds like what we moved away from?
So absolutely, the case could rise and fall on the lack of history and tradition. I think the one
It's pretty simple, right? Your position is there are no sufficient analogs. Usually when, as Heller says in Part 3, when you're looking for a historical tradition that justifies an exception to the textually expressed right, it's got to be a deeply rooted tradition, broadly consistent over time and broad among a lot of states. You don't have anything like that here. So it's just kind of, from your perspective, pretty simple.
From our perspective, it's an overdetermined case. I think the reason you might want to go on.
Why not just, why didn't you lead with that? I don't understand why you led with the other argument, and it maybe neither here nor there at the end of the day, but I was trying to figure out why.
I think 2 reasons. One is because it would be a shame, I think, if the Bruin inquiry discounts the idea that, or just doesn't account for pretextual laws, given how rooted, how antithetical they are to the history.
What do you mean by pretext? Because a government often will look at one of our precedents and say, well, we don't agree with that precedent, but we want to regulate right up to the line of that precedent. There might be some gray area there. I mean, we don't call that pretext every time when a state government does that in the First Amendment.
No, and I understand. I don't want to fight this too hard because I think we are in agreement that this is an easy case at the end of the day. And every single way you look at it, there's no history and tradition.
Ms. Harris, on that, moving to that, there's been some suggestion that this is just, redefining property rights and has nothing to do with the Second Amendment. And of course, we don't allow governments to redefine property rights in other contexts that would infringe other constitutional rights. I'm thinking here of the Takings Clause in Tyler versus Hennepin County. But I'd like you to respond to that argument.
That is exactly correct. In no other context could you say that there's an exemption to constitutional restrictions just because you're trying to redefine the laws of trespass. The state cannot. And the First Amendment's another example beyond the Takings Clause. I think Lamont, for instance, is on all fours. You could have very easily said in that case, no big deal. Federal statute is just flipping the presumption. Normally, the default rule is recipients of mail get the mail unless they say no. Just flipping the presumption. Now you don't get your mail if it's on a certain topic unless you affirmatively consent and send in a very easy to send postcard. The court absolutely rejected that reasoning.
But Ms. Harris, can we just be a little bit more specific about the Second Amendment right that you say is being infringed here? This is the point that I guess I'm still stuck on, is whether or not in a world in which we all concede, and I think the United States is on board with this, that the Second Amendment yields to the property interests of a private property owner, such that the private property owner gets to consent as to whether or not you can carry a gun on his property. When we're in that world, what Second Amendment right is being infringed when the property owner says no, or when the state says the property owner's consent has to be expressed?
So let me unpack that both in terms of the methodology and the ultimate answer. I think when you collapse the whole inquiry into a specific question of what happens vis-a-vis property rights, you're backing away from the Bruin framework. The 2 steps are,
I am backing away because the Bruin framework only applies where the Second Amendment is implicated. And what I'm suggesting is that the Second Amendment right is not being implicated when the regulation is about the property owner's consent, the form of it. Can it be implicit or must it be express? In a world in which we've said that consent already takes precedent over the Second Amendment right.
So what we're answering here is what is the scope of the right to publicly carry under the Second Amendment? And I don't think states can get out of constitutional scrutiny by trivializing what they're doing.
But haven't you already agreed that the Second Amendment right yields to the property owner's consent?
Of course, we're not saying that you override what property owners are saying, but what we're saying is when a restriction parts ways, when it redefines the concept of trespass to essentially say for this one category of people licensed to carry, you are no longer presumptively allowed to carry at gas stations.
But you're only presumptively allowed because the presumption goes to the consent, not to your right.
I understand.
You're presumptively allowed because we're presuming that in this situation, the owner is consenting.
And this goes back to the colloquy with Justice Gorsuch, which is when states are trying to redefine property concepts, that doesn't take them out of constitutional scrutiny. Quite the contrary, in both the First Amendment context and the Takings Clause context, the rule is when the states are departing from the default in a way that implicates other constitutional rights, they can't do that. The Takings Clause may be an outer limit in sort of what exactly states can do. But it would be, I mean, just the floodgates would open if the position were all that's going on here is just tweaking how you consent. Just think about, I think in the First Amendment context, you would say, no big deal. You are now going from a world where candidates can go door to door and for campaign speech, but now you have to have a big sign in your yard that says political speech welcome for someone to go in. Or in the Second Amendment context, Hawaii's same reasoning would lead to a rule that it's fine to ban tenants from owning guns in self-defense unless the landlord in the contract expressly consents to doing so. And I really think the concept that this is just tweaking consent elides the burden that Hawaii is imposing here of presumptively banning open carry, banning public carry.
Thank you. Justice Thomas, anything further? Justice Alito?
Would you explain why the anti-poaching laws that Justice Kagan was talked about are not, in your view, an appropriate analog?
Absolutely. Those poaching laws, as the Sigmund article and other sources and the text of the laws themselves exemplify, show the opposite of the tradition Hawaii is trying to show. They show that for property closed to the public, the people have taken steps to enclose for improvements to protect the fields from being trampled by hunters. For that special category, there were laws that said you have to get affirmative consent, sort of like Justice Barrett's questions about do you need affirmative consent to go into dwellings. The rule for other property open to the public, open fields, was the exact opposite. There was a conscious decision at the founding, because hunting was an incredibly important issue, that if you did not enclose your lands, it was an open invitation to carry, and that's consistent with the tradition at the founding of public carry that the NRA amicus, for instance, details. The idea that Hawaii's law is a relevant analog would just take the level of generality to just justify the opposite of the tradition. It would have been profoundly disturbing to the founding generation to hear that in order to travel at inns or taverns or anywhere else, people commonly carried arms, that they had to get the affirmative consent of each sort of tavern and hope that they weren't trespassing if they were traveling and their carriage had to stop somewhere.
In order to determine whether an analog is adequate for Bruin purposes, is it possible to disregard how do you choose the level of generality? What is the principle that tells you what is the relevant level of generality?
I think here the relevant level of generality does revert to some the property law concepts. If you're talking about property open to the public, the relevant comparator is property open to the public because there is a relevant common law tradition of certain permissions that go there. And when the state is essentially presumptively banning or switching the tradition, I think that is an issue. So I think that's relevant. And to disregard the clear text of these statutes, which are focused both on property, that distinction between property closed to the public and open to the public, and the specific question of hunting would allow you to abstract out everything. It's the same thing the court rejected in Bruin, that just because some places, for instance, might be sensitive places, every place could be a sensitive place on the same reasoning at too high of a level of generality.
What do you think is the purpose of the Second Amendment right?
The purpose of the Second Amendment right is to allow citizens to bear arms for self-defense and other lawful purposes.
And other lawful purposes.
Yes.
not just self-defense. Did Heller say that?
I don't think Heller excludes it, and I don't think the court has to decide is it self-defense and other things, but it would be, again, sort of strange to think that you cannot use arms for any other purposes when the founding generation considered arms important, not just for self-defense, but for instance, for making sure that people were proficient in arms to be able to defend the country. So I don't think that there is sort of necessary, but I don't think the case presents the question.
Do you think it's possible to ignore the purpose of the Second Amendment in determining the level of generality that's appropriate?
I think that it depends on the case. For this particular case, I don't think the court has to resolve it because the point here is Hawaii is saying its law is supposed to protect private property rights, and it's essentially trying to negate people's right to publicly carry everywhere.
Justice Sotomayor?
There's been a number of church shootings recently. Does the state or the federal government, does it bar from saying you can't go into a church without a gun, without the owner's permission, the church's permission?
So
Is that illegal?
the answer to that question would go into the sensitive places inquiry, which is different from this case because that is sort of place specific. So the question would be, is there a history and tradition of allowing restrictions on people carrying in churches?
I suspect there isn't. So I suspect, I could be wrong, I never read about that, but if we're not looking at property rights and a government's right to regulate a presumption, then what would give the government the right to think that flipping the presumption in that case is reasonable?
Again, I
Just
think
as here, where most property owners for 200 years didn't carry weapons in this state without an owner's consent. That's the presumption of the Hawaiian people.
So 2 points on that. One, with respect to the presumption of the Hawaiian people. As petitioner notes, there is no Second Amendment for every single state in the union that's different. It is a national tradition and states cannot retain their pre-statehood traditions as sort of a veto for the Second Amendment national traditions.
It's not a veto. No one's vetoing an owner's right explicitly or expressly to consent to carrying guns. The owner's the one with the right.
So to be clear, what I mean by that is you can't use local customs to say that each state gets its own Second Amendment. The court has rejected that very type of analysis in the Takings Clause, for instance, in Hennepin County, in Cedar Point, where the court said, even if California has a kind of unusual way of defining easements, or Minnesota has a strange way of defining property interests, that doesn't mean that sort of
There's nothing unusual about this. This is simply a presumption.
Respectfully, this is highly unusual, as the heirs article itself acknowledges. In all 50 states in the District of Columbia up until Bruin, the universal rule, and this does trace to the founding, is that when you have property open to the public, you are inviting people to go on with arms unless the owner says otherwise. We think that implicates the Constitution, the Second Amendment, for the same reasons it implicates other amendments and other
doesn't
contexts.
change that. The presumption lets the owner choose.
The presumption is that you're trespassing. It treats just for one class of people. It turns essentially property open to the public, like a gas station, into the equivalent of someone's house, where you're committing a crime under Hawaii law if you actually go onto it without consent.
Mrs. Kagan?
Can you imagine, Ms. Harris, any modern analogs of these anti-poaching laws? I mean, I guess what I'm asking you to do is to say, are there any modern laws that sort of use this kind of authority over, consent and licensing and so forth, but that don't have to do with hunting, that would be permissible because they're very much like these anti-poaching laws?
So 2 answers. One is obviously these laws themselves have endured throughout, which is why I think maintaining the distinction is important. But 2, you could say it's not that distant, but there is a separate tradition with respect to property close to the public, like your house. What are the relevant permissions? What's the default for property close to the public, setting aside hunting? And I think that's consistent with the way these laws work. I mean, Justice Sotomayor mentioned the 1763 New York law, and that's talking about enclosed property like orchards or gardens or other stuff, and saying if you carry arms on that land, that's a trespass. But it's also saying you can't trespass generally in these places. So I think it's getting to the idea of if you have particular property that's close to the public, you might not want people with arms on it. That is what these sort of founding era laws say. You don't want them trampling your cornfield and destroying your improvements because it's closed to the public. Similarly to, you might be able to say, you know, and again, this is a matter of like what the history would actually show. So,
if I can, your objection to the use of these old laws really is just that the Hawaii law applies to although it's private property, it applies to property that is entirely open to the public for all other purposes and with respect to all other activities. And that's your view of why Hawaii is different. And if the Hawaii law was narrower than that, or if some other states were, then you would have a different question.
I think it would present different questions. And yes, that is our main objection. And the reason is Hawaii is trying to use laws that actually show the opposite tradition, which is laws closed to the public. You might need affirmative consent in order to be able to hunt on them. Property open to the public, though, is the exact opposite rule from the founding on otherwise, in order to ensure that people could publicly carry absent objection. And so, yes, I think that that is the most critical point about these laws. The fact that they concern hunting, I think, is a relevant additional factor that goes into what was the point of the presumptions. But the fact that it's hunting and also sort of other forms of trespass, I think, is the bottom line.
Thank you.
Justice Gorsuch?
There's been this suggestion that this is just flipping a presumption about the implied license and that that's just a matter of property law, not the Second Amendment. But how do we think about that, given that it flips the presumption on the longstanding implied license only with respect to firearms, not knives, not solicitation, not politicking, not anything else?
That's exactly right. I think there's two ways to think about it. One is we do think that that makes it much more like the kind of pretextual laws that the founding generation thought were anathema to the Second Amendment, because you're singling out a particular right in a particular group who's committing trespass when everyone else isn't. But two, just going back to this concept, you can't just say, you're tweaking how to give consent and you're out of the Constitution. When a state is saying you're presumptively banned, you're committing a crime unless you get consent, that is a much bigger deal than just sort of tweaking the edges of property law. And in no other context has the court said, no big deal, the Constitution doesn't apply, this doesn't even implicate the relevant constitutional inquiry.
What are the implications? Hawaii allows oral consent to be sufficient. California had a law requiring a posted sign. The Ninth Circuit struck that down while allowing Hawaii's law, but I'm not sure I understand the distinction between the two. Why couldn't a state require affirmative signs? Why couldn't it perhaps create an irrebuttable presumption against consent?
I think that is exactly where Hawaii's position leads. I don't think there's any principal distinction between those two things. And again, it's not just sort of, oh, is it easy to get one person's consent? How hard is it? That's kind of interest balancing at the outset. But as a practical matter, in order to run your errands, you have to run the table of knowing you're not trespassing on private property to like pick up your dry cleaning and catch a cup of coffee. And if you run out of gas and you're trying to find a gas station, you can't get gas unless you're in your car, you have your gun in your purse, and you're not actually committing a crime by stepping on the gas station property. Now, Hawaii is trying to say it's a little easier than that, but the text of its law says just entering the property without permission is a crime.
And then lastly, there's been some discussion about the black codes, and maybe they should be relevant, and maybe we really should consider them as significant here. In fact, they're a dead ringer. Thoughts?
It is 2026, and it is somewhat astonishing that black codes, which are unconstitutional, are being offered as evidence of what our tradition of constitutionally permissible firearm regulation looks like. Those laws are dead ringers only in the sense that this law too is an unconstitutional pretext. The black codes were offered, as you mentioned, by states before their readmission to the Union. It is not an indictment of the Bruin framework to say that unconstitutional laws do not count in illuminating a valid tradition. As Bruin and Rahimi themselves say, you're looking for laws that aren't outliers. They illustrate what the national tradition entails. And so it is no indictment, but frankly, an endorsement of our history and tradition that when you look at the founding era laws, they are very different from the black codes, and that these black codes themselves are complete departures from what the laws in Louisiana and other states were like before, which was to allow people to presumptively go about in public on property open to the public without consent.
Thank you.
Justice Kavanaugh?
For purposes of the textual and historical tradition analysis specified by Heller and elaborated upon by Bruin, Heller's Part 3 on exceptions remains very important, I think, in my view, at least. Do you agree with Part 3 of Heller, accept Part 3 of Heller?
Yes, we are not trying to depart from anything that this court has said with respect to its Second Amendment precedents.
And then in Part 3 of Heller, the court said that nothing in our opinion should be taken to cast doubt on laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. Do you agree with that?
We agree with that, and I think as elaborated by Bruin, I think the question is, how do you define relevant sensitive places at the correct level of generality so that not every place is a sensitive place and so that you are looking to the right historical analogs?
Understood, but you agree with the principle as stated there?
We agree with the principle as stated that there are obviously sensitive places. You determine them with respect to the history of firearm regulation.
Thank you.
Justice Barrett?
Mr. Harris, I'd like to talk about the relevant analog in these anti-poaching laws. And one question that I have is along the same lines as Justice Kagan, which is when you're thinking about these anti-poaching laws, you're thinking about a problem that arose at the time. So at the time, poaching was a problem, and so legislatures enacted this regulation to address the problem. In an agrarian area, an agrarian society, that was it. Let's imagine that Hawaii, rather than just flipping this default categorically, instead is experiencing, say, a rash of gas station robberies. And, doesn't want to make the argument that gas stations are sensitive places. That would be a tough one. So instead flips the presumption like the anti-poaching laws, just with respect to gas stations. Is that okay?
Not okay, and it still runs up in the basic distinction that we're seeing, which is when the history and tradition is for the type of property open to the public to have an implied license to go into the property, when the state is trying to load the dice, when it's trying to say you generally can't go there, it has to point to relevantly similar analogs that are doing the same for the how and why. And the anti-poaching laws, it's not just that they're about hunting, it's about that they're this specific part of land. It's almost like they're the exception to the general rule that on property open to the public, you can generally carry, on property closed to the public,
how do you know that's the relevant distinction? I mean, it could just be that, well, that is an incidental of the problem. I mean, that just happens to be where the problem of poaching arose, which was on enclosed lands, because those are the people who were trying to protect themselves from poachers. But I mean, there might have been poaching on open lands too. And then the legislature might have responded differently. I think this is this problem of just because the legislature didn't address a problem because it didn't exist at the time, why does that mean that the analog ties the legislature's hands now?
And I think the answer is that is you look to the broader articles and I think history of what was going on with the anti-poaching laws. It's not that, poaching on or hunting on lands open to the public wasn't a problem. It was actually at the founding, it was a hugely politically salient and highly debated issue, so important it was in state constitutions, that this was a sort of elemental distinction to the founding generation that's carried on our property law, that property open to the public is not, you're not trespassing if you're hunting on that land, and property closed to the public, you want to protect the improvements, and so you are allowed to restrict it by changing the rules so that you have to affirmatively consent. And I think you know that from the laws themselves, actually. I think the laws themselves make that distinction. I point you to the New York 1763 law. The 1771 New Jersey law is of a piece with that, and the Sigmund article is sort of canvasses the history, but I think this is not just, well, it's sort of strange they were focused on this particular type of land. What do you draw from it? They were extremely focused on this because it was a huge political topic.
Okay, but Ms. Harris, then that raises this question for me. In footnote 1 of your brief, you say this case does not concern property closed to the public. So the court need not address state laws that prohibit carrying a firearm into a private residence without the owner's affirmative consent. But both you and Mr. Beck are drawing this distinction in the anti-poaching laws between property that is open to the public and property that is closed to the public. So I guess I don't understand how, if you win this case and we do the history and tradition analysis and you win, how is the court supposed to distinguish that analog in the way that you're proposing we do without deciding this question, you tell us we shouldn't be deciding.
Right. So I think two things are important. One is when you're deciding whether the analogs are on all fours, it's inescapable, and it runs throughout the position that there are different permissions, different common law traditions applicable to property open to the public and property closed to the public. I don't think that is a complete answer, and the reason we're saying it's just not presented is it's not the question presented. To whether property closed to the public, what the range of permissions is. For instance, if I invite someone to my house, what is the tradition with respect to that?
So maybe the state could flip the presumption in the way Hawaii has done here, but just with respect to private residences. Mr. Beck said no to that.
We're leaving that open because we're thinking of this as, again, different property traditions. And so they would have to show a relevant history and tradition. Again, I think that would be likely easier for them because the rules regarding property closed to the public have always been different than property open to the public.
Okay, last question. On your broader argument, you state the rule pretty broadly. I'm looking at page 11 of your brief. You say a law is per se unconstitutional if it broadly prevents ordinary Americans from carrying protected firearms in public. Who is an ordinary American, and why? Kind of throughout your brief, you use that formulation, but as I recall, in Heller, it says ordinary law-abiding Americans. Why not the law-abiding, and what is an ordinary American?
I don't think we're trying to suggest any difference between ourselves and Heller and our position here. I think we're frankly using it as a shorthand.
Okay, thanks.
Justice Jackson. So I guess I really don't understand your response to Justice Gorsuch on the black codes. I mean, I thought the black codes were being offered here under the Bruin test to determine the constitutionality of this regulation. And it's because we have a test that asks us to look at the history and tradition. The fact that the black codes were at some later point determined themselves to be unconstitutional doesn't seem to me to be relevant to the assessment that Bruin is asking us to make. So can you say more about that?
Absolutely. Black codes were unconstitutional from the moment of their inception because they are pretextual laws that are designed to ensure that newly freed slaves are returned to a condition of sharecropping.
Okay, let me stop you there. They were not deemed unconstitutional at the time that they were enacted. They were part of the history and tradition of the country. And when we have a test now that's asking us to look at what people were doing back then, I don't understand why they should be excluded.
Because they are outliers. They are by definition unconstitutional. They have
Found later,
unconstitutional.
afterwards, not at the time. And if the test says what's happening at the time tells us what's constitutional for this purpose, why aren't they in?
Respectfully, a law is always unconstitutional. When it's from its inception,
So the history doesn't matter. We shouldn't care about the history then.
We should deeply care about the history, but the whole point of the Bruin framework is as follows. The history and tradition of the Second Amendment are particularly important because it is codifying a pre-existing right. To figure out in sort of common law fashion what the national history and tradition are, you throw out outliers. And I can think of no greater outlier than blatantly unconstitutional laws that flipped what had been the tradition in states like Louisiana. And during the period before those states were readmitted to the Union, for the purpose of trying to reduce newly freed slaves back to conditions of servitude, made it a new crime, new trespass in order to go about armed on private property. Those are obvious outliers.
All right,
It should not count under the whole point of Bruin.
Mr. Katyal will address it. I just have one more question. I'm trying to understand whether there is a Second Amendment problem in the following circumstance. So what if a state that's trying and hoping to dissuade gun rights, so it fits your view of like a state acting in a pretextual way, passes a law providing for free no gun signs to every business. And they're really very invested in this, so much so that their law offers to send these signs to every business, offers to send someone out to put the signs up at the business owner's request. Do we have a Second Amendment problem in that situation?
If you're just, no, I don't think so. You're not having a law that's regulating arms bearing conduct. I think the premise, the hypothetical is you retain
But it
existing rule.
affects arms bearing conduct, perhaps in even a more egregious way than what you're talking about here today.
I think we go back to the words of Bruin and Rahimi.
And their purpose is to dissuade. That was part of the hypothetical. So your test was about the purpose of the state. We have the purpose here. We have the effect here. 97% of the businesses, let's say, in Hawaii, under the test that or the law that I'm positing, accepts this offer.
Yes, and what I'm trying to distinguish is I think your hypothetical really illustrates what we're not doing, which is a bad legislative motives, purpose, and sort of effects test. Whereas what we're saying is our pretext argument is very firmly rooted in the idea.
Right. I just want to know, is the Second Amendment implicated? And I think you're saying no, and I don't understand why it wouldn't be in this situation if it is in the situation here.
Because in the law that Hawaii is enacting, it is regulating arms-bearing conduct by saying, if I carry my gun to a gas station, I am presumptively committing a crime. That is a direct regulation of where and how you can bear arms, under what circumstances. You are hypothesizing a situation in which the state is merely subsidizing certain types of speech. That might have other constitutional problems, but the problem is not going to be with respect to regulating arms-bearing conduct in the way that we think Bruin is talking about.
Thank you, counsel. Mr. Contio.
Thank you, Mr. Chief Justice, and may it please the court. This case is about two fundamental rights, the right to bear arms and the property right to exclude. And there's lots of agreement among the parties about how those rights interact. Everyone agrees there's the right to carry on private property if the owner wants guns on his property. That was elicited by Justice Sotomayor to my friends. And everyone also agrees there's also no such right if the owner doesn't want guns. The only question is whether there's a Second Amendment right to assume the owner wants guns on his property when he's been silent. There is not. There is no constitutional right to assume that every invitation to enter private property includes an invitation to bring a gun. The Constitution protects the right to keep and bear arms. It doesn't create implied consent to bring those arms onto another's property. At bottom, that is petitioner's theory, and yet they have zero support for this. Zero support from the founding or for the next 200 years. No treatise, no commentator, no court. Not only is there zero affirmative support, it runs counter to our traditions of implied consent. From the founding and Federalist Paper 45 on, states have used law and custom to clarify the rules around consent. In some states, it's natural to say when a homeowner invites you in, they're fine with you bringing your gun unless they say otherwise. But in others, it's pretty obvious that if you bring your gun to someone's house, you have to ask. And the same is true for stores. In some places, it's reasonable to assume guns are welcome. In others, it's pretty clear an invitation to shop is not an invitation to bring your Glock. It's reasonable for a state to clarify these defaults, passing laws that say you can assume consent absent permission, or as here, that you can't assume it. The Constitution permits this type of democratic flexibility in states functioning as laboratories. Before rigidly constitutionalizing one type of property default rule, this court should insist on at least some evidence that the Second Amendment so requires it. I welcome the court's questions.
Are there any other constitutional rights that you could place on which you could place similar limitations?
Sure. I think the general proposition of the law is that property rights, are
open to the public. Always add that part. We're not talking about private homes. We're talking about restaurants. We're talking about malls, things like that.
Yeah, so I do think, first of all, I do think they are talking about private homes. That's what I think ultimately my friend conceded to Justice Barrett earlier in the
I thought
question,
he made the distinction between private homes versus private property open to the public as opposed to closed to the public.
Justice Thomas's brief made that distinction, but at least as I understood what he was saying at argument, that his rule would apply even there. And I think this is what's so dangerous about his rule, because he's saying, look, as long as something has to do with guns, then we go right to Bruin step 2 where the burden is shifted.
Well, that's, I'm not going to argue that point, but I do want to know if there are other constitutional rights in similar circumstances on which you could place similar limitations.
I do think that there are. I think here, this case concerns guns, but sometimes, like, for example, this court's decision in Breard recognized for some First Amendment restrictions, you could have a change in the default rule, and that was understood as constitutional. Here, we're just following the
So
long.
suppose there were a state that said, we're going to flip the default rule so that you cannot leaflet in shopping centers. unless you secure permission first. Would that be constitutionally problematic or not?
The problem there is that oftentimes in the First Amendment context, the First Amendment rules are different than the Second Amendment because they forbid content discrimination and viewpoint discrimination. And a leafleting law often will have some sort of illicit thumb on the scale for a certain set of viewpoints. And so
Well,
that's
but like any leafleting for anybody
yeah, so in that,
on any subject.
right, in that circumstance, this court's precedents on viewpoint and content are so broad, it might encompass that. But even if even if you could jump past that, you'd still have to at least have rational basis review. This court in Free Speech Coalition versus Paxton recently said, even for stuff that isn't encompassed in the First Amendment, you still have to have at least some rational basis. Your example would flunk that. Here, Hawaii's done the opposite. There have been no guns effectively in Hawaii for 200 years. The underlying, expectations and local custom, as Justice Sotomayor was saying, was that nobody had to think about guns. What the Hawaii legislature said here in the wake of this court's Bruin decision is, Bruin's a real game changer. Not going to read someone might have a concealed Glock on them and the like. And so to vindicate those expectations, they said, we are placing the default rule there on the property owner to say whether they wanted to affirmatively invite guns in. And in choosing where to place that responsibility and that burden, I think it's absolutely reasonable for the state to place it with private property owners whose consent is required.
Counsel, I just want to understand, because one of the motivating concerns, and you can see it in our decisions under the Second Amendment, is that it is a disfavored right. And it strikes me that one of the things that your side of the case has to come to grips with is that it is a very clear constitutional right under the First Amendment. If I, for example, as a candidate for office, want to walk up to your door on private property and knock on the door and say, here, give me your vote, that's exercising the First Amendment right. But you say that it's different when it comes to the Second Amendment, that you can walk up. So when the candidate wants to walk up and he's carrying a gun, what exactly is the basis for the distinction? Because part of, again, what our precedents talk about in this area is that the Second Amendment has been treated as a sort of, a second level right. And that's one area where given this law, I don't really see the basis for the distinction.
So we totally agree the Second Amendment is no disfavored right. At the same time, there are rules about the Second Amendment, I think rules that this court laid down in Bruin, in which you've said the relevant question is whether or not the scope of the Second Amendment's text as informed by history would say that there is a violation of the right. With the First Amendment, you've got burden tests and all sorts of stuff that this court disclaimed in Bruin at page 22. And so it's just going to apply somewhat differently. But our fundamental point to you is, yes, this is a law that which traces back to the founding with other laws like New Jersey in 1721 in 1771, laws that basically said, look, when you're bringing guns onto property, even property open to the public, that states are free to flip the default rules. Indeed, that is what happened, going back all the way to those early examples. And my friend on the other side is, I think, selectively reading those to say, the Solicitor General saying, these laws are just about poaching and the like. Absolutely not. They have no answer to what we said in our red brief, which is that these laws dealt with improved lands, and improved lands were, as Professor Hertog says, stores, seed stores, and things like that.
Right. But let me just switch gears a little bit. We talked about the tradition in Hawaii. Hawaii, given its obvious origins and its admission to the United States fairly recently, has a totally different, in some areas, tradition and practice. The law of property in particular in Hawaii, I mean, for the longest time, maybe it's still the case, is that you don't own property, you get a long-term lease as if you were a bank in a skyscraper in New York. That was the common method. And I wonder, I thought, as was mentioned earlier, it is part of the United States. And do we have different traditions in different states when it comes to applying Bruin?
No, Your Honor. I think my friend on the other side has mischaracterized our argument. Our argument is that the Second Amendment means the exact same thing in every state. No Second Amendment right to enter private property without an owner's consent. What varies is what the definition of consent is from state to state. And local law and custom help inform that. That's what I think that Justice Holmes' opinion in McKee recognizes. So just to take a simple example.
Well, just before, I don't want to lose the thought. You said part of the history and tradition is there's no right to enter private property without the owner's consent, right?
Mm-hmm.
Well, we know that that's not a through line, right? Because you do have a right to enter the owner's private property if you want to exercise your First Amendment rights, right?
So not without their consent, Your Honor.
Sure. I don't have to have a sign on the sidewalk before you enter my property saying, okay to come on if you're going to give me some leaflet, or okay to come on if you're a candidate. The assumption is that there is a First Amendment right. Yes, you can withdraw it. And again, I'm just trying to figure out exactly what the difference is between the First Amendment and the Second Amendment.
What I think what's doing the work in your hypothetical about the leafleting or something is the government is putting its thumb on the scale of some sort of speech and saying they're worried about some type of leaflet or the like. To the extent that they just ban it entirely, it would flunk rational basis review. The relevant right there is not located in the property in the place it's spoken, but rather that the government is coming in and affirmatively taking a position.
Thank you, Counsel.
That.
Well, Mr. Kyle, I don't understand why you're resisting the First Amendment. Well, I do understand why you're resisting it, but let's say there's no content discrimination. It's just a ban on leafleting, and it's a ban because people don't like solicitation. So they just don't want people passing out pamphlets. It's not aimed at Jehovah's Witnesses or anything like that, like some of our old cases. Why would that fail rational basis review?
So I think it might, because as this court said in Free Speech versus Paxson, you still have to have some underlying rationality.
Yeah, people
for it.
find it annoying. They don't like it. They think it affects their businesses, and people don't want to go to businesses if they're going to be accosted by pamphleteers.
But it may be a rational basis problem, but I don't think it's a First Amendment problem. This court in Rowan said that, quote, the right to engage in expressive activity generally stops at the outer boundary of every person's domain.
And that's the
Let me
point.
one more question. So let me take it out of the First Amendment for you. I mean, let's pretend that public accommodation laws don't exist, because the 14th Amendment doesn't apply to private action, only state action. Let's say that a state, in the absence of public accommodation laws, decides to flip the default and say, unless the owner affirmatively consents, Black people cannot enter your home.
Yeah, so I think that's one which would be unconstitutional
Why?
every day of the week, because it would violate the Equal Protection Clause, because the government on its face is making a racial classification. So
Because there's state action in the way the government is adjusting its property defaults.
Absolutely.
Even if there's a long history and tradition, say in Louisiana,
Yeah.
of this kind of discrimination at the doorstep.
right, it would still violate the Equal Protection.
Why isn't there state action here when the state is flipping the default? It's not just a matter of property law.
Right, our point is not that whether there's state action or not, it's that there's no underlying right. It's that my friend assumes, is conceded this. He said there is no right to come onto private property absent consent. And so the only question is whether the state can fill in the conditions.
Yeah, there's
of
no
that
right to
consent.
come onto private property without consent. So my public accommodations example is right. I mean, absent a public accommodations law or in a private residence, you could turn someone away on the basis of race.
But there is no anti-discrimination component in the Second Amendment the way there is with the Equal Protection Clause. And so that's why it
So, Mr.
functions.
Katyal,
Mr.
going
Kyle,
back
you're just relegating the Second Amendment to second-class status. I don't see how you can get away from that. If someone owns a store, or let's say it's a little restaurant, and this person has very strong political opinions and does not want anybody in that restaurant who is wearing attire that is expressing approval of a particular political candidate, that person, the owner of that restaurant, has the right to say, you can't come in, right?
Yes.
All right. Now, could Hawaii enact a statute that says that if you are wearing the attire expressing approval of a particular political candidate, you can't come in unless you get express consent from the owner of the restaurant?
Again, that's a viewpoint discrimination and prohibited.
It's a
by-
violation of the First Amendment. We have a violation of the First Amendment and a violation of the right that the court held is protected by the Second Amendment in Bruin, which is the right of law-abiding citizens to carry a firearm for purposes outside of the home for purposes of self-defense.
I quite agree with much of what you're saying. I think what's the difference is that the Second Amendment, it's not a second class right. It just doesn't have the same components of viewpoint discrimination or anti-discrimination for the 14th Amendment. That's just not in the Second Amendment. And I think the key point here is the court, if you accept my friend's invitation, you for the first time would be saying there is some sort of right here which no commentator has recognized, no treatise has recognized, no court has ever recognized. Compare this to Bruin, in which you had St. George Tucker, you had many state decisions in the 18th and 19th centuries that said laws like the New York one were unconstitutional.
Well, Justice Sotomayor cited a poll about what the people of Hawaii think about the possession of guns. I'm not aware of the poll, but let's assume it's correct. Let's assume that 78% or whatever the figure was in the poll that she cited really don't like guns. So what then is the big deal about this statute? Why does it matter if store owners and owners of private property that are generally open to the public don't like guns? Why is it a big deal to say they want people carrying guns to stay out? Just put up a sign.
Yeah.
Why does Hawaii have to have this law?
So I think Hawaii has, like all state legislatures, has the right to put a default rule in that says, that tracks the expectations of its people.
That's true. Then what's wrong with California's law, which flipped the default rule and said it can only be overcome with a sign?
Right. So I do think California's law would probably be constitutional, but our argument doesn't depend on it
So
because
you
Hawaii
disagree with the Ninth Circuit's decision on that score.
I do, but I think that here,
a result here, you'd admit would logically entail permitting California's law or ones like it to pass as well.
no, you don't have to go that far.
Oh,
You
I know I
can
don't
say-
have to go that far, but you just said you would go that far.
I personally would, but I don't
Yeah,
think
okay.
you do, Justice Gorsuch. So in the reason.
No, I appreciate your candor about the extent of where your argument leads. And so it seems to me that, you could have a state law that doesn't just flip the presumption and require express oral consent, but requires express written consent, maybe a sign, maybe an irrebuttable presumption, flipping of and I appreciate your candor on that. The other question I want to ask you is the black codes. I struggle to see what relevance laws that are outliers, and in Bruin, we're not supposed to consider outliers, that they're put aside under our test. We're looking for the mainstream and a significant tradition. And you rely very heavily on an 1865 black code law in Louisiana. You say it's a dead ringer and a reason alone to affirm the judgment. And I really want to understand how that could be.
So let me take those in turn. So first, with respect to the California law, I think it's really important to understand here, the Hawaii law has a much broader definition of consent.
I know it does. That wasn't the question. Why don't you answer the question posed?
About the California law?
No, I want to understand how you think black codes should inform this court's decision-making. It's quite an astonishing claim to me.
So the black codes are undoubtedly a shameful part of our history, but that doesn't at all mean that this particular law is irrelevant to Second Amendment analysis for two reasons. First, the Solicitor General says correctly, as she did just now, that Louisiana wasn't a state in 1865. The relevant point is what happened in 1868 when Louisiana was admitted to be a state. The Act of June 22nd, 1868 admitted Louisiana as a state. That was the Radical Reconstruction Congress. It examined the Louisiana laws, including this specific statute, and Louisiana was admitted into the Union by the Reconstruction Congress. There were many laws that the Louisiana...
You're not answering the question. The question is, it's an outlier. And you just call it a shameful outlier. And I agree with that. And Bruin was supposed to look at the mainstream of our tradition and history, not outlying statutes that were unconstitutional the moment they were passed. And yes, when Louisiana was admitted to the Union.
So Justice Gorsuch, when I said it
I understand a lot of people like to cite the black codes who promote gun restrictions, who would otherwise, they would be garlic in front of a vampire in front of them. But here they like them, they embrace them, and I'm really interested in why.
So Justice Gorsuch, when I said the black codes were a shameful period, there are parts of the black codes like this particular statute, which were race neutral, which the Congress of the United States, the same Congress that ratified the 14th Amendment, implicitly blessed by admitting Louisiana back in. It didn't treat that with respect to other laws from other states, but it did here. And most importantly, even the opponents of the black codes recognized, as the Sickles General Order says, that you have no right to carry a firearm onto someone's property absent their consent.
Mr. Katyal, wasn't the purpose of the laws in the post-Reconstruction South that disarmed black people precisely to prevent them from doing what the Second Amendment is designed to protect, which is to defend yourself against attacks? They didn't want that. They wanted to disarm the black population in order to help the Klan terrorize them and law enforcement officers in that period, in that region. They wanted to put them at the mercy of racist law enforcement officers. So is it not the height of irony to cite a law that was enacted for exactly the purpose of preventing someone from exercising the Second Amendment right, to cite this as an example of what the Second Amendment protects?
So Justice Alito, we quite agree with you that parts of the black codes were motivated by and had exactly that operation. Our point to you is this consent requirement did not operate that way. Indeed, if anything, it protected black churches and black-owned businesses and the like by insisting on this consent rule. And that is why the radical Reconstruction Congress admitted Louisiana back in. They said no to various laws, but they never did that with respect to this. And this law stayed on the books for a long time. More generally, of course, we've obviously for good reason taken all this time on Louisiana, but remember our argument. If we were to get to the historical analogs and the like, we don't think we even need to. But if you got there, you wouldn't just look to Louisiana in 1865. You'd start with New Jersey in 1771.
Well, on Louisiana, in Ramos, on the jury trial right, the question of whether he had a right to a unanimous jury, there were Louisiana and Oregon precedents going way back that allowed non-unanimous juries. And we flatly rejected that historical example for the exact reason that Justice Alito and Justice Gorsuch have been mentioning. Those were rooted in racial prejudice designed to prevent black jurors from having their votes counted on juries in the wake of a decision like Schroeder in 1880. And we just said, no, that's inadmissible to account for that as somehow justifying an exception to the constitutional right. It seems like the same kind of thing here.
No, Justice Kavanaugh, we just disagree with the idea that that applies to this particular law from Louisiana 1865. But regardless, our tradition goes way back before that. New Jersey in 1771, 1721 Pennsylvania, the law said, quote, you cannot carry any gun or hunt on the improved or enclosed lands of any plantation. The 1763 New York law, which the Solicitor General only read part of, says that it was unlawful to carry, shoot, or discharge any musket or other firearm whatsoever into any orchard, garden, or other enclosed land whatsoever. And there's other statute after statute. There's no allegation by anyone that those were motivated by any sort of racist concerns or the like. And what they've said is, oh no, that was just limited to poaching. That's just wrong. There's two parts, for example, to the New Jersey law. Part two is about poaching.
And
Part
on
one
those laws, a couple of them that you cite, it seems to me you're approaching the whole analysis upside down from how the court's cases have approached it. The court's cases have started with the text, which declares an individual right. And then in Heller and in Bruin, the court has elaborated on it. Of course, there's, as there are with all rights, as Heller said, some exceptions. But those exceptions to be recognized must be historically rooted. Deep tradition, broad tradition, widely recognized, commonly recognized, not isolated examples, particularly not ones from the black codes, but even apart from that, not isolated examples. And I just don't see the kind of broad tradition of the regulation here that you see with the other things specified in Heller, for example.
So I agree with some of what you're saying. So I completely agree that the relevant test under Bruin is text. And then the next words you used were as informed by history. And so the question is whether or not there is some sort of right at the framing, whether the right to keep and bear arms was understood, the right to assume an owner's consent to bring arms. That's where we think their case falls apart, because for the first time, you'd be saying, if you accept their invitation, in the absence of any affirmative evidence whatsoever, a commentator, a court, anything that said that there was a right to imply consent, there's just nothing. There is precious zero on that. And here's why it's so important. You heard my friend when he stood up, he said, and under questioning from Justice Barrett, hey, is your rule going to apply to private homes? Because lots of states even today have those, Alaska, in Arkansas and the like. And he ultimately said, yeah, because the burden shifting, you wouldn't be able to defend the law under the burden shifting of step 2 of Bruin, in which you have to have demonstrated historical analogs and the like. That gets everything undone entirely. I mean, this court has a general rule, Justice Alito wrote about it in Kennedy versus Louisiana, which is when you are coming in to challenge a state law, you bear a heavy presumption that your challenge is invalid, that there's a presumption of good faith and presumption of regularity on the part of the legislature. If you just jump to Bruin step 2 and say, oh, this law deals with guns, therefore the burden flips to the government, then yeah, you're going to have a really difficult time defending laws. Every state is like the ones that deal with gun consent on private homes.
Well, which is why you don't want to get to step 2, because it's a lot harder for you at step 2. But I think what Justice Kavanaugh is asking is, I have the same question, is how can you avoid step 2? Because the text encompasses it. And that leads you to step 2, where you have all the difficulties you were just saying.
Because if you read Bruin as only about the text, okay, I agree with you. You could say, well, maybe it's the right to keep and bear arms is implicated by these implied default rules, but it is the text as informed by history. And when you ask yourself, text is informed by history, where has anyone ever said there's a right to presume consent of the owner in the absence of an explicit statement? It just doesn't exist.
That's the second step when you're looking at the history. I mean, I could see history being relevant at the first step if you're talking about what is the meaning of arms, for example. But when you're talking about things that kind of go to what is the core of the right, or is it included, and you're talking about history and tradition, I guess I don't see how it's the first step.
Well, I think it's got to be. Otherwise, I think you run into the problem that you've now flipped the burden for every firearms regulation. As long as it deals with guns, then the state has to come in, or the federal government has to come in with an affirmative thing. And we have all sorts of laws.
That's exactly what the cases say.
Oh.
I mean, I thought that's what the cases say. If it deals with arms, and this is what Heller Part 3 says, then the government comes in and shows there's a historical tradition. And to get ahead of all this, Heller actually went through and specified a number of kinds of regulations that would be permissible because they are so broadly and deeply rooted. At least, I mean, what's wrong with that reading of our precedent?
Because then it would really, as the Everytown brief says, threaten gun regulation more generally in ways this court has so far not reached, because you have all sorts of times in which, like take the 922 statute, 11 different categories of things that are singled out as gun regulation. If every single time the state had to defend the burden on each of those things and say, you've got to find historical analogs, that really does undo, I think, the much more limited nature of the inquiry that Bruin
Mr. Cutchell, I
recognizes
thought your
step
answer
1.
to Justice Barrett and Justice Kavanaugh is that really step 1 is trying to help us to understand what the scope of the right is.
Correct.
The Second Amendment right, is it really being implicated here?
Correct.
And so that when you have a situation like this one, in which there is broad consensus, everybody agrees that there is some limit to the Second Amendment right, and you read a case that said that limit was geography, in the sense that you don't have a Second Amendment right to bring your gun onto someone else's private property. They have to consent for you to be able to do that. We have already limited the scope of the Second Amendment right for purposes of this discussion, because we're talking about a right that doesn't just freely exist. So in the Chief Justice's leafleting example, it's similar. Like, I don't see the Second Amendment operating differently than, say, the First Amendment, because in the leafleting example, The reason why you get to go up to the person's door is not because you have a First Amendment right to do that. You get to go up to the the person's door because there is a custom and tradition of implying the person's consent for you to do that in that situation. That all the states, everybody says when you come for the purpose of passing a leaflet, we are going to assume, we're going to imply that the owner is allowing you to do that. He doesn't have to put up a sign that says, please come. But it's operating around property rights, not that your First Amendment right is what is getting you onto his property. Similarly, the Second Amendment right is not getting you onto someone's property in this way. If it's a private property, even the property open to the public, it's the implicit consent that many states have allowed that is what is doing the work of allowing you to carry your gun in that gas station. Am I right about that?
That's exactly right. And the one thing I would add is that what I think is doing the work in my friend's argument is some sort of insinuation that Hawaii has singled out and is hostile to guns or the Second Amendment and the like. And I point you to two reasons why that's wrong. Number one, Hawaii has these very same laws about implied consent and changing the default rules for other things besides guns. So 445-115 has it for cards and banners and placards, akin to the example that you're mentioning before. 339-4 is about litter and bringing it on. 291C is about vehicles.
And what you're saying, I think, is that there is no Second Amendment right to assume implicit consent.
Yeah.
There is no, to the extent we're talking about, is this about consent? And I think we are, because you don't have a right to go on without consent. Then is the Second Amendment doing work with respect to allowing you to say, I have a constitutional right to assume that I'm allowed to be here? And you're saying they have no case, no history, no nothing that establishes that principle.
That's exactly right. And the other thing I'd point to about this motivation attack by my friend on the other side is that, Hawaii, the legislature took Bruin seriously. This statute's all about making sure the right of Bruin is vindicated. And just last year, for example, Hawaii issued 2,207 concealed permits for firearms. They only denied 119 applications, and the majority of those were denied because people didn't fill out the application in full or they got it out of time.
Thank you, counsel. Justice Thomas?
If you're going to cite the Louisiana Black Codes of 1865, don't you also have to cite the subsequent adoption of the 14th Amendment that was in part generated because of laws like that?
Right, so that is exactly our point, that the Reconstruction Congress that ratified the 14th Amendment, this is the unusual case in which you have those folks saying, effectively, Louisiana should come in, and many of the parts of the Black Codes, including parts that Justice Alito referring to that were racially discriminatory about firearms, were struck from the Louisiana law. But this law stayed in effect. And so, yes, we do think it is relevant history. We don't think our argument depends on it because there's statute after statute from the founding on. And the idea that the number of statutes we've provided isn't enough, I think is very hard to reconcile when you have zero tradition, zero evidence on the other side saying these statutes were problematic. I mean, these statutes are around. You would have thought someone, if this was an infringement on the right to keep and bear arms, would have had a court case, a commentator, anything like what you had in Bruin. You've got none of that.
Well, actually, there was quite, as I said in my McDonald opinion, quite a bit of discussion of these sorts of laws and the consideration of some that they thought that the Privileges or Immunities Clause in the 14th Amendment preempted these. That's simply my point.
So Justice Thomas, I agree with you about what you said there, but I don't think that applied to this specific question, which is private property default rules. I think what the evidence you were talking about there dealt with other aspects of state regulation over firearms.
Justice Alito? Justice Sotomayor?
Three-part question. In one or two sentences, could you finish answering the California point that Justice Gorsuch raised? Number two, finish your list on where else the state of Hawaii has flipped the presumption. You got up to littering and then you were cut off. And then number three, I have never quite understood the the court's recent jurisprudence on outliers don't count. I don't know how much outliers mean.
Yeah.
Meaning at the founding, there were 13 states. I don't know how many territories at the time because I don't remember off the top of my head, but there were at least 4 states that had flipped the presumption: New Jersey, New York, Maryland, and Pennsylvania. And then later there was Massachusetts in 1790, at least for a group of islands. And then you don't have just the black codes, you have Oregon and Florida flipping the presumption a little later on. So it seems to me that you can't call all of these laws out, this many outlaws, outliers. And so the custom and tradition that existed was you did the license you had, and whether you presumed or didn't presume permission could be flipped, correct?
Correct.
So why don't you answer the other?
Yeah,
two
so on the California thing, the one thing I would just add to my prior discussion with Justice Gorsuch is just, I think the overall history of what the Hawaii legislature did here was relevant. They weren't trying to attack a second-class right or something like that. They were rather trying to take Bruin seriously by opening up what counts as consent, unlike California, deviating even from the old historical laws like New Jersey in 1771, which required written consent. And I think what did the work in my friend's argument in his opening statement was this idea that 96.4% of Hawaii is now encompassed. You pointed out that dealt with sensitive places, but there's a much more fundamental problem, and it has infected this case from the start. If you read page 1 of his brief, it says, quote, it says 96.4% of the publicly accessible land in Hawaii is impacted by this law, by this law. The map he's got isn't even about Hawaii. It's about one county in Hawaii, not even the most populous county in Hawaii, and it's a map he drew himself. So I just caution the court into saying, because if you read these briefs, it does sound like, oh, the government of Hawaii is out to get guns or something like that. Nothing could be farther from the truth. They've taken Bruin seriously, as the permit statistics I read to you say. With respect to Hawaii singling out firearms, there's statute after statute. I was reading 291, 112, which is that you can't use a vehicle for habitation on private property, quote, without the authorization of the owner. There's also 633.16 that you can't remove shopping carts without the written consent of the owner. There's statute after statute like this, and the amicus briefs from the property law professors goes through and says this is true not just in Hawaii, but in state after state. They flip default rules all the time. Your last question was about outliers. And I think here our most important point is we don't think that there's some sort of mechanistic formula for how many states is enough or anything like that. We do think it's relevant that there are a number of states at the founding that do have this. This court on the sensitive places part of Bruin said legislative assemblies may be a sensitive place. There was only one state in the founding that had that. That was Maryland, and it passed 2 separate laws 5 years apart during the colonial era. That was enough to count as an analog. We certainly think the much larger number here is enough to count as an analog, because these laws actually did the same thing as what the Hawaii law does. It said, for respect to property that is open to the public, like plantations, like premises, like enclosed land. Professor Hartog says that includes seed stores, other retail establishments, akin to the kinds of things that my friend is challenging here. There is historical precedent for all of that. We think that's certainly enough to make this constitutional.
Justice Kagan?
So just on your last point, Mr. Katyal, I took Ms. Harris to be saying with respect to your analogs at Bruin Step 2, that her principal point was, look, it's not about like, is it about poaching? But the difference between those laws and this law is that those laws were about lands that were closed to the public. And that was her principal point, that made that like just a different category.
Right. And it just blows off the word improved in the statutes. It's not just about it's not just about fenced land, but improved land. For improved land, the statutes did change the default rule and say you couldn't imply the consent of the owner. And as Professor Hertog said, that applied to stores, it applied to plantations. Indeed, that's the definition of plantations, and it applied to premises, which is another word used in some of these statutes. And so the idea that it didn't apply to these types of things that are just like what my friends are challenging is just wrong.
Okay. And on this, your step one inquiry, which I find interesting and difficult. I mean, I think somebody could say, look, what these consent flipping, default flipping rules do, they do burden the carrying of firearms. And that's what they are. And to incorporate the burden into one's understanding of the scope of the right is a kind of category mistake. That it's the burden is supposed to be at step two, and these are burdens on the carrying of firearms.
So two things. One, factually, we just fundamentally disagree that this burdens firearms. As Justice Alito was saying earlier, if people in Hawaii don't want to have the guns anyway, they're always going to be able to, even under their rule, say, have signs that say no guns allowed. So either way, you could have that burden. The second thing is legally, this court has made clear as day at page 22 of Bruin, you can't ask that burden test. Here's the language. You said, quote, Heller and McDonald expressly rejected the application of any judge empowering interest balancing inquiry that asks whether the statute burdens a protected interest in a way. And so, that which my friend is definitely trying to say, that this burdens the right, that is not a Second Amendment violation. That's going down the road of undue burdens that this court has criticized in a separate number of contexts and saying that's a smokescreen for policy judges' preferences. Rather, the inquiry at Bruin step one has always been text as informed by history. And when you ask yourself what in the text informed by history this Hawaii law violates, the answer is precious zero. No commentator, no treatise, no court, no one's ever said you have a right to imply consent of the private property owner. And rather the fundamental tradition, which Justice Sotomayor was saying earlier, that Justice Scalia recognized in the Jardines opinion, is that there's a fundamental right to exclude. And that right to exclude has always meant at the time of taverns and the like, you can exclude people for violating the terms on which they come in, even if your tavern's open to the public.
Thank you.
Mr. Gorsuch?
Near as I can tell, the movement to flip the burden with respect to firearms began in the states in 2020. Is that right?
The burden to flip the firearms with laws like this, I think they arose after Bruin. I think that was when this court's decision in Bruin happened, and then laws like the states like Hawaii, in which there was no tradition at all of carrying, had to deal with this question for the first time.
Thank you.
Justice Kavanaugh?
How many states have laws like Hawaii's with respect to firearms on property?
So I think 5 states have enacted those laws just in the few short years since the Bruin decision. I think other states, there's a brief for you from DC saying some other states are considering it. Our point is the Constitution permits both types of rules. It's not constitutionally compelled that you have to use the Hawaii rule. States function as laboratories. They can pick either default rule. Neither is an infringement on the Second Amendment right to keep and bear arms.
Thank you.
Justice Barrett? Justice Jackson?
And it's not an indictment necessarily that this arose after Bruin. It was in response to Bruin because Bruin gave rise to the need for clarity about property owners. Once Bruin said you can carry the gun outside of your home, and there was an alternative, well-established principle that private property owners can exclude people, I think the states were trying to make sure that property owners had the opportunity to do that. And that only became necessary once Bruin allowed people to carry their guns anywhere.
That's exactly right.
I mean, it wasn't like they were necessarily trying to keep people from carrying the guns. They were giving property owners the right to exclude by making sure that they were asked, do you want this gun in your store.
Exactly. And I was saying to Justice Gorsuch, with respect to California law, Hawaii took it far more seriously. They said, we want to make sure that you have the opportunity to get on the spot oral consent, which is why the gas station hypothetical that the Chief Justice used and the others, it is not an issue under the Hawaii law, because you do have the ability to go and ask for consent, even if there's no postage, no sign one way or the other.
Thank you, counsel. Rebuttal, Mr. Beck?
Your Honor, as NRA's amicus brief makes very clear, this is a historical tradition of carrying on private property open to the public. This whole legal theory regarding the presumptive ban, default rules, started off the law review article that was published in 2020. And the premise of that law review article is putting in a presumptive ban like Hawaii has would lessen people from carrying. The state of New York adopted that law first, and the governor of New York said the express reason they were doing that was to undermine the Bruin opinion. There's a clear body of evidence here that this was done to undermine Bruin and to undermine the Second Amendment right. And thus, this law very clearly implicates the Second Amendment, and the state has simply failed in its burden to justify this law through relatively similar historical analogs. Therefore, this court should rule in our favor.
Thank you, counsel. The case is submitted.
All right.
It's very admirable, and I understand Canada's position.
We continue our live coverage now with a discussion on the Russia-Ukraine war with Republican Senator Tom Tillis and representatives from Ukraine, Finland, and Canada. We're joining this in progress live here on C-SPAN 2.
We will hear argument first this morning in case 2438, Little versus Heckox. Mr. Hurst.
Thank you, Mr. Chief Justice, and may it please the court. Idaho's law classifies on the basis of sex because sex is what matters in sports. It correlates strongly with countless athletic advantages like size, muscle mass, bone mass, and heart and lung capacity. Tragically, but not surprisingly, male athletes have even injured female athletes in many sports. If women don't have their own competitions, they won't be able to compete. Gender identity does not matter in sports, and that's why Idaho's law does not classify on the basis of gender identity. It treats all males equally and all females equally, regardless of identity, and its purpose is exactly what the legislature said, preserving women's equal opportunity. In fact, it's our friends on the other side who want to classify based on gender identity. They're seeking special treatment for males who allegedly lack an unfair advantage, but only if those males also identify as transgender. Denying special treatment isn't classifying on the basis of transgender status. It's consciously choosing not to. Idaho's sex-based classification would get intermediate scrutiny if Heckox challenged it. But Heckox's requested relief presupposes separate women's sports. All Heckox challenges is the law's application to a tiny subset of males who identify as transgender and suppress their testosterone. But that's not how intermediate scrutiny works. Idaho's law is a substantial fit for 99% of males, and a perfect fit is not required. If it were, that would be the end of all sex-based classifications. Finally, a word about mootness. When trying to avoid mootness below, Heckox told the court, "I intend to play women's club soccer this semester, next semester, and through the remainder of my time at BSU." A contradictory post-cert affidavit does not make it absolutely clear this controversy is over, so Heckox's formidable burden isn't met, and this case isn't moot. I welcome the court's questions.
There'll probably be some questions about mootness, but I'd like you to, in focusing on the equal protection analysis, the sex classifications in sports is not being challenged.
That's correct.
How does that work in this case when we're talking about one individual being accepted from a particular or included in a particular category?
There's no basis for heightened scrutiny, intermediate scrutiny in that situation, Your Honor. If the sex-based line passes intermediate scrutiny, which no one disputes that it does, then the edge cases, the potential exceptions, that's all rational basis review.
That makes no sense to me. All right. And I don't know how you can say sex classification is not being challenged. There's no question here that a male who identifies as a female, but it's a male, is being excluded from a female sport, correct?
That's correct.
All right. By its nature, that's a sex classification. And all sex classifications, we have said repeatedly in our case law, require intermediate scrutiny. Now, what you're saying is, well, she's not challenging males generally not playing. She just doesn't want to be the one male excluded. So it's a subclass of people that she's challenging, correct?
Yes, I think that is correct.
All right. So how do you square our various case law, Caban, Lear, Claiborne, VMI in particular, all of whom involved a subclass of people who challenged on equal protection grounds their exclusion from a definition?
I'm happy to take those cases in order, Your Honor, starting with Caban. There was no notion of as applied anything in Caban. In Caban, it was a facial challenge to the statute, and individual circumstances were used as examples to prove that the statute was overbroad and lacked a substantial fit.
That's the point. That's what she's saying here, that the state interest here is the safety of women, correct? And promoting competition. That's the state interest. And in Caban, the state interest was in ensuring that only children with active parents, let's say, were given a state benefit, correct?
Yes, and Caban was struck down facially. The statute was considered unjustified.
How about Lear?
In Lear, we had the same,
That's the opposite. That's the subclass, the people who were excluded.
in Lear, the court said, the law would be justified with respect to you, plaintiff, and because the law would be justified with respect to you, you are not able to challenge the law elsewhere.
All right,
So the
how
court
about
says,
BMI? That distinction doesn't make any sense to me. It's still an exception. It's a subclass of people who are covered by the law and others are not. That's what we said.
the VMI case is the flip side of Idaho's law. The VMI case, equal opportunity required letting women in to previously single-sex spaces. In this case, equal opportunity for women requires giving women separate spaces. And VMI said that was okay. VMI
Wait a
said
minute,
separate housing.
That's begging the very question at issue here. You can have a sex classification based on sex. You just have to have a reason for it and one that matches your exclusion. What you're trying to say is we don't even look at the reason to see if it has a scientific basis.
The reason we don't look at the reason in this case to see whether there's a scientific basis is because no one disputes that there is a scientific basis for separate women's
But
sports.
there is a dispute of that.
I'm sorry. Are you then saying, Mr. Hurst, that there really is no such thing as an as-applied equal protection challenge?
No, Your Honor, but what I am saying is that equal protection, the question is whether the classification is valid and not whether it makes sense in individual situations.
But that sounds to me as though, and I think our precedent is actually very sparse in this area, sort of surprisingly sparse. But it sounds to me as what you're saying is, as long as the classification is facially valid, a person does not get to come in and say that with respect to some subclass, a small subclass in this case, a person doesn't get to say with respect to some subclass, there's a mismatch, that the justification has run out, that the justification doesn't apply. You're saying that that really is just not an available argument.
I agree that is not an available argument, and I think this court has taken that approach, our approach, in cases from Conn v. Chevron all the way to Wynn, and Wynn is the best example because there the petitioner had been raised in the United States by the U.S. citizen father, and the court said Congress's interest in making sure there's a connection with the United States is enough to justify the classification. Well, this petitioner obviously had the connection with the United States. There was no basis to apply these justifications to that petitioner. Didn't matter.
I mean, one thing that this case could be about is, and in this case, I mean generally, this litigation, is whether the plaintiffs are right here that there is a mismatch, right? And some of your briefing addresses that question. Right, you can take all the hormones in the world, you can take all the puberty blockers in the world, you say, and there still will be a competitive advantage. That's one thing that this litigation could be about and one way to resolve this litigation. Another thing that this litigation could be about is this deeper and, as I say, surprisingly unanswered in my mind, equal protection question about what an as-applied equal protection challenge is and whether they exist. And I guess, you're suggesting that we should, well, I don't really know what you're suggesting because here you're saying, look, just do it that way. They could be right on the science and we would still win. A lot of your briefing really contests their view of the science. So which way should we think about this case?
We think that equal protection jurisprudence is about the validity of classifications. It takes a classification to trigger the doctrines to begin with, and then you ask, is the classification justified under intermediate scrutiny? And so that we think that's the right approach. Is the classification justified? Not is it justified in each individual instance, because as Wynn said, this court has never held, Wynn said, that a law has to be capable of achieving its ultimate objective in every instance. And as soon as that possibility of forcing the legislature to justify the law with respect to individual plaintiffs is on the table, intermediate scrutiny is over. That is strict scrutiny.
Can I question the premise that you are putting forward? even if I agree with you that equal protection is about, is this classification justified? I think that begs the question, what is the classification? And so to the extent that you have an individual who says what is happening in this law is that it is treating someone who is transgender, but who does not have, because of the medical interventions and the things that have been done, who does not have the same threat to physical competition and safety and all of the reasons that the state puts forward, that's actually a different class, says this individual. So you're not treating the class the same, and you're not, how do you respond to that? In other words, the as-applied challenge essentially redefines the class, or one could think of it as that. And so what's wrong with that, number one, and how do you square that with our holdings in Caban, which Lair later described in this way? In other words, Lair suggested that Caban was establishing that as-applied challenges of this nature do exist.
Certainly, take the second question first.
Yes.
Caban says nothing about as applied. I know that Lair says later this was an as applied case, but simply reading Caban, it does not say that. It simply applies intermediate.
No, I understand, but those two cases were in juxtaposition with one another,
Yes.
and Lair comes out the way it does, distinguishing Caban on the basis that it's an as-applied challenge, and we in Lair have a facial challenge, and it's basically the same facts. So if you're right, those two cases can't come out the way they do.
I don't think so, Your Honor. Again, Lair was actually briefed as a standing argument of maybe you might be able to argue that this law is overbroad, but you individually are not in the overbroad part, and therefore you don't get to challenge it. The court didn't use standing language, like express standing language in the opinion, but that is the logic of the opinion.
Mr. Hurst?
Yes.
There's another way to think about the case your friends on the other side posit, and that is that transgender status should be conceived of as a discrete and insular class subject to scrutiny, heightened scrutiny in and of itself, given the history of de jure discrimination against transgender individuals in this country over history, in immigration and family law, cross-dressing statutes. They give a long laundry list, and I'd like you to respond to that.
Certainly, on the jury discrimination point specifically, there has been some discrimination against transgender people, significant discrimination against transgender people in the history of this country. The same can be said of many groups. The same could have been said of the mentally disabled in Cleburne, et cetera, et cetera. I think Justice Alito's concurrence in Scarametti is helpful with this in saying this quasi-suspect class or suspect class process, what we're really looking for is classes that look like race or like sex. And if you compare the discrimination in this case, where not one of the laws they cite actually classifies expressly on the basis of transgender status, if we look at that history and we compare it to the history of African Americans and women who were not able to vote, who were not able to own property, who had express classifications based on their status written into the law for most of this country's history, these things don't compare. They're just not alike.
I'm sorry.
No, please.
Okay.
There are two things in that answer that are kind of at odds with one another. You start by saying you don't question that there's a history of discrimination, I assume de jure, in this country. Mm-hmm. And then you say, well, but they don't classify on that basis. How should we think about that?
I think that the famous footnote 4 helps, right? This has been a discrete and insular minority. Has it been a group of people that were recognized as a group where laws were passed on the basis of their membership in that group, demonstrating that they lacked the political power to protect themselves in the political process? This is from Justice Barrett's concurrence, of course. We just don't have any of that here. All they can point to is conduct. It says, no cross-dressing, no drag performances in bars, these kinds of things. As I think our friends on the other side would admit, people cross-dress who aren't transgender. This is not a classification on that basis.
What do you do with the legislative history in this case, where the people who introduced the bill called it a transgender bar? So you in answering Justice Gorsuch, you said there's no evidence of that, but there's certainly a lot of comments in this bill when it was passed.
Your Honor, I respectfully disagree. I am aware of nothing in the legislative record that says that. I know that the Ninth Circuit opinion says that, but if you'll notice, the key quote that the Ninth Circuit relies on puts the words transgender women in brackets. And if you look up that colloquy in the legislative record, in their transcript that they provided in the district court, the word transgender, gender identity, et cetera, do not appear in that section of the transcript.
Can I go back to the mootness question that Justice Thomas talked about, but not addressed here at all? Yes, this respondent made certain allegations about her intent at a certain point, but she signed an affidavit with this court attesting that she has permanently stopped playing sports covered by the ban. She will not try for any school-sponsored women's sports, and in fact, I think she'll finish school very shortly. And there's no reason to question the sincerity of that belief, given that dropping out of sports puts you at a disadvantage where you lose your competitive edge, and she's going to graduate soon. How is this different than Atchison Hotel, where the person in the litigation made representations that she intended to visit and continue visiting hotels in the future? And then when the case got before us, she voluntarily dismissed those suits, like here, with prejudice. And we then directed that the case be considered moot. How is that different?
To begin with,
I add one further difference between the two cases. Here, it's not like she's attempting to avoid us reaching the question. In just a little while, we're going to reach the identical question in another case. So we don't have a subterfuge in attempting to stop the court from reaching an important legal question.
I'll start with Atchison Hotels, Your Honor. In Atchison Hotels, no one disputed that plaintiff's plans going forward. In this case, even the district court does not credit the plaintiff's plans going forward. The district court struck the notice of dismissal and said, Hecox's plans have changed before. Hecox's plans could change again. And also, the court feels that this is somewhat manipulative in order to escape the Supreme Court's jurisdiction. None of that existed in Atchison Hotels, and that puts us in City of Erie territory, where in that case, the premises were sold, the business was closed, the owner was in his 70s, and they said, that's not enough. You could still reopen this business. Your company is still incorporated. Under these circumstances, where it's the respondent seeking through post-certiorari maneuvers to moot the case, that isn't enough. This case isn't moot.
Thank you, Counsel. Justice Thomas.
Does the justification for a classification as you have in Title IX, male, female sports, let's take, for example, an individual male who is not a good athlete, say a lousy tennis player, and does not make the women's and wants to try out for the women's tennis team. And he said, there is no way I'm better than the women's tennis players. How is that different from what you're being required to do here?
It's not all different, Your Honor, and that's exactly what we're concerned about, that their arguments about needing to make exceptions from an otherwise valid classification for people for whom that classification doesn't make sense, those arguments don't limit themselves to people who identify as transgender. Many males could say, I can't really compete with the women's basketball team, and therefore I should be able to try out. And I haven't seen an answer from the other side as to why they couldn't, beyond, I correct myself. They say that, well, those people don't face the same dignitary harm as transgender people. But I don't see how that's relevant to the intermediate scrutiny analysis. The analysis is this classification substantially related to a legitimate state interest? The person's reasons for wanting to violate the classification don't come into the analysis.
Justice Alito.
Justice Sotomayor raised the question whether the issues here are identical to the issues in the case we're going to hear in a couple of minutes, and I'd appreciate your views on that. Suppose we affirm or reverse in this case, in the other case, would that leave something undecided with respect to your case?
Yes, Your Honor. Our case involves the issue of the constitutional definition of sex, which the Ninth Circuit made a decision about what sex means for constitutional purposes. The Fourth Circuit did not make that decision. We will be bound by that decision going forward unless the court reaches that question. That said, I would dispute the premise of the question, because whether or not the court has Article 3 jurisdiction in this case does not depend on what the court might do another day in a different case.
No, that wasn't the premise of the question. It was just an attempt to explore the consequences of deciding the mootness issue one way or the other. Thank you.
Thank you, Your Honor.
There's a Munsingware GVR that's being agreed to here. So you're not bound by anything in this case. And our decision there will inform any new decision in the Ninth Circuit on this issue, correct? Whatever analysis we adopt in the little case will control what happens in a new case.
That is the law, Your Honor, yes.
With respect to the Erie case, there, the 90-year-old man never said he didn't intend to open another business. He just said this business. And that was the distinction we saw. Here, she has said, I don't intend to do this. Now, every other promise that she made in this litigation, that she was going to continue trying out, that she was going to stay in sports, held true until this case and the negative attention she received, correct? To say she misrepresented her intent is going a little extreme when she honored all her previous intents and only changed her mind when new circumstances arose, i.e., the notoriety of this case, correct?
No, Your Honor, nothing changed externally to the plaintiff. The plaintiff's affidavit filed in this court says that there has been negative attention and so forth since the beginning of this case. The only thing that changed is this court granted certiorari. And then after that, the plaintiff said, I want out, and so I will stop playing sports.
Do you dispute that having a case named after you makes your infamy live forever?
No,
you don't think that Brown and any of the other named plaintiffs that we have in famous cases drawn attention to those people as people? Have you studied your law cases? Students do all the time. I think one of my colleagues had a course where they looked at the lives of the plaintiffs. Do you doubt that having a named case with such an eventful event is going to continue attention on this person?
I don't doubt there will be attention, and I confess—
Negative attention.
I confess I have studied a few law cases, but—
have you studied the people?
To some degree, Your Honor. What I would disagree with is there's no background principle of plaintiffs get to leave the litigation whenever they want. Even Rule 41, even in just the district court, the rule is that once the litigation hits a certain point, you can't leave.
What you're going to assume, I know you don't want to, that you were to lose this case, you would say that we have to force an unwilling plaintiff who has offered to dismiss with prejudice, promise not to incur this activity again, we would force that person to continue prosecuting this case.
The court did in City of Erie.
That it did there, but is it the right thing to do? We didn't do it in Atchison.
In Atchison, no one disputed that the case was moot. The only question was which Article 3 question would be decided first. In this case, we dispute the case is moot. We dispute all the facts that this is based on. This is a formidable burden that Hecox bears. That's from Nike, already be Nike, to show that it is absolutely clear that this conduct cannot be reasonably expected to reoccur. We think, as the district court said in its striking order, that based on the changing history here, based on the past conduct, as Scalia mentioned in his footnote 3 of his City of Erie concurrence, there is a reasonable basis to doubt whether Hecox's current plans are the final plans. And as long as there's a reasonable basis not to credit the current plans, Article 3 lets the court hear the case.
Justice Kagan?
Mr. Hurst, I want to take you back to our conversation about whether there's such a thing as applied equal protection challenges. and ask you for two things. The first is I do think that runs counter to a couple of things that we think of as basic principles of constitutional law and maybe equal protection law particularly. In constitutional law, we often say as applied challenges are the preferred mode of constitutional adjudication. Certainly, we have not erected like bars to them in any other area, as far as I understand it. And then in equal protection law, we say all the time things like people need to be treated as individuals and not as just as members of a group. And I'm wondering whether both of those principles don't suggest that any bar on equal protection, as applied equal protection challenges, is just wrong, is off. And then the second thing I want you to do after you do that is assume for me that there is such a thing, and to tell me how, in your view, an as-applied equal protection challenge ought to work in this case.
Certainly, Your Honor. The first answer would be, I recognize those principles that Your Honor is alluding to. The contrary principle would be the very nature of intermediate scrutiny analysis, that it is always possible, if you only have a substantial fit supporting legislation, then it is always possible to find people whom it doesn't fit. And then we're in strict scrutiny.
So I completely take that point, Mr. Hurst. I mean, you're exactly right. And of course, intermediate scrutiny is different from strict scrutiny. It doesn't require the, almost perfection that strict scrutiny does. Completely take the point. But isn't that point really addressed to what we often consider in these areas, which is to facial challenges, right? So when you bring a facial challenge, of course, that's right, that you're allowed to have over-inclusiveness and under-inclusiveness and a lack of a perfect fit, but that the nature of an as-applied challenge is different.
Certainly the court could do that, Your Honor. The court has not done that before, as I think we both agree. And the result of that would be judge-made exceptions to laws anytime judges thought they didn't make sense for particular classes of plaintiffs. And the deference to the legislature that should exist to some degree, even under intermediate scrutiny, would be done away with. It would be gone. And then the administrability justification for many sex-based classifications, including this one, would also be gone because you could no longer administer the classification evenly. You would have to make as many exceptions as courts thought you needed to make. So it's really an institutional competence thing or institutional power thing between courts and legislature.
So you're suggesting to me that the whole thing is just unworkable and we shouldn't, but flip to the second prong of my question, which is suppose we said, where as applied equal protection challenges exist as applied anything challenges do. What would it look like, do you think? What should it look like?
Yeah. I'm not sure what it should look like. I can say what it does look like in this case and why we think there's a problem with it.
So you're not willing to take me on my second path, which is like, let's assume that there is such a thing as this challenge.
Yes. I mean, the most I can say, I doubt this is a satisfactory answer, Your Honor, but the most I can say is that the as-applied nature of a challenge might go to the remedy. The legal analysis still focuses on the classification and the justification for the classification. And once we're talking about individuals, we're not talking about a classification anymore.
Yeah, I mean, that doesn't seem like much of an as-applied challenge, right? You have to prove the exact same thing as you do in a facial challenge, but don't worry because you only get relief as to you. So that's not a true as-applied challenge.
And I'm having trouble coming up with what it could look like because it will always be possible to carve the class down further, right? I mean, so if they say that their class, that their subclass, I guess, subclass of males is males who identify as transgender, then we would come back and say, well, only something like 10% of males who identify as transgender take the testosterone suppression. And then they might say, well, okay, no, the class is just the males who take the testosterone suppression. And then we might come back and say, well, according to the record, according to their own expert, of males who take testosterone suppression, only 1/4 of them are able to achieve the appropriate, able to achieve ordinary levels of testosterone for women. And the other 3/4 would still have an advantage, and therefore we'd be justified 75%, pretty good fit in intermediate scrutiny, and we'd be justified with the law. But then they can just change the class again. They can say, aha, no, our class is males who identify as transgender, who suppress their testosterone, and who suppress their testosterone successfully and are able to get it down to where they don't have a competitive advantage. And at that point, we can say, if you can define the class so precisely, you're going to force the state to to define the class that precisely. It's going to be enormously burdensome for everyone, and the state can never win, because whenever the state points to the fit in the statute, they just redefine their class as only the people who are outside the fit.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
To follow up on something you were talking about, Justice Sotomayor, would your constitutional position be different if the law explicitly stated that transgender women and girls cannot participate in women's and girls' sports?
My answer to that depends on what's in the rest of the law. So I would refer back to Scrimetti and say, it's not a magic words test. The mere presence of the word transgender in the statute is not enough to make it a transgender-based classification.
What would make it?
If the law, either expressly or through its effect, let all males except males who identify as transgender participate in female sports, but made it so that somebody's ability to play in female sports depended on transgender identity.
Assume that the law does not allow males to play in women's and girls' sports, and then explicitly says, a separate provision, transgender women and girls, biological males who identify as female, cannot play in women's and girls' sports. Would your constitutional position be any different in that situation?
No, Your Honor, I think that's Scrimetti. I think that would be a reference to transgender identity, but the law's application would never turn on transgender identity, so it wouldn't be a transgender status.
Even if it says transgender?
The word transgender in the statute might be relevant to a pretext analysis, but it wouldn't be relevant to facial classification if that word did not change how that statute applied in practice.
How many states allow biological males who identify as females, transgender women and girls, to play in women's and girls' sports?
Statutorily, I'm aware of 27 states that take our side and do not permit that, and 23 states that take the other side and do permit it.
And those states who do allow it, is your position that they are violating the Constitution, the Equal Protection Clause rights of biological girls and women by allowing that? Or do you say that's up to each state to decide, and that the Constitution gives discretion to the state whether to allow it or not to allow it?
I have not yet been persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter.
Okay.
Justice Barrett?
I have some questions about the implications of your theory. So how would your theory play out if we're talking about 6-year-olds, where there's no difference between boys and girls in terms of athletic ability, testosterone levels, et cetera? Could you have sex-separated teams then? Or sorry, sex-separated teams by biological sex and not allow trans girls on the...
Certainly, Your Honor. First, I'd like to explain how the statute applies to that situation so I can put my answer in context. There are no 6-year-olds in the state to whom the statute applies because there are no school-sponsored.
That's why it was a hypothetical.
Okay, right. Yes, like it would be the normal intermediate scrutiny analysis. And are we saying it applies only to 6-year-olds or to everybody across the board?
Well, I'm just trying to give you a I mean, yours is driven by testosterone levels and differences in athletic capability. So I'm asking you, what if you try to take that out of the equation and you're just drawing the line based on biological sex and saying that trans girls can't be on the girls' team in an age group that's prepubescent?
The record in this case does not support the notion that males lack an athletic advantage at 6 years old. That's about as early as the science goes from what's in the record. And even at that age, males have about a 5% athletic advantage over girls in most situations. Now, if this is not a level of competition where anybody cares about that, the simple solution is the solution you see in most places, which is you have co-ed sports. You don't divide the teams based on sex, and everybody can play. And Idaho's law does nothing to interfere with that.
And remind me whether Idaho's law, and I guess your answer made me think of this, and I guess this goes to the question of whether the law discriminates on the basis of trans status. Is it true that biological girls, trans boys can play on boys' teams?
Anyone can play on boys' teams, Your Honor.
Anyone can play on boys' teams. Okay. And to this point about medical uncertainty and scientific uncertainty, you were talking about what advantages you might have even that are apart from testosterone levels. Mm-hmm. Your friends on the other side say that, listen, that science is uncertain, and so we need more factual development. It's not really clear how much of an athletic advantage boys and men have if their testosterone levels are below a certain point. How does that play out? Tell me why we don't need more fact-finding, or what is the state's burden in showing what the state of scientific certainty is? Do we have to defer to the state, presumably at some point, if deference is due? the state would have too little scientific evidence to really get that deference? Tell me how to think about that.
The first question would be, are we applying intermediate scrutiny? And we argue that the court shouldn't. But leaving that aside, if the court is applying intermediate scrutiny, then we'd say it's Turner Broadcasting that says the legislature, First Amendment case, applied intermediate scrutiny and said under intermediate scrutiny, the legislature has to draw reasonable inferences from substantial evidence. It does not need to act only on scientific consensus, which is what the district court in this case assumed incorrectly.
Thank you.
Justice Jackson?
So I guess I'm going back to your discussion with Justice Kagan. I'm not sure I understand why you're characterizing the as-applied challenge in practice as the individual coming back and proposing a different classification, as though we're doing an analysis of the classification in the way that you suggest. I thought that the state has a classification that is its general rule. No individuals who identify as female but were sex at birth male can play in women's sports. And that the individual then is merely seeking an exception based on their individual capacity, because the state's general rule is based on fairness and medical science and all of these things. Do I have this, like, they're not proposing an alternative class necessarily. They are just saying that I should be accepted from that general rule on this basis.
We agree that an exception is what they are seeking, Your Honor. And it's an exception based on transgender status, again.
But that's the way the rule used to work, right? I just want to be clear about what we're talking about here.
Sure.
I understood that this law originally was exactly that you basically said no transgender women in girls' sports, but we'll look at your evidence and look at your circumstances and decide whether or not you individually can be included.
So
is that what used to happen?
As a matter of Idaho law, there was no law whatsoever before this.
Is that what was happening on the ground in Idaho law?
That's what NCAA policy permitted from 2010 to 2022. Before 2010, the NCAA policy matched ours. Since 2025, the NCAA policy has matched ours.
Okay. But what I'm asking is, if that's the ask here, not that all transgender women be allowed, but that this particular plaintiff be allowed based on their circumstances, why is that so not administrable or proposing a different classification that we're not going to be able to sustain? I don't understand.
So first as to administrability, Your Honor, making sure that a transgender athlete does not have an unfair advantage would require ongoing testosterone monitoring, because circulating testosterone can fluctuate. That is invasive. That is intrusive.
No, but that's the burden of the person. The person who wants to play, he has to demonstrate to you, to whatever degree of scientific certainty, that they don't have a competitive advantage. Why would you not allow that? I guess I don't understand.
The second answer is that there's nothing in that argument that limits itself to transgender identifying athletes. If this athlete doesn't have an advantage over women and therefore can compete safely, then there are other athletes that could say for different reasons that they don't have an unfair advantage and therefore they could compete safely.
Yes, and I understand that. And there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis of transgender status. The law expressly aims to ensure that transgender women can't play on women's sports teams. So why is that not a classification on the basis of transgender status?
I'd apply Scrimetti again. The question is whether the application of the law turns on transgender status, and it doesn't. It turns on sex. The legislature did not want to exclude transgender people from sports. It wanted to keep women's sports women only and exclude males from women's sports.
No, I understand. But with respect to two individuals, a cis woman and a trans woman, who both want to play on a team that reflects their gender identity, this law operates differently based on their sex, right?
The law does operate differently based on their sex, as Your Honor just said. It does not operate differently based on their transgender identity.
But it treats transgender women different than cis women, doesn't it?
It has a disparate impact because men who identify as transgender have a different reason for wanting to play women's sports than women, than biological females do, right? But if that were enough, then Skermeti would have come out a different way, Gaduli would have come out a different way, other cases would have come out a different way. I'm blanking on the other ones.
All right, finally, let me just ask you about mootness, because it's a little odd, I think, that a defendant would not want a case dismissed. Ordinarily, the defendant is the one who's claiming mootness because they've been sued. So this plaintiff has brought a claim against you, and the claim relates to your policy about college sports. And as I understand, the plaintiff is about to graduate. So wouldn't we have a mootness problem potentially notwithstanding any representations that the plaintiff made?
I don't think so, Your Honor. I'd look to Camreta as the case that tells us the best case for telling us how we analyze mootness in this situation. It's, does the petitioner still have an interest in continuing the litigation?
Only for a few more months. What if this decision doesn't come out until June and she graduates in May?
It's my understanding at this point, I defer to my friends here, it's my understanding at this point that May graduation is not possible.
For this individual?
For this individual, that's correct.
All right, thank you.
Thank you.
Thank you, counsel. Mr. Mupan?
Mr. Chief Justice, and may it please the court. It is undisputed that states may separate their sports teams based on sex in light of the real biological differences between males and females. States may equally apply that valid sex-based rule to biological males who self-identify as female. Denying a special accommodation to trans-identifying individuals does not discriminate on the basis of sex or gender identity or deny equal protection. All of that remains true, even assuming a man could take drugs that eliminate his sex-based physiological advantages. The law is reasonably tailored, regardless of whether it is perfectly tailored as applied to any such tiny subset of men. And states are not required to redefine sex or monitor the testosterone levels of female athletes. In short, male athletes who take performance-altering drugs are not similarly situated to female athletes, and states need not treat them the same. I welcome this court's questions.
Would you elaborate on what you alluded to, and that is that whether or not a state has to, its asserted interest in classifications has to bear out in each individual case? That seems to be what the applied challenges in individual cases would require.
That's right. So intermediate scrutiny requires a substantial relation or a reasonable fit, which is not a perfect fit. And this court has recognized, and I point this court to Edge Broadcasting in particular, it focused on this exact issue of if the law is substantially related in general, can an individual come in and say, well, as applied to me individually, it's not. And the court said, no, we're not going to allow you to do that because that would essentially convert intermediate scrutiny into strict scrutiny on an as-applied basis. Now, I'm not disputing that you can sometimes bring as-applied claims under intermediate scrutiny. So if, for example, you had a law that applied, this sort of law that applied to sports, but also math and also chess, it might be that as applied to math or chess, it was invalid, but it was valid as to sports because for math and chess, at the level of the classification, it's not reasonably tailored. But here, critically, everyone agrees that for sports, for 99% of men, it's reasonably tailored. It's just the 1% of trans-identifying individuals who take drugs and then those drugs are effective. That's a problem. And this court's decision in Michael M. makes clear that that's not a viable as-applied claim. In Michael M., this court upheld a statutory rape law that applied differently to men than women, and the rationale was because women faced a unique risk of pregnancy. But of course, if either the male rapist or the female victim was infertile, there'd be no pregnancy. So on their theory, you could have come in and said, well, I have an as-applied claim that I was infertile, so it was okay to rape the underage girl. And this court not only rejected that, the court said it would be ludicrous to say that you could bring an as-applied claim for prepubescent girls. That's just not the way as-applied scrutiny works in intermediate scrutiny cases. That's equally true, as my friend said, in Wynn. In the court's decision in Wynn, the justification for the law was making sure that the parent knew that they were the parent and had an opportunity to have a relationship with the parent. But Wynn's father knew about the birth, was present with Wynn the whole time, and brought Wynn to the United States. Nevertheless, the court held for the class of men overall, it was reasonably tailored, and they weren't going to focus on the specific facts of Wynn.
You started, Mr. Mupon, by saying that did think that there were as-applied equal protection challenges, and giving an example of, well, if it had also applied to the chess team or something. But that doesn't seem like an as-applied challenge to me. That seems as though there's just a provision of the law that's facially invalid, right? So let's put those kinds of cases aside where you can split the law up and say this part is facially invalid, this part isn't, and focus instead on like real as-applied challenges. Your classification is basically okay, let's posit, because there's a substantial relationship to your goal. Is there ever a time where a person can come in either on behalf of herself or on behalf of a subclass and say, notwithstanding that there is no valid facial challenge here, there is an as-applied challenge, this subclass has to be exempted?
So I don't think this court's cases have ever squarely addressed that. I think if it could be brought, it would have to be a very substantial percentage. So to give you a stylized hypothetical, if you had a law that regulated on the basis of sex, and you could imagine 3 subgroups of males, for subgroup 1 and subgroup 2, each of whom were a third of men, it was reasonably tailored. But for subgroup 3, which was a third of men, it wasn't. Maybe in a circumstance like that, the third subgroup could come in and say, for a third of the applications of this law, it's not reasonably tailored. That's not enough of a substantial fit, at least for us, even if you're going to uphold the law for the other 2/3.
But why does it have to be that many people? Why? I don't understand why that subclass can't make this showing and get the remedy as to them.
Because if it's one person, you're basically converting the law into strict scrutiny.
But you're not. I mean, because what you're doing is you're allowing that individual to get the remedy that we've said in cases like CASA is the only thing that's available, that you can't have this flow to everybody. It's just about this individual and whether or not he's been unconstitutionally treated.
So again, because if the law is reasonably tailored for 99.99999% of people, and you come up with a point fraction of percent and say that that person has a viable claim, that's more than you would ever require under strict scrutiny. I don't know if any.
No, but I mean, well, what's the result of that? If you're making a facial challenge, I understand that you're saying that if the law has such a broad sweep of constitutionality, then we're not going to strike this thing down just because we can identify one person for whom it doesn't apply. But if you are that one person and you can show that this is unconstitutional as applied to you, I guess I don't understand why it matters that it's constitutional as applied to 99.9% of the other people.
Well, because I think you're begging the question when you say it's unconstitutional applied to you. Laws that classify on the basis of sex only need to be reasonably related. And so if it's reasonably related because it's tailored for 99% of people, then it is constitutional even applied to you.
Even as applied to you. So you are saying there is no such thing as an as applied intermediate scrutiny
no,
challenge.
again, if there was one where it was a third of the people, I can maybe understand a claim that the third of people, it's not reasonably related for them, even though it is for 2/3 of the people. I'm just saying that when the numbers get as small as they are here, that claim's not viable. And we know that from this court's cases. Again, Michael M., every infertile man.
No, I understand, but we didn't do that same kind of quantitative analysis in Caban, right? We didn't ask the husband in Caban to figure out where he stood relative to all husbands who were to whom this was applied.
Right. So yeah, let me talk about both Caban and Lair. So Caban is not an as-applied challenge. Caban did not say that there was some set of people for whom that law was valid. The differential treatment
itself. Lair said that about Caban.
So what Lair held was the father in Lair had abandoned the child, And what Lair essentially said is, if the mother had abandoned the child, the mother wouldn't get a veto.
Can I read to you what Lair said about Caban? Discussing Caban, Lair explained, quote, "We have held that these statutes may not constitutionally be applied in that class of cases where the mother and father are in fact similarly situated with regard to their relationship to the child." So Lair is interpreting Caban as an as-applied challenge, isolating a subset of people where there's not actual similarly situated circumstances. And Lair is different. It is a facial challenge. It is in opposition. No?
What that sentence in Lair, the facts of Lair, there was no differential treatment. The father in Lair had abandoned the child, and the court basically rejected his claim because if a mother had abandoned the child, the mother also wouldn't get a veto. So Lair's a case where the plaintiff lost because there was no differential treatment at all. Caban is a case where the plaintiff won because the classification couldn't be justified. The only way those cases would support their position is if either Caban or Lair had said there is some set of cases where the woman gets a veto, but the father doesn't, and that's fine. And neither Caban nor Lair said that. This court has never said in those line of cases that the mother can get a veto, but the father doesn't, and that's perfectly okay. So that's what they're arguing, and neither of those cases support it. You'd also asked about VMI, so if I could just briefly address why VMI doesn't support them either. In VMI, the point was, yes, lots of women wouldn't want to go to VMI, but also lots of men wouldn't want to go to VMI. As to the set of people who were actually burdened by the exclusion, all of the women, the law was not fairly tailored. The argument that Virginia was making VMI was essentially equivalent to the following. If MIT said, most women and frankly, most men can't meet our math and science standards, so we're just not going to allow women to come to MIT at all. Of course, this court would reject that argument. That was the argument that they were making in VMI, that just very few women wanted to attend. But for the set of women who wanted to attend, the law was not properly tailored because there was no justification for excluding them.
Thank you, counsel. Justice Thomas? Justice Alito?
Under Title IX, what does the term sex mean?
We think it's properly interpreted pursuant to its ordinary traditional definition of biological sex. And I think probably given the time it was enacted, reproductive biology is probably the best way of understanding that.
Thank you.
Justice Sotomayor?
The problem I'm having with what you're doing now is you're doing exactly what Justice Stevens said should be done. And he admitted later in O'Connor that the court roundly rejected that in Caban and Lair. He wanted to do exactly what you said. He said, in dissent, this court should be in analyzing equal protection, contending that if the classification is justified in those cases in which the rule has its most frequent applications, then it doesn't violate equal protection. And then he said the court should presume that the law is entirely valid and require the challenger to demonstrate that its unjust applications are sufficiently numerous and serious to render it invalid. It's exactly what you said we should be doing. So you want us to accept what the dissent did and not what the majority said it was doing in Caban or Major. In BMI, Justice Scalia said the same thing, that taking the majority's logic to its logical conclusion, a single woman who wanted to attend could satisfy the admissions requirement would be enough for an as-applied challenge, and that shouldn't be the law. You're asking the court to adopt views expressed by two minority dissenting judges in this case. We've been doing an awful lot of that lately, but you're smiling because it's true, but you're asking us to adopt an approach that we have rejected as a majority court and accept what dissenters are doing, correct?
With all respect, no. Again, in Caban, nowhere in the majority opinion in Caban did they say this law is reasonable for certain classes of men, but it's not reasonable.
It did exactly. It said it's reasonable for fathers who don't support their children. It won't be reasonable for fathers who don't.
With all respect, Your Honor, it did not. Caban did not uphold that law. as applied to any man who hadn't abandoned their child. Now, it is true Lair's upheld the law for someone who had abandoned their child, but the reason it upheld the law is because women who abandoned their child.
But the logic of the opinion is that if the reverse had been true, it would have ruled the way it did.
I don't think that's true,
Counsel,
but even
could
if
I
you
have-
thought that was, sure.
No, I just have one last question. What's percentage enough? There are 2.8 million transgender people in the United States. That's an awfully big figure. I do understand that in Idaho, this was the first transgender child, but that just happenstance as to location. What makes a subclass meaningful to you? Is it 1%, 5%, 30%, 15%? One is not enough for you, but why?
Well, so I'll say.
When the numbers don't talk about the human beings.
So I'll say a couple of things about that, Your Honor. The first I'll say is if the distinction between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit, 1% surely has to be on the side that's reasonable. But if you don't want to just take the 1% on its own face, I would point your court, you want to focus on majority opinions or opinions for the court. Michael M. rejected a challenge, even though that law wouldn't, for infertile couples, either infertile rapists or infertile victims, the justification didn't apply. There are certainly more infertile people.
They did it on a different basis, which had to do with different harms.
No, that's not
to a
true, Your Honor.
previous-
With
Well, I
all
can read the
respect,
decision and tell you.
with all respect, that paragraph, it says, even setting aside the physical differences, it is ludicrous to think we have to exclude infertile children from this rape law. And there are certainly more infertile people than there are trans-identifying individuals who take these drugs and eliminate all their physical advantages. So if we just focus on holdings of this court, we know that this percentage is too small.
Justice Kagan?
Mr. Rubin, just assume with me that there is such a thing as a as-applied equal protection challenge. What would it take to bring that challenge? What should the plaintiff have to show?
I think they would have to show that, A, they are a substantial enough percentage to be able to bring an as-applied claim. And then as to that group, the law wasn't reasonably tailored for them.
And that they would have the burden on that. It's not for the state to come back and say, the state does not have to satisfy that burden initially.
Certainly not the first of the two things I said. I think if you thought that you could have a valid as-applied claim and they had made it through the gate of saying they were a big enough class, then I think consistent with normal intermediate scrutiny, I think the state does bear the burden of showing justification for that class. So I think the state would have it on the second step. The plaintiff would have it on the first step.
I see. So they have to sort of get through the gate of we're big enough for you to take us seriously, but then the state has it.
I think that would be how you would analyze it.
And I think you were asked this, but big enough to be taken seriously? Like, how do we decide that?
You know, again, the court's cases haven't really talked about it. I think the way I would think about it analytically is the difference between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit. So is there enough of a group here that we think that we're not essentially holding the state to perfection? If it's so close to perfection, then you're really undermining the difference between the two. If it's a big enough group that we're not asking for perfection.
I mean, are you really undermining the difference between the two? Because usually we think of the difference between the two with respect to facial challenges. So you have to do a whole lot less to show that the facial classification that you're making is okay.
I don't think so. I do think that you would very much be undermining the difference between the two if you said that even a single person could bring an as-applied intermediate scrutiny case. And again, I would urge your honor to read Edge Broadcasting. There's a whole section of the opinion that's on this exact issue. It says exactly what I'm saying. Now, admittedly, it's a First Amendment case, but it's an intermediate scrutiny First Amendment case.
Thank you.
Justice Gorsuch?
If the class is big enough, in your discussions, say a third, as you discussed, might it just fail intermediate scrutiny facially? I mean, at some point, do they collapse?
So I agree that that's part of why these are so unusual. If there's a big enough group that you've excluded, you're exactly right. It might not be reasonably related as a whole, and so then it facially fails. But I could at least conceptualize a situation where it covers enough people validly that a facial challenge fails, but it covers a big enough group that it can't be justified for, then maybe you could bring an as-applied claim. I don't think this court really needs to grapple with these fairly tricky analytical questions, because this is the world's easiest as-applied claim to reject. It is a fraction of a percent. Whatever as-applied claim you could bring, it cannot possibly be a fraction of the percent. That would be totally inconsistent with this court's decision, Michael M. and Wynn, both of which rejected claims by people who had a much greater percentage than a fraction of a percent.
As you know, a lot of states allow biological males who identify as female, transgender women and girls to play in women's and girls' sports. And you heard Idaho say that the states, those states, other states, constitutionally may allow that, consistent with the Equal Protection Clause. Do you agree with that?
So we've been challenging those laws under Title IX in lower courts, and as we said in our brief, we would urge the court to just reserve judgment.
Can you answer the Equal Protection Clause question that I just asked?
I'm not sure if we've taken a position on the equal protection piece.
Do you have a position?
I don't right now.
Okay, and on Title IX, footnote 2 of your brief seemed to say that you don't have a position on how Title IX applies to those states as well.
No, so we are actively litigating in lower courts, and we are saying that they are violating Title IX. What the footnote said is it's a very different question, and we would urge this court to make clear it's not resolving that question one way or the other by what it says in this case.
Okay, so you have a position on it, but you don't want us to say anything about that issue.
It's a very different question analytically, and so—
I understand, that's why I'm asking.
Yes.
Yeah. Okay, thank you.
Justice Barrett.
So, Mr. Mupan, when Justice Kagan started asking the questions early on about the as-applied equal protection challenges, she pointed out that there was kind of a surprising dearth in the case law really grappling with this. But I think you wouldn't be getting all the questions that you're getting about Caban and Lair and Michael M. and VMI if it weren't the case that you can read some lines of cases either way. So let's say that there is this uncertainty. We haven't really confronted it. As far as I can tell, it's because it just wouldn't be relevant in strict scrutiny because it's often fatal in fact, or typically almost always fatal in fact. So it's really an intermediate scrutiny problem. Maybe it's a rational basis problem too. I mean, maybe this would have implications for all kinds of review. Because it seems to me that if you're never talking, in any case in which scrutiny is not talking about a perfect fit, you might have this problem. What would it do essentially? I'm just trying to think about the ramifications of allowing as-applied challenges. It seems like it's at war with the theory of intermediate scrutiny for some of the reasons that Idaho said, because all lines, all classifications overshoot or undershoot, right? So can you imagine how intermediate scrutiny works? And this is, this isn't designed to be a layup or something. It's honestly just something I'm grappling with. How would it even work going forward?
So I'm not sure I can say a whole lot more than what I've already said, which is I do think it's a problem. The reason I think it's a problem is it's conflating the difference between strict scrutiny and a perfect fit, intermediate scrutiny and a reasonable fit. And I worry that if you allow as-applied claims to a small enough group, you're essentially collapsing the difference because you're essentially requiring a perfect fit. Because whenever you have a reasonable but not perfect fit, the subset who falls within that will come in and bring an as-applied claim. And so the state will essentially have to have perfectly tailored laws because any single person for whom you don't have a perfect fit could come in and bring an as-applied challenge.
Including, say, boys who just couldn't make the team because they weren't good enough, because the law, to the extent that it's designed to protect competitiveness and safety, et cetera, wouldn't pose the same danger in the case of a boy who just isn't good enough to make the male team, but perhaps could make the girl team.
At least arguably, depending on what their exact theory is for the justification.
Thanks.
Justice Jackson?
I guess I'm still struggling to understand why the state would have to have perfectly tailored laws. I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
So making exceptions is tailoring your law. That's literally what it means to tailor.
No, but from the standpoint of a facial challenge, when we're asking whether this law has to be stricken completely because it isn't, perfectly tailored. What we're doing is a different exercise in the as-applied challenge. We're asking whether, even though this law is overbroad, we're assuming it's overbroad now because you've got in there some people to whom it should not be applied. What do we do about that? What is the remedy that those people can get? And what I hear you saying is they get no remedy unless they can demonstrate that there are enough people that this is sufficiently overbroad that it's no longer something the state can do.
Right.
And I don't understand why that is. Why wouldn't, when we identify people for whom this law operates unconstitutionally, that's the premise, because now I'm in remedy, right? The premise is that you have a person who's successfully made an as-applied challenge. This, to me, unconstitutional. You say too bad unless you can show that it's also unconstitutional with respect to a sizable number of other people. And I don't understand why that's the case.
Because I don't agree with the premise that the law operates unconstitutionally as to an individual person just because it doesn't, the justification for the law doesn't apply to that person. That's what this court held in both Wynn and Michael M. It recognized that the justification that was put forward for the law might not be true for each and every person the law applied to, but this court said that's fine.
And if we read Caban and Lair to say something different, if I disagree with you, then we just...
Well, Wynn is the most recent of the cases. So even if you read the cases that way, and Wynn is explicit about this. Wynn explicitly says, I believe it's, I'm not going to get the page number right, but Wynn explicitly says that we recognize that there are some men who were present at the birth of their child, who have a DNA test to prove that they were the father, that have been with their kids their entire life. In fact, that was probably true of Wynn's father. Tough luck.
Okay, so Justice Barrett is worried, I think she said, about the implications of allowing as-applied challenges. I guess I am worried about the implications of not, because as Justice Kagan said, we have consistently said that facial challenges are really hard to get, that as-applied is really all there is. So now we're in a world in which you are setting up new barriers, in my view, to establishing an as-applied challenge. So at the end of the day, is your position that no matter how clear it is that the particular prescription is operating to disadvantage a particular group, classifies you, treats you differently, you're just not going to be able to get a remedy for that individually anymore.
Let me take a step back, and then maybe this will help. Laws that classify in general are subject to rational basis review. Now, there's higher scrutiny for classifications on some things. For race, we have strict scrutiny. For sex, we only have intermediate scrutiny. What that means is it is okay to have a classification that doesn't operate perfectly for each and every person. So it's not the problem is that it's unconstitutional, but there's no remedy. The point is that it is constitutional,
I don't necessarily
even though
think
it's
that's the
overbroad.
takeaway. I think what that means is it's okay because we realize that in some circumstances, maybe even in many circumstances, this classification is justified. But when we can identify a situation in which it's not, I don't understand why a person can't bring that challenge.
Well, I can't say anything better than in both Michael M. and Wynn, the court recognized that there were people who wasn't tailored for and they didn't give them a remedy.
Thank you.
Thank you, counsel. Ms. Hartnett.
Mr. Chief Justice, and may it please the court. Idaho concedes that HB 500 draws a sex-based line by categorically excluding all students with the biological sex of male from women's teams. Sex classifications like that are closely scrutinized under the Equal Protection Clause to ensure they rest on evidence, not supposition. Idaho's articulated justification for this line is to protect women's sports from birth sex males because of their, quote, biological advantages. That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage. This court's cases have recognized that when the government's justification for a sex-based classification does not apply to a discrete subgroup of those classified, that classification is unconstitutional regarding that subgroup. And that holding in Caban, which I'm sure we'll discuss further, has been repeatedly referred to and reaffirmed, including more recently than Nguyen and Morales-Santana. Because the court can affirm based on sex discrimination, it's not necessary to reach the question of transgender status discrimination, but HB 500 also fails on that basis. If the court does not find the case moot, the preliminary injunction should be affirmed. I welcome the court's questions.
Couldn't you make a similar argument with respect to Title IX itself and the sex difference, the permission, the fact that you can have male and female sports?
No, Your Honor. So I think the point would be, the question would be, would the sex line that's drawn in sports, and that's a line that does exist, as a commonplace line, is that substantially related to the important state interest?
Well, you could have individuals who, for example, don't present the problem of physically outmatching women in a particular sport, or a group of people who don't.
Right, and the broader goal here, of course, is not sex separation for its own sake. The idea is to have equality in sports, and that's the ultimate objective that I think we're all talking about, not separation for its own sake.
Well, my point is the argument that you're making now with respect to the subcategory, could it not also be made with respect to the sex separation in Title IX generally?
Occasionally, there have been examples of a boy challenging the separate teams because they want access to a team that's not available for the boys because of the way Title IX works. To be clear, we have not aware of an example of a boy challenging the sex separation so that they can be on the girls' team where there's a boys' team that exists. In that case, the courts do look at that under intermediate scrutiny, and they determine that the overall goal of ensuring equality in sport opportunity for women and men allows for the distinction.
Counsel, I wonder if you could address what has been, I think, the basic focus of the discussion up till now, which is, as I see it anyway, whether or not we should view your position as a challenge to the distinction between boys and girls on the basis of sex, or whether or not you are perfectly comfortable with the distinction between boys and girls. You just want an exception to the biological definition of girls.
Thank you, Your Honor. We're not asking for a particular definition or even really an exception. I think what we're asking for, and it is similar to the nature of the challenge that was brought in Caban. The situation there where there are unmarried fathers that were barred completely from objecting to their child's adoption. And there the father said, we'd like to be able to have that objection. We have a substantial relationship with the children. And in the group, and there was actually a pretty tailored group in that case, in Justice Stevens' dissent, he points out, it has to be an older child and there has to be a participation in the rearing for that subgroup. They were allowed to challenge that and get the relief. And so, I do note too that Justice Stevens pointed out that it was an indeterminately small subgroup of an unknown number of fathers. So I think that's the analogy that we would draw here to what we're asking.
So what would be the appropriate inquiry? And it's asking you basically for your response to Mr. Mupan in particular, that going sort of challenge by challenge, whether it's based on a transgender status or anything else in the situation, is really transforming intermediate scrutiny to strict scrutiny.
We agree there would have to be a group. I don't think, in our view, in a way, at least the way that the cases have worked out, and this is Caban and Lair, it also goes through Nguyen and Morales-Santana. I would also direct the court to the illegitimacy or the non-marital children case. Those are Trimble and Lally. They're cited in the BPJ brief. In the same way, I think the court looks, is there a definable group that's not just a person who happens to not meet the fit, but actually a group where the rationale doesn't make sense for the subgroup. But the group can be somewhat specific. Like in the case of Caban, it was actually unmarried fathers who had acknowledged paternity and had a substantial relationship. In the Trimble case, it was non-marital children who had a confirmation of paternity and a relationship with the father.
Well, that sounds an awful lot like strict scrutiny, unless you're going to say whenever you can come forward with anything that is an exception to the boy-girl distinction, in any case at all, you can go forward with the strict scrutiny challenge, whether it's 1% or whether it's 12 people. And I'm just not quite sure, grasping why your position isn't really an effort to apply strict scrutiny to a distinction that we haven't applied it to.
Thank you, Your Honor. I mean, all I can say, and I do agree the cases are not that many in this context. I think it's possibly because facial challenges were more in vogue before, and now as applied challenges are more preferred. And so that may be explaining why a statute in Caban, for example, wasn't viewed as carving out the statute for the people it couldn't be applied to versus facially invalidating it. But I do think it matters because it's not just a matter of fit that makes intermediate scrutiny different. There also has to be an important government interest, not a compelling one. And this is really critical. You can burden the right in intermediate scrutiny. So in Nguyen, for example, that person failed because he actually didn't take the steps that would be needed to confirm the paternity. So you're allowed to actually, he may have had a compelling case on a one-off basis that, hey, I actually do have that relationship with the citizen father when I was born abroad, but he didn't take the steps that he needed to do. The same thing with Lair, and the same thing with Lally and the Trimble-Lally line. So you can actually burden the right by saying Lindsay Hecox has to actually submit testosterone tests or something else different than other people, and that would not be allowed if it were strict scrutiny.
And if we follow your approach, which allows a challenge to even a fairly small group that's affected, in what way would we not, that would apply across an entire range of things where there's a distinction currently between boys and girls, quite apart from just athletics. Is that correct?
Your Honor, I do think that the question would, I think we're not trying to invent something here. I think we were trying to draw from what we understood to be precedent from the court. And I would direct you to the Equal Protection Scholars Brief. They have some scholars that have actually focused on this question of what does an as-applied challenge mean in the equal protection context. But I think taking a step back, the question always would be looking at what the state's asserted interest is here. And here the state is not asserting an interest of having the boys' teams be better and the girls' teams be worse. What they're trying to do is control for a sex-based biological advantage. And so I think a lot of the hypotheticals that you can maybe understandably think about, what about the untalented cisgender boy? What about the transgender woman who didn't mitigate? You know, what about this or that? That gets taken care of because the testosterone is the advantage on this record. And almost all the people that might want to try to get an as-applied challenge under some other idiosyncratic framework would not be able to show that their exclusion actually was.
Okay, and this will be my last question. My point was more that how we approach the situation of looking at it not as boys versus girls, but whether or not there should be an exception with respect to the definition of girls. That would, if we adopted that, that would have to apply across the board and not simply to the area of athletics.
I mean, I think it's a general framework for equal protection challenge that, again, predated this case, this litigation. There have been boys that have tried these challenges in the past. They generally have failed because they actually don't lack the opportunity or actually are treated, they're not being treated differently than similarly situated individuals.
You said, Ms. Hartnett, that you're not talking about individual by individual by individual. It has to be a defined group. So how big does the group have to be? How does it have to be defined? And why are there those requirements? If what you're saying is right about equal protection law, why wouldn't it extend to individual by individual by individual?
I don't think the court has foreclosed that other than this actual obvious conceptual question of like, when do we get towards strict scrutiny? I think what I could tell you is that in the way that the court looked at it from Caban to Lair to Nguyen to Morales-Santana, and then also Trimble and Lally for the case of non-marital children, the court seems to usually be trying to figure out not just is this individual somehow idiosyncratic, but are they part of a group that actually doesn't make sense to exclude? And that makes sense because usually you're trying to figure out, is the interest served by the exclusion? And there's usually some principle why a subgroup was not properly included.
And what are the requirements? What does that group have to look like? Mr. Mupon suggested that it has to be, fairly sizable. It can't be 1% or less. Why not? Why? What are the other requirements? Like, how do you go about defining which group, which subclasses get to make this challenge and which subclasses don't?
That's a good question, Your Honor. I think in Trimble, this is again the non-marital children case and cited in the BPJ brief, they said discrete categories that were unnecessarily excluded. That was the notion there. So I think that's where we were trying to make clear that we don't think it can just be, we have a person that is extraordinarily idiosyncratic and they should get their case. And I don't think anything in your cases rules that out. I guess that's not actually the case presented here. We think we have an easier case because we actually have identified a discrete subgroup, transgender women who do not have an athletic advantage.
But I don't think you're answering Justice Kagan's question, which is fine. If you buy into you have this subgroup as you've identified it, Mr. Mupon says that subgroup has to be big enough. Do you agree? And if so, how do we evaluate that?
I don't agree with that. I think I think in a way this is the Caban dissent kind of coming back after many decades, because there, Justice Stevens said in the dissent, he's assumed that the case in that case was assuming that the case extended only to himself and by implication to an unknown number of fathers, and went on to say indeterminately small part. So I think there's never been a numerical requirement. It's more of a question of whether there's a principle that, some sort of a principle that allows for the exception in light of the failure to align with the interests that the state's asserting. And here, I think the record, and again, we're at a preliminary injunction stage, but the preliminary record was that the exclusion of our client actually was not going to advance the interest, nor the exclusion of other transgender women who do not, who have taken efforts to mitigate their testosterone, which was on the record here again, was the main driver of differential athletic performance.
Counsel, one might wonder whether the efforts to refashion our equal protection jurisprudence here that we've been discussing at length on sex discrimination is really a fallback from what one might wonder might have been your primary argument, which is that transgender status is itself a discrete and insular class. And I'm curious why you haven't brought that up and what thoughts you want to share with us. Your friend on the other side said the laws you pointed to in your brief don't address transgender persons as such, and that makes all the difference. Thoughts?
Well, thank you for the opportunity to address that. I think we were trying to find the most straightforward way to help the court to an answer here, and I think we do think
I've been wondering what's straightforward after all this discussion.
No, I understand. I think these are older cases, but it's very interesting to see the debate between the majority and Justice Stevens, and Justice Stevens and O'Connor kind of admitting that he was applying his dissent in Caban. So these are cases from the court. We think they have some force. But to the question you've asked, I do think it's important to begin with, you heard my friend on the other side talk about cross-dressing or other laws. They didn't have any response to our point, because there isn't one, that transgender people were categorically excluded from immigration to this country under an overall umbrella of being a psychopath. That was the actual decision of this court in the Boutelier case. It was interpreting language of Congress that determined that when Congress used the term psychopathic personality to exclude people, they meant to include homosexuals and other sex perverts.
Perhaps not our finest hour.
Well, it's not your fault, but I think that.
Thank you for that.
No. Well, it was by reference to a congressional report. They were trying to figure out what did Congress mean, and there actually was a public health service report. I would direct your attention to it because I think it really does go to the level. I was surprised when I read this document. It's 1952 UScan 1653 at 1701, trying to explain why sex perverts would include homosexuals, transvestites, which was the name of the day for transgender people. The term transgender did not become more common till now. So I think reading Boutelier and reading the UScan that's cited in Boutelier is instructive. I also think that the laws on cross-dressing, I think that's an interesting point, because what that actually means as a practical matter for the transgender person was that they weren't allowed to leave their home as themselves to enjoy all of their civil rights. And I don't think, we don't want to exaggerate it, but we also don't want to understate it. There were major cities in the country, Chicago, others, that actually barred you under subject to criminal penalty for leaving your house in clothes that weren't matching your gender. And people were actually prosecuted under those laws. So again, I appreciate it. And we're not saying you have to have the same history. We're certainly not equating the experience of the transgender community to that of Black Americans or of women. But just as illegitimacy or non-marital children has been recognized as a class that gets closer look, I think we respectfully submit here it would make sense to do so. We appreciate, though, this is a question that the court hasn't recognized a suspect class for a long time. They also haven't shut the door to a suspect class since Cleburne. So I think we prefer, to the extent the court was still finding another path forward, the reason why we tried to help you find a way to answer the question here based on sex discrimination.
Well, to pick up on the issue of discrimination on the basis of transgender status, let me just go to some basics. Do you agree that a school may have separate teams for a category of students classified as boys and a category of students classified as girls?
Yes, Your Honor.
If it does that, then is it not necessary for there to be for equal protection purposes, if that is challenged under the Equal Protection Clause, an understanding of what it means to be a boy or a girl or a man or a woman?
Yes, Your Honor.
And what is that definition for equal protection purposes? What does it mean to be a boy or a girl or a man or a woman?
Sorry, I misunderstood your question. I think that the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state or the government was just understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court. And we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams, and that there's a subset of those birth sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
I think here we just know that we basically know that that they've identified pursuant to their own statute, Lindsay qualifies as a birth sex male, and she's being excluded categorically from the women's teams as the statute. So we're taking the statute's definitions as we find them, and we don't dispute them. We're just trying to figure out, do they create an equal protection problem?
All right, suppose this school that has a boys, let's say, track team and a girls track team. The school has that. And a student who has the genes and the reproductive system of a male and had those at birth and has never taken puberty blockers, never taken female hormones, never had any gender altering or affirming surgery, says, nevertheless, I am a woman. That's who I am. Can the school say, no, you cannot participate on the girls' team?
Sorry, so you're just a birth sex male who has all the advantages of birth sex male hormones, and can the school bar him from the women's team? Yes, they can.
But that person, is that person not a woman in your understanding? If the person says, I sincerely believe I am a woman, I am in fact a woman. Is that person not a woman?
I would respect their self-identity in addressing the person, but in terms of the statute, I think the question is, does that person have a sex-based biological advantage that's going to make it unfair for that person to be part of the women's team? And that's the rationale for the regulation. And so that's the way we would be testing that hypothetical.
Well, the reason I'm asking has to do with discrimination on the basis of transgender status. So what you seem to be saying is, yes, it is permissible for the school to discriminate on the basis of transgender status, because if this person is a trans woman, a trans girl, and is barred from the team, from the girls' team, then that person is being subjected to differential treatment based on transgender status, right?
Well, that would be, then the question would be whether it was, the scrutiny would be satisfied. So from our perspective, that would be a transgender classification. It would get heightened scrutiny, and it may be satisfied here because of the need to have, to curtail unfair athletic advantage. That would be the analysis. We are not pressing in this case the notion, and the case does not require the court to decide whether transgender women who've gone through puberty and have not suppressed their testosterone would be able to play on a men's team. And the record here is a preliminary one where that doesn't present that question for the court.
When this does present a particular factual situation, and we have to decide that case, but looking to the broader issue that a lot of people are interested in, there are an awful lot of female athletes who are strongly opposed to participation by trans athletes in competitions with them. What do you say about them? Are they bigots? Are they deluded in thinking that they are subjected to unfair competition?
No, Your Honor, I would never call anyone that. And I think what we're saying here is that you have to, that's the reason why there is intermediate scrutiny, or even in rational review, you don't legislate based on undifferentiated fears. You base on trying to make a rational response to what is a perceived issue. I think here, although I would take issue with the notion that there was no reference to transgender individuals in the creation of this law, I really would direct the court to JA. Again, this is not about animus. I'm just saying that if you look at JA, pardon me, I need my JA 105 through 112, there are numerous references to from the sponsor of the law saying the way we're going to try to protect women's sports is to not have transgender women play on the women's teams. And that was the fear that they had at the time. Again, that is not an accusation of animus. It's just a question of what was the statute doing? And then we go to the point of, does the statute survive heightened scrutiny? That would be the inquiry.
Do you think that the success of trans athletes in women's sports is proportional to the percentage of trans athletes who participate in women's sports?
I think I would direct your attention to, there's a, I want to make sure I have the right amicus. There's an amicus brief that talks about actually some of there are examples, obviously, of some transgender people that have participated and excelled. They actually are few and far between. You know, we have our client here who tried to make the NCAA team because of the injunction. She was too slow. She played club soccer, club running. She was even an officer in one of those clubs, just doing what you would hope a college student would do. You'll hear from my colleague about the other case. But I do think that, and there's a brief that in the amicus briefs that will share the examples of showing that's a bit overstated.
Would the analysis be different if they were more successful?
No, I think it would be, to the extent, I mean, we've already covered that transgender people are a meaningful slice of the population, but a small slice. I think the state, if there were a concern of women's sports being fully overrun by an outbreak of a huge new number of transgender people, that might be a different factual situation. In the end of the day, and we understand, there were legislators who were concerned about that. The legislative history makes that clear here, but that wasn't the factual basis before the court. If there were actually a threat to women's participation in women's sports, that could be a different analysis, because obviously the goal of sex equality in sports is a very important goal. We don't take issue with that. We just would say that I think this is an important moment to just take a step back and say, is this law actually responding to a problem in a rational manner, or is it actually overreacting on the presumption that transgender women are categorically going to be strong athletes when that's not the case?
Well, just to put the big picture, and you know this on the table, and let you respond to it, but obviously one of the great successes in America over the last 50 years has been the growth of women and girls sports, and it's inspiring. And there's some states in the federal government and the NCAA and the Olympic Committee. So these are a variety of groups who study this issue, think that allowing transgender women and girls to participate will undermine or reverse that amazing success and will create unfairness, because you said if large numbers, well, for the individual girl who does not make the team or doesn't get on the stand for the medal or doesn't make all league, there's a harm there. And I think we can't sweep that aside. And I think that's what's undergirding some of the concerns, big picture, and there are harms on both sides. So I completely understand that, but I just want to let you respond to that, because that is, the NCAA, the Olympic Committee, a lot of states, federal government, that's a lot of people who are concerned about women's sports and think this raises a big problem. And I just want to make sure you can explain that.
Thank you, Your Honor. And just to be clear, Title IX is a huge triumph, and I'm a veteran of women's sports myself. So I'm glad it exists. It's made a huge difference in our society. That's not what we're talking about here. But I do think to the point of, for the podium question, I think the question is there an unfair biological advantage? That would be the question. So I understand the point. If there is somebody who's coming in with an unfair biological advantage, that would undermine the entire point of separate sports in the first place, which was to allow women to have a place to thrive, to be strong, to win, not to just be the B team. The question in this case is if the person had actually mitigated their sex-based advantage, which maybe interestingly, maybe counterintuitively, actually is more about circulating testosterone after puberty than a lot of the other things we might think are sex-related, then that girl that's come in second to a transgender person that's mitigated actually may just have come in second because the transgender person was similarly situated, but was stronger in that one competition. That's why we are here not proposing a rule of absolute inclusion, but saying that in the case with people like our client who have mitigated, their exclusion doesn't match the statutory interest.
Well, can I ask you a question about analytically in the discrimination on the basis of transgender status? Since trans boys can play on boys' teams, how would we say this discriminates on the basis of transgender status when its effect really only runs towards trans girls and not trans boys.
We understand the point, and I think that might be relevant to a, for example, animus point, right? There were not a complete exclusion of transgender people, there was an exclusion of transgender women. But I think on that piece, this court has never required the whole class to actually be excluded to look at the cases to whether the exclusion of a subclass was.
I'm talking about for triggering intermediate scrutiny if transgender status is a suspect class.
Right, so like Craig B. Bourne, for example, that's the one about the men that couldn't get the 18 to 20-year-olds, right? That wasn't all men, it was a subset of men, and yet the court still viewed that as a sex classification subject to heightened scrutiny. And likewise here, even though it's just transgender women, in our view, that are being barred and not transgender men, that also would trigger heightened scrutiny. And I think there's the Rice v. Cayetano case from 2000. There's other examples of the court making clear that just because a subset of the protected class is being excluded, you still would apply heightened scrutiny.
Another question about the science. So you were talking about circulating testosterone being kind of the marker. Idaho is saying, well, that's not the only indication. There are other, when I asked the question about 6-year-old teens before that, that there are other just kind of genetic hardwired differences, maybe in size, et cetera, that don't have to do with circulating testosterone. Is it your understanding that testosterone is it?
So, and my colleague who will present the argument in the next case is that the record there was more about prepubertal and puberty. I think that the 5% even is not clear whether that's just environmental or biological, actually.
Right.
But I do think, so there are other things that I think, like height, bone size, there have been some other discussions of this. This is an underdeveloped record, by the way. This needs to go back and have a full trial, except that it's moot. But I think the point there is that, no, I'm not trying to make a point on that. I'm not trying to pretend that I'm going to have a trial when we're not. But I think the point is that sometimes counterintuitively, it's like having a larger frame, but not having the muscle and the testosterone to drive it could actually put the person in a worse position. And that's a study that was commissioned by the Olympic Committee. It's footnote 6 of our brief, indicates that actually it could be actually put the transgender woman at a disadvantage if they happen to have larger bones and less testosterone or muscle to drive those bones.
Last question. So below, as I understand it, your client challenged the verification procedures.
Yes.
Except when we were talking about how this might be administered, I understood you to say that it would be by checking testosterone levels, because it would be okay to say to Justice Alito's hypothetical about the cisgender male who has taken no steps and who is now trans to exclude that person. But would that be an invasion? Would that be a violation itself or too invasive to require someone to, and maybe not just once, but maybe to periodic testing to make sure that the circulating testosterone was low enough? Why wouldn't that be invasive?
So that's an ordinary blood work that a transgender person would get. And that's why I think it's of the nature of the minimal burdens, like in Nguyen and the other cases where the court has said intermediate scrutiny applies, and you actually can, if there's minimal things you have to do to make yourself fall in the category that we want to keep protected, we can require that of you. But
didn't you challenge it?
Well, that was different actually, because the 3 things that you'd have to prove under the state's novel verification thing would have to be your genetic, your reproductive anatomy, which would require actually like a pelvic examination or examination of someone's, nude area. It would be chromosomes, which would require chromosomal testing. That's not what we're talking about. Or it would be endogenous testosterone. And the reason why that wasn't a problem is not because of a blood test. It's not invasive. It's because it would have required the transgender person to stop their hormone treatment to get back to an endogenous level to be able to show they're endogenous.
Okay, so the distinction between circulating and endogenous.
Right, the point was that was actually in a way, like, and I'm not trying to cast aspersions, but a kind of a false requirement for transgender people because they aren't on their endogenous testosterone when they're on hormone therapy. They're on a non-endogenous medical treatment.
Thank you, counsel. Justice Thomas? Justice Alito? Sotomayor?
I'd like you to address mootness because you raised it with Justice Barrett. Is this case moot? Could you respond to the other side's positions or arguments as to why it wasn't? And how do you respond to that? Secondly, Justice Barrett did raise earlier, this law applies even to primary schools, correct?
Taking your second question first, yes. I don't think it's in the record whether or not there are any primary schools, whether they sex separate or not, but that is the law.
And so at least as to that subgroup, no one could doubt that primary school children might have the strongest argument that there's no difference in their physical makeup that would cause harm or otherwise create an advantage, correct?
That would be our position, Your Honor. In this case, we had both our client who was at college at the time, and then we had a high school intervener who was worried about being subject to the sex verification. So we didn't really get into the building a record on the
But the point is that the law might be overbroad in many ways.
Certainly, yep.
And there's still, as you noted, Idaho was the first or the second state to pass this law?
It was the first. I mean, these cases come to you
The
because
first.
they're early
And
ones,
the record here was the most underdeveloped, correct?
including because it was a preliminary injunction. There was a substantial amount of expert material in the record that allowed the district court to make appropriate findings, but it was not the level that you build up for a trial.
And both courts said that the record had to be looked at more carefully.
Expressly, they did.
All right, so answer the mootness question.
I mean, Your Honor, all I can say is that we've tried to provide the court with accurate information as soon as it came to pass. In 2024, when we opposed certiorari, our client still was active and intending to play sports. The court granted the case. She was preparing for what she hopes is her final year of college. She was concerned about the increasing hostility and the visibility. I mean, we're here now and that's okay. She understands she brought the case, but that was the basis for her trying to end her sports career. And it isn't contrary to what she said before. She did intend to play sports through college. Her college has taken a long time. She's now sworn she will never play sports that are covered again, and she won't do that even if she happens to somehow win this case. So that is just the truth. But whether the court believes it's moot, that's, we put the facts before you for you to decide.
How about her graduating this year? There was a suggestion she might not.
As you can tell, we have college students have so she is trying her best to get through college. I think at this point, and I'm just basing it on what I know of as to today, she's unlikely to graduate by May, as my friend said, but is hoping to make through summer credits, could graduate in the fall.
Finally, in terms of the sports teams, the Olympic team, that all happened in 2025 after our president directed them to.
We do think that's worth parsing out. Again, there's been a lot of contentions made on both sides that are extra record, but I do think a lot of those things flowed from the executive order. There were some other sports orgs that were doing different things, but I think we have to be careful not to broad brush that because some of it may have been political, some of it may have been scientific, and the record really isn't fully before the court.
Justice Kagan?
Ms. Hartnett, I just want to get your understanding of what constitutional review would look like in this context. So you said it's not individual by individual. You have to come in and say there's a class that's not being treated appropriately. What is that class here?
And thank you, Your Honor. And I would say I don't think the court has ruled out the individual case. I just think we weren't presenting it that way because we were trying to align ourselves with how the court had looked at it. I think we would say we represent the group of people that do not have an athletic advantage, that have mitigated their their biological advantage of being born male.
So who do not have an athletic advantage, I mean, for reasons of taking certain medications or hormones or?
No sex-based biological advantage. So it would encompass both people that had gone through the male puberty and had mitigated. It would also encompass others like that have not yet gone through puberty or that staved off puberty with the puberty blockers.
And as to those people, who has the burden of showing that the justification doesn't fit?
I think I think once we've identified the subclass under intermediate scrutiny, it is the state's burden to show a substantial relationship for that group, and they failed to, and that's how those other cases proceed.
You wouldn't think that because we are talking about an as-applied challenge to a law that's facially everybody concedes legitimate, that the burden should shift to you?
I don't think that's how the cases looked at it when they were assessing. They were kind of assessing whether the state had provided enough to allow the exclusion. For example, in Lair, the state had made an adequate showing to show why the parent in that case was properly excluded.
And how do you think the question of scientific uncertainty should play out in an analysis like this?
Thank you. That's a good question. And I know this was something the court did address in Scrimeti, a rational review case, but citing Carhart, which also talked about that. I think the one thing we definitely want to have is complete findings. So that's why we really were urging to have a full record developed before there were any final judgment of scientific uncertainty. I think the court has not fully grappled with what does scientific uncertainty mean and how does it come into conflict with heightened equal protection scrutiny. But I think we don't need to present that yet because on this record, there was not uncertainty. This person had mitigated, testosterone was the determinant. Maybe on a later record that would come out differently, but I don't think that.
Just play it out a little bit if there were scientific uncertainty.
I mean, if it really were an equipoise, then I think that that is a situation where I think it's still heightened scrutiny. So under heightened equal protection scrutiny, the burden is on the state to justify the law. And if they haven't been able to justify that, that usually fails. If it's really a question of they're at 50-50, do we allow the state some leeway? I don't think that's been answered in the court's cases. Normally, the heightened scrutiny controls, and there's not a deference on top of that in the equal protection context.
Thank you. Justice Gorsuch.
Just to follow up on that, I wonder if that starts to sound like strict scrutiny, because the point of intermediate scrutiny, of course, is some leeway for the state, not a perfect fit, at least in the facial area. But if there's scientific uncertainty about whether puberty blockers and testosterone suppressants completely or mostly or some percentage of the time eliminate all competitive advantage, some competitive advantage. I mean, you've been very careful, I think, and rightly so, to talk about mitigating advantage. But I don't know, does the state have to show that it eliminates advantage and it doesn't eliminate, some percentage of advantage remains in each individual case, or for the group as a whole? I'm struggling to understand your response to Justice Kagan on that score. Maybe I'm inartfully posing the question, but I hope you understand.
I do understand your question. I think the question is at some level, I think the question is where you have science that's developing in real time at some level, what happens, how does that dovetail with trying a state that's trying to regulate and do that? I think what we can say on this record is the categorical exclusion is really not supported, I don't think, by any science. This again was from kindergarten through college. And so there'd be some subgroups at least. And I think there has to be an effort to try to tailor it. I think here the problem was there was a reaction of transgender women, a picture of what that would be, kind of an undifferentiated fear, frankly, from the Cleburne case. And so I think
I appreciate all of that, but it seems to me from my glance at the record, and quite a record it is, that there is a healthy scientific dispute about the efficacy of some of these treatments, and that's understandable. And I'm just wondering, how does that fit with, assume there is some dispute, and I understand the record remains to be developed further, but how does that fit with intermediate versus strict scrutiny?
At the end of the day, it's the state's burden to show a substantial relationship. And I think in the case of something where they're doing their best and have the best evidence some evidence to support what they're doing.
Some evidence, the best evidence, exactly. I mean, that's
a level of evidence that wasn't met here. So the study and the findings, the district court made a really good point. That study had actually been retracted and it didn't pertain to transgender athletes. So in a way, this is not the hardest case. I appreciate it as a hypothetical. I guess what I would just urge in this area that's sensitive, obviously politically, but also as a matter of science, to at least let a record develop in one of these cases that lets you decide, actually, is this
I totally agree
50-50 versus 80-20?
All right, but 50-50, does the government win? Does 70-20 the government win? That's what I'm getting at. I understand the complexity of the record and the difficulty of the science, but if we're going to have individual cases brought, that's the kind of question we're going to ultimately have to answer, not the science question, but the percentage question, if you will.
No, I understand that. VMI does provide some sort of a metric of what we would do there, which was we look to see there were kind of evidentiary debates on both sides of that. But even if you could say that a lot of women may not have ever made the cut, the fact that there were some that did was enough to invalidate the entire policy. So I think there are ways for courts to make those judgments. And I think the court has not yet, encountered a case where heightened scrutiny puts a heavy burden on the state. It's not an insurmountable one like strict scrutiny normally is. And then what happens if it ends up with the evidence being a tie or close to it when we go back to the trial court? I think that would be that would be breaking some new ground, because I don't think there's an equal protection case that decides that issue. Usually the evidence is kind of clear on one side or the other about whether the restriction is justified.
That would remain for us to decide at a later point.
I do think that's the most prudent, but definitely on a record that's more developed, because I think I think in the end of the day, it might end up being a surprise we don't know yet, but I think we have some good evidence that actually at the end of the day, being transgender woman, actually to the extent there are, and you've repressed your testosterone, you're at somewhat of a disadvantage in many ways, because you have, again, this larger frame with weaker muscles and no testosterone.
Thank you.
Justice Kavanaugh?
Just to follow up on Justice Gorsuch's question, a broader frame about the role of this court when there's scientific uncertainty. I mean, there'll be different district courts who do different things, almost certainly in different cases, and in an area of scientific uncertainty where there's strong assertions of equality interests on both sides. And so it's going to come to this court, and we have to decide for the whole country, constitutionalize this. And I guess given that half the states are allowing it, allowing transgender girls and women to participate, about half are not. Why would we, at this point, just the role of this court, jump in and try to constitutionalize a rule for the whole country while there's still, as you say, uncertainty and debate, while there's still strong interest in the other side? And I think one of the themes of your argument's been the more people learn, the more they'll agree with you. At least I've detected that theme in your argument. So why would we get involved at this point, constitutionalize?
I understand the question, Your Honor, and I do think that the Equal Protection Clause's demands have never been viewed as kind of a separate avenue from the legislative process. They can and do often coexist. And here, I think the point is we have two as-applied challenges to early laws. They have their unique cases in their own right. I don't think this court needs to set rules forever on this area. I think the most important thing would be to allow a record to develop, even in areas of controversy. And we look back at what you cited to in Scrimeti, you cited Carhart. There were extensive findings. There also were findings in VMI. There were findings in Craig v. Boren. I'm learning things by reading these cases over again. There were findings in those cases. And so I think that at least before the court decides to either step up fully or to embrace its role here of providing the scrutiny that should be attended to groups when there's a worry that the democratic process isn't actually going to fairly respond to their concerns, I think the point, at least at a minimum, would be get a full record, which we don't have here. That would be my request.
Thank you.
Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal?
Thank you, Mr. Chief Justice. A few points. I heard just a moment ago that there is no real threat to women's sports. We strenuously disagree. We cite your honors to the UN Special Rapporteur's report that says 600 women have lost 890 medals in 29 different sports. That's what we're talking about. It is a real threat. Medical transition does not reliably suppress all male athletic advantages. I'd cite your honors to our record in which our expert, Dr. Brown, shows the experience of one CC Telfer, an elite track athlete who underwent a medical transition and whose track times did not change. That is the story in many situations. And unless we can reliably distinguish between those situations and the situations in which testosterone suppression does reliably eliminate the advantage, then we can't do that. We need a broader classification, and sex is the right one. And if it were merely politically motivated, I would add we wouldn't see this same rule being implemented by World Athletics, World Boxing, the NAIA, these different groups that were not influenced by recent politics, but came to these decisions after studies, after lengthy examination, and reached the same decision that Idaho has. Justice Gorsuch, in your colloquy with Respondents' Counsel, she agreed with us that this is not the same as the discrimination that has been faced on the basis of race or on the basis of sex in this country. We agree it's not close to the discrimination that people have faced on the basis of race or sex in this country. That said, the court does not need to reach that answer here, because if there is no transgender status classification in Scrimeti, there certainly cannot be one in this case. In fact, as our briefs argue, the court can and should avoid all of these questions by applying rational basis review. Bottom line, sports are assigned by sex because sex is what matters in sports. It is the fairest and the safest and the most administrable way to assign sports teams. It's been widely accepted for many decades because it's necessary for fair competition, because where sports are concerned, men and women are obviously not the same. If Idaho can't enforce a sex-based line here in sports where nobody disputes that biological differences matter, then no line based on biological sex can survive constitutional scrutiny. The court should uphold the Fairness in Women's Sports Act and reverse.
Thank you, counsel. The case is submitted.
Ladies and gentlemen, you are staying for the second case. Please remain in your seat.
Argument next in case 2443, West Virginia versus BPJ. Mr. Williams?
Mr. Chief Justice, and may it please the court. States have long assigned students to sports teams by sex. West Virginia is no different. Maintaining separate boys and girls sports teams ensures that girls can safely and fairly compete in school sports. The question today is whether this enduring structure can continue. It can. Title IX permits sex-separated teams. It does so because biological sex matters in athletics in ways both obvious and undeniable. The text, history, context, and structure of the statute, alongside regulations expressly authorizing what West Virginia has done, confirm as much. Respondent says that West Virginia schools can no longer designate teams by looking to biological sex. Instead, schools must place students on sports teams based on their self-identified gender. But that idea turns Title IX, a law Congress passed to protect educational opportunities for girls, into a law that actually denies those opportunities for girls. The court should not embrace that backwards logic. Aside from its problems with Title IX, the decision below constitutionalizes one side's view of a hotly disputed issue. But West Virginia's law does not offend the Equal Protection Clause either. The West Virginia legislature reasonably and rationally defines sex based on biology and acknowledged the physical differences that biology creates. Given those differences, the law satisfies rational basis review. And the state's law satisfies even intermediate scrutiny because it is substantially related to the important governmental interest in ensuring fairness and safety in girls' sports. Respondent attacks the law by searching for a transgender classification that simply isn't there. The law is indifferent to gender identity because sports are indifferent to gender identity. Ultimately, West Virginia's law, like the laws of at least 26 other states, simply preserves the enduring structure on which girls' sports depends. It should be upheld. I welcome the court's questions.
What's your view of with Title IX, how it defined the separated sexes, male and female?
So under Title IX, Your Honor, we would look to the ordinary understanding of sex at the time that Title IX was passed, 1972, and I think also relevant would be 1974 when the Javits Amendment was passed. And at that time, the ordinary understanding of sex was biological sex, consistent with the understanding of sex reflected in West Virginia's statute. I think that's also consistent, frankly, with this court's own understanding of sex and some of its own cases like Frontiera, where it likewise focused on things like reproductive function.
Well, with that definition, how would you square this challenge with the continued existence of Title IX?
So I think this challenge fails under Title IX, and in fact, it amounts to a backdoor attack on Title IX, in the sense that Title IX itself contemplates sex distinctions, and express regulations specifically applying to the context of athletics expressly contemplate the distinctions between sex of male and female sports teams.
In interpreting this definition, would it make a difference, or does it make a difference that this is a spending clause statute?
I think it absolutely does, Your Honor. Obviously, in the spending clause context, as this court has somewhat recently reminded lower courts, it's important for Congress to speak with an even clearer voice because of the contractual nature of the conditions that are imposed. States like West Virginia have to understand exactly the obligations that they're assuming in the context of a spending clause analysis. And so it amounts to effectively a canon of construction that requires that clearer statement in order for the condition to attach.
I would have thought that's an interesting argument, that this is spending clause legislation in Title IX, and Congress has to speak with a particularly clear voice, and whatever it's said here isn't clear enough. You didn't raise that argument. And there's an argument from your friend on the other side that you waived the argument, or forfeited it at least.
Right.
And it sure isn't the lead argument in your brief. Help me out. Why?
So we, of course, start with the plain text of the statute, Your Honor, as this court has told us to do several times.
Yeah, well, I might start with the constitutional authority under which that statute was adopted, counsel.
I think that's equally compelling authority for our understanding of the
equally compelling, the Constitution equal.
Perhaps greater compelling.
I would have
authority.
thought, yeah.
West Virginia, as you know,
why isn't it in your brief?
West Virginia is maybe uniquely a fan of clear statement rules, as Your Honor might know from past cases. But in the spending clause context, I think it is in fact the case that your court has repeatedly stressed that Congress has to speak with that.
I know what we've said. I'm wondering about what you didn't say.
So I think if you're looking at the way that West Virginia has characterized it, certainly we have made that argument and presented that argument to this court. I'd refer you to the topside brief. It's clear and centered under a clear heading. As I think what their suggestion is from the other side is that we didn't clearly enough raise that argument below. We would take issue with that characterization. There was obviously binding contrary authority in the Fourth Circuit. And so I think strategically we decided not to make that the front and center argument because we understood that was dead on arrival in that particular court. But that's not to say that we waived the issue by any means. It's a canon of construction that continues to assist this court in its application of the text of the statute.
But counsel, can I just ask you about this though? Have we ever applied the spending clause's notice requirement outside of the damages context? Because here we're not talking about a situation in which BPG is seeking damages. And I thought that was sort of a crux of the spending clause analysis.
I will concede, Your Honor, that many of the cases that talk about this rise in the context of, or maybe even all of the cases
yes,
rise in the
thank you.
context. I'll concede as much, yes, Your Honor. But I don't think the court has ever suggested that the specific request for damages is the reason for its analysis. And I think that actually would be inconsistent.
But we would be having to address that, I guess, and extend it in this context if we were to take a spending clause tack.
I would respectfully disagree, Your Honor. I would say that just because the court hasn't done so before doesn't mean it's an extension per se. I think that what the court has said is that you view the language of these statutes as effectively contractual agreements. And I think that that same sort of contractual logic applies whether you're asking the state to pay out damages or whether you're asking it to take specific action under compulsion of that.
Who is the contract between here? And I thought the regulated party needs to know what it's agreeing to so it can consent. But here the regulated party is the schools and it's the state that's coming in. So I'm just trying to understand how the spending clause analysis works in this context.
So I think the state is certainly one party that does receive federal educational funds, but it's also the many other petitioners that stand before you, including the county school board and the state school board are also petitioners in this case. I think there would certainly be, if anybody were clearly bound by the conditions of Title IX.
So it would map on, I mean, I guess I'm worried that this might actually implicate the question that we didn't resolve in Moyle. And so we'd have to kind of figure that out because it seems like it's a different set of facts than the typical spending clause application.
I think if anything, Your Honor, this is maybe easier than your typical spending clause analysis because you've got everybody from the state all the way down to the local county school board. Anybody and everybody who's involved in this case is a party to this action. In fact, you resolved a petition for cert from the Athletics Commission saying we're not actually a state actor, and the Fourth Circuit saw things quite differently. So I think there's really no concern in this case that you'd have an absent actor problem when it comes to the spending clause analysis. And ultimately, of course, if it's just a canon of construction, if you're looking for a clear statement, then I think it would apply regardless of the particular party who might be in front of you because the statute applies across the board. You know, the regulated party is going to be affected regardless of whether they happen to be in front of you in the given case.
Can I ask you
I'm sorry. I presume that if it's statutory construction, a canon of statutory construction, it's hard to say you can waive that.
It's very hard to say you can waive that, Your Honor. Yes.
Just wanted to ask if, on your understanding of Title IX, you could have separated by sex classrooms in biology or math based on some evidence that you have that say men are better at math and science. What are the limits to your Title IX theory?
So I think your instinct there in part arises from the fact that we're skeptical of any notion that there are inherent differences. So I want to kind of acknowledge the real reality of this.
Well, your whole position in this case depends on there being inherent differences, right?
It does. And I think that that's exactly why discrimination in the Title IX context, where it acknowledges merely inherent biological differences, that's not discrimination, that's a distinction. And I think that's consistent with this court's longstanding understanding of what discrimination means. It looks to differential treatment of similarly situated individuals. So even in a case like North Haven, you're talking about differential treatment of similarly situated individuals. So if we're talking about in an athletic context, you're not addressing similarly situated individuals. And I think, again, the Javits Amendment and the regulations that flowed from the Javits Amendment are a realistic reflection of those meaningful biological
The
differences.
Javits Amendment gives you a reason in the sports context maybe to do it. I'm just wondering whether, your friends on the other side have basically conceded that Title IX allows sex-separated sports teams. So I don't know that we need to really get into that. I'd be a little bit concerned about what the ramifications of that might be. And the Javits Amendment in the context of sports makes a difference anyway. But more broadly, I mean, if a state produced some studies saying, listen, women's presence in, calculus is holding men back because they're so much more capable and they can just move so much more quickly. Seems to me like there'd be some risk on your understanding that that would be okay.
I think, again, realistically, Your Honor, that would almost certainly fail on the lack
Well, how about chess club?
a chess distinction, I think, again, might fail because there's an actual lack of evidence of meaningful physiological differences that are reflected in the existence of the express regulations in the athletics context.
I mean, I think a lot of people would say, if you look at the ranks of chess grandmasters, there are not a whole lot of women there. And, what does that mean?
Well, I think,
I think that there's a sort of intuitive, I think there are a lot of chess grandmasters who would tell you that women just for whatever reason, they're not as good as this.
I think chess is an interestingly closer question. I've come to understand just recently, in fact, that there are sex distinctions.
Well,
in the elite.
you're fighting the hypothetical, and I guess the question really is, okay, Title IX says you can't discriminate on the basis of sex.
Yeah, sure.
I understand what that means. I think I do, right? Can't treat men and women differently. Okay, all right, fine. You're saying, but it matters whether they're similarly situated, and your friends in the government like that line too. Well, there's, I got a lot of evidence that girls perform a lot better in high school than boys. Okay, there's a lot of scientific evidence, whatever, or let's just posit that, all right? Well, so I'm going to have a special remedial program for boys, and the women can't come. And because they're not similarly situated. Why on earth would Title IX care about that? It says you can't discriminate on the basis of sex in a program or activity of your educational institution.
So I think—
Why put that gloss on it?
And Your Honor, I want to be clear. I think the task for the court today is somewhat easier in part because of the express regulations that they have actually not challenged and that do expressly contemplate exactly what West Virginia has done. So I think your hypothetical, yes, of course, is there, but I think the reality is that Congress and the agency have together kind of addressed this specific question in a way that makes this court's task much easier. But I think the problem maybe with
Maybe another answer, we don't need to rely on this similarly situated argument. Is that what you're trying to tell me, counsel?
I think you could also take that approach, yes, Your Honor. And I think the reality is that that hypothetical addresses a situation that's much closer to the sort of exclusion and the specific context that gave rise to Title IX in the first place. And so I think that the court would be much more legitimately concerned that that would detect the very problem that Congress was trying to head off in passing Title IX in the first place. But I think that really kind of puts the lie to the position that West Virginia is somehow discriminating because it's advancing the very same purpose that Congress itself was trying to advance in enacting Title IX in the first place. I mean, that's why West Virginia somewhat deliberately made its law mirror the exact same language from the express regulations themselves.
I'm afraid I've got one more question. I'm sorry. Please go ahead. No, you're.
I can do both.
No, you can't do both. That's not fair. That's not fair. I mean, even by our standards. You make the argument that on the basis of means solely because of. solely. We have long said that because of means but for, not solely because of. The Rehab Act speaks of solely because of. It seems to me an awful big stretch, counsel, to say that on the basis of imports anything other than but for causation. And, you know, Comcast is against you there. And I just wonder why you put your eggs in that basket.
So 3 answers, Your Honor.
And by the way, isn't the distinction here solely because of sex anyway?
Well, let me take each of those in turn, or I'll try. I don't think that the case turns on the court accepting the idea that it's solely on the basis of sex. So I think you could stop.
That's a sufficient answer right there.
Fair enough.
Thank you. Your turn.
Thank you.
Can you explain the relevance and significance of the Javits Amendment to distinguishing sports from all these other hypotheticals?
So I think the relevance and significance is Your Honors are faced with a unique set of regulations in that Congress was directly and intimately involved in both the instigation of the regulation in 1974 and then sort of—
And in that law referred to the nature of particular sports, right?
It did. So what they said was, we want you, the agency, Hugh, to go ahead and implement Title IX writ large. And it called out one specific problem that I think arose on the floor about whether Title IX applies to intercollegiate athletics, in particular intercollegiate athletics. And I would say—
And that's been extended to high school by the regulations. But
exactly.
But ruling for you on sports does not open the door, in my view, given the Javits Amendment, to the chess club necessarily. That could be separately analyzed, but it doesn't follow from a law that says sports.
That's exactly right. And that's exactly why we were trying to make your job easier, in the sense that we took the language expressly from the regulations and mapped it over under our own statute. So there's really no debate. If it's outside the context of Title IX, it's outside the context of our statute. So at that point, the court's analysis is done. But I think when you have a regulatory scheme where Congress was specifically involved, in fact, undertook a review, then that's exactly the sort of regulation that even in a post-Loper Bright world continues to have importance, because it's longstanding, continuous, contemporaneously issued, all those sorts of check boxes that this court under a Skidmore framework continues to place substantial weight on. So I think that makes the court's task relatively straightforward.
And what about Bostock?
No.
You want to deal with Bostock?
I think— So I guess it depends on the way in which you mean it. Does it deal in Bostock?
Well, if an employer said we're going to fire all the transgender women, that'd be a violation. If a school says we're not going to allow the transgender women to play sports, you say that's not a violation. Both statutes use the term sex. Can you explain?
I think the reason why is, well, to be clear, our statute is very different from a specific choice to say a transgender person shall not participate because of their transgender status. And I think that really is what makes the difference between this case and Bostock. Is Bostock is attacking status-based discrimination, and West Virginia would, I think, be in a much different position if we had just said transgender persons shall not compete. But that's not what West Virginia—
What if it said transgender women and girls shall not compete in women's and girls' sports?
I think, again, that's a much closer question. I think if we're talking about engaging with the actual status—
You think you could lose under Title IX with a statute that said that?
I think Bostock, is, now I understand Your Honor's question. I think Bostock raises an interesting question as to whether that reference to transgender status would in turn implicate the sex status that Title IX is meant to address. But ultimately, I think the court doesn't need to address that, because you can stop at the first step, right? You don't have an actual transgender exclusion that would give rise to that kind of linkage of analysis.
Thank you, counsel. In terms of Bostock, I understand that to say that discrimination on the basis of transgender status is discrimination on the basis of sex. But the question here is whether or not a sex-based classification is necessarily a transgender classification. And I wonder if that is consistent with your understanding.
It's entirely consistent. I would say on the equal protection side in particular, and also in the Title IX context, I think for some of the reasons I just discussed with Justice Kavanaugh, I think the court can stop and say that a sex definition and a reference to biological sex is not the same as a transgender classification. And I think even if we engage in the sort of but-for causation analysis, I think it's as simple as saying, does the result change if you change the gender identity of the individual involved? And the reality is, if you apply the West Virginia statute to someone identifying as a biological boy identifying as a boy, applies in the very same way as a biological boy identifying as a girl.
Justice Thomas? Justice Alito? Justice Sotomayor?
I find it strange that the district court and the court below did find a Title IX violation, but not an equal protection violation, and remanded for the equal protection violation. I'm not sure how it could do that, because it would seem to me that if the evidence is not sufficient to justify finding an equal protection violation, it's not sufficient to find a Title IX violation. Is that correct? At least on the record as it exists now.
Right. And so to be clear, the district court actually ruled for West Virginia on both Title IX.
Right.
And so the Fourth Circuit said, you lose on Title IX and we're not sure about equal protection.
But assume the Fourth Circuit is right.
Right. Well, so in answer to your question, I think that doesn't make sense. And I think the reason why it doesn't make sense is because the Fourth Circuit effectively stripped out what they said is Title IX doesn't leave room for any kind of justification or any kind of analysis of what the reasons might have been for the state's action. And I think respectfully, particularly when you look at the regulations themselves, that actually does contemplate exactly that sort of analysis.
I agree with you on the regulations.
Right.
And so could you not have a Title IX violation, but still have, let's assume, and I know you're going to fight the factual premise.
I'll try to embrace it, Your Honor.
All right, embrace it. All the scientific evidence showed that there's no difference between cisgender girls and trans girls. I know there's a fight about
it. It hurts.
I know it hurts. But assume it. Could you not still have violated? Could we hold that as the regulation stands, the regulation would permit you to discriminate, but the equal protection clause would not?
So let me try to get my head in the framework of assuming. I think the regulation would still allow us under its express terms, right?
I'm assuming,
right.
Yes.
And so you're asking, even assuming our compliance with the regulation, could we still have a potential equal protection problem?
Yes.
In that world, I think we would still be fine under the equal protection analysis, frankly, for some of the reasons that you heard from the solicitor earlier today, where it's because even if you assume the heightened level of scrutiny, let's assume that we're in intermediate scrutiny world, it's still a reasonable fit. It's not a perfect fit.
Then we're back to that.
Exactly. And
Right.
I know we've had a long colloquy about that today, but ultimately I think that's what
I just destroyed that by saying that the science has said there's no difference.
Well,
and we know that's not true. But assuming the science said there was no difference.
Right.
How could you ever say it's reasonable?
So I'm assuming a world in which there's no difference between you're saying testosterone suppressed individuals? Is that?
No,
or you're saying all men and women full stop?
Right.
Oh, okay. Maybe I apologize for misunderstanding the hypo. If we're assuming a world in which there's really no biological difference, full stop, as to men and women, full stop, then I think, right, the legitimate governmental interest falls away. I agree with you.
Justice Kagan? Justice Kavanaugh?
There are, as we've discussed, a bunch of states that allow biological males who identify as female, transgender women and girls to play women and girls sports. We were talking about that with the Solicitor General earlier. On your theory of Title IX,
right,
are those states violating Title IX rights of the biological females?
I think it's a much closer question under Title IX than it is under equal protection. And I think the reason being is that the regulations specifically say
what do you think the answer is under equal protection? I might as well ask that.
So under equal protection, I think we agree with our friends in Idaho that there's enough room for California to make a different determination.
Okay.
I think under Title IX, the reason why it's a closer question is because of the existence of the regs. And the regs start by saying you start with co-ed teams, and then you can move down to sex-separated teams in the context of contact and competitive skill. And it really contemplates a real, genuine sex distinction in that move down B provision.
Mm-hmm.
And then, of course, it pivots. It also has the catch-all where it says, but actually in the contact sports, you can't even, you can't move back in the co-ed world. So I think if a state is moving away from a genuine sex distinction as the regulator contemplated and as Congress ultimately contemplated, then maybe they're kind of, if you think of B as a safe harbor in a sense, they're outside the scope of that safe harbor, and now they're running into the problem in A. So I don't think the court needs to get into any of that.
Right, I agree. I'm just trying to know what's coming.
But I think that it's a closer question at least than the.
Because your theory is that sex is biological sex in Title IX, or is that not your theory?
No, that is, and it's not our theory, Your Honor. It's just it's the ordinary understanding of what sex meant, both in 72 and 74 when the regulations were themselves implemented. So I think we're just trying to be consistent with that.
Thank you.
Thank you.
Justice Barrett. Justice Jackson.
So I guess I'm trying to puzzle through whether or not there is some independent form of discrimination against transgender women that is distinct from the sex separation that Title IX allows. So I appreciate that your argument is that because the regulations permit sex separation and that hasn't been challenged, that should be the end of this inquiry, basically. And I think you get there because you say you're sort of picking up on this idea that maybe this is just about a definition of who is a male or a woman. Is that right?
I think to some degree, but it's also, Your Honor, it's just because we're indifferent to a person's gender identity and applying the law.
But the law actually operates differently, I think, for cisgender women and transgender women. That is, with respect to their desire to play on a team that matches their gender identity, cisgender women can do it, transgender women cannot. And so we do appreciate a distinction, I think, that is being drawn on the basis of your gender status, gender identity status, trans or cis, right?
So, and I want to make sure I understand
Yes.
if we're operating in Title IX world or equal protection world, because I think it might make a difference to the answer. But
okay, let's start with Title IX.
So Title IX, I think the question of, I look at this statute and see a distinction between boy and girl indifferent to gender identity. And I think that.
Right, but I'm testing that proposition, right? You see that distinction and I see it too on the separation of teams level at the beginning.
Right, and I think what I'm hearing is that distinction arises from a difference in effect. And I don't see a disparate impact analysis that's sort of hidden away in Title IX.
But why is that a difference in effect? So it's like a second order discrimination, right? The first order is separating male from female.
Right.
The second order is separating transgender women from cisgender women, right?
Respectfully, I would disagree,
No.
Your Honor. The reason why is just because I think anytime you have a classification, you could divide it into subclassifications. And I don't think that then becomes like the law in the same way applies to brown-haired biological girls and blonde-headed biological
No, I
girls.
understand,
There's
but
not
I don't think you can
classification
get,
based on hair
I'm not sure, and maybe this is switching to the equal protection. I don't think you can get out of the implications of making a classification by setting it up as a definition. As a subclass. And so we've already okayed the classification because it's really all about classification. You can't distinguish in that way, right?
Well, I think what the court said on the equal protection side is you look at the facial classification, and I think here it's effectively unconceded that the facial classification is between boy and girl. And I think at that point, if maybe you have a situation where you think that the classification is somehow a proxy for some sort of secret secondary classification, but I don't.
No,
hear
but
them suggesting
the definition implicates another division. So here's an example. So suppose that we have Title IX exempting, and I think it does this, certain religious institutions from its requirements. And let's say Title IX then went on to define, this is in my hypothetical, religious institutions to include only those institutions that proselytize. Is that a classification problem or a definition problem? I would say it would be a classification problem, and you'd still have to apply all of the heightened scrutiny just because, they're defining religious institutions in a certain way. Similarly here, you have the overarching classification, everybody has to be play on the team that is the same as their sex at birth. But then you have a gender identity definition that is operating within that, meaning a distinction, meaning that for cisgender girls, they can play consistent with their gender identity. For transgender girls, they can't.
So I think that, okay. So as to the part about your ability to pass over from boy to girl. where
Yes.
You can go from one way but not the other. I want to be clear that BPJ is not challenging that specific classification. I think that's important to start with. But I think if anything, that's useful evidence as to the lack of a transgender-based discrimination, because if the legislature were just sort of unsettled by the notion of transgender athletes, I think the answer would have been to then bar them from
No, I
passing over in any
appreciate
way
that.
consistent with their gender.
I appreciate that. I guess I was getting at the, what I understood the Chief Justice to be trying to discuss, which was this notion that this is really just about the definition of we accept that you can separate boys and girls, and we are now looking at the definition of a girl, and we're saying only people who were girl assigned at birth qualify.
And there is authority cited in our brief. This court, I don't think, has ever phrased it quite as in the way of this definitional framing that we're talking about right now. But certainly cases like Jana Rock in the Second Circuit do approach it from this sort of definitional framing. And they say that if you effectively concede that there's an initial ability to draw a classification, then that suffices to satisfy the intermediate scrutiny question. But then past that, the definitional question is evaluated through rational basis review, and that's Jana Rock. I recognize this court has never gone as far as that, but I don't think the court needs to go as far as that, because again, I think the way that you would do the analysis is to start by looking to the face of the statute. And if the face of the statute is engaged in a conceded boy-girl sex classification is conceded to be legitimate, then at that point, you kind of know which world you're operating in.
Thank you.
Thank you.
Thank you, counsel. Mr. Lupan?
Mr. Chief Justice, and may it please the court. So there have been a lot of different arguments made this morning, and so I think it might be helpful to just focus on what I think are the easiest way to resolve both of the claims in this case. On the equal protection claim, it's the arguments we discussed this morning about intermediate scrutiny doesn't work on this as-applied basis. So let me focus for the Title IX claim. I think the simplest way to resolve the Title IX claim in this case is as follows. The regs expressly authorize sex-separated teams. The other side isn't challenging those regs. When those regs use the word sex, they obviously use the word sex to mean biological sex in the reproductive biology sense. That's the ordinary meaning of the term in 1972 and 1974. As a result, whether or not they are right that taking testosterone suppression eliminates any physical advantage doesn't matter, because the regs define separation based on sex, based on biology, not based on circulating testosterone levels. So the difference that their claim that they've eliminated the difference just doesn't matter under the language of the regs, and that's enough to resolve the case.
So your argument, as I understand it, is that they're not similarly situated.
So that's an additional argument you could make, is to say that even if you just focus on the language of the statute says discriminate on the basis of sex. Discrimination, as this court has repeatedly recognized, including in Bostick, means treating one person worse than someone who is similarly situated. And yes, we don't think a man taking performance-altering drugs is similarly situated to a woman, but you don't even have to reach that question, because under the regs, the question is, the regs say you could separate based on sex. Everyone agrees that sex in those regs means biological sex. Therefore, the circulating testosterone levels are just legally irrelevant under the regs.
So why do you say you can separate the sexes? Why are you now taking the position in other cases that if states choose not to separate the sexes in the way you want, that they're violating Title IX?
Well, so again, we think that's a separate question and you should leave it separate. But the argument we're making in those cases is the statute and the regs allow separation based on sex because of the biological differences between men and women. If you purport to separate based on biological sex, but then you allow some biological males to play on the female team, you've undermined the justification for separating in the first place. Because normally you can't separate. If you take, for example, world history class, you can't have world history class for men and women. That's generally prohibited by the statute. The reason you could separate for sex for sports is the biological difference. And if you then undermine that, you undermine the justification for separation.
So we're now back always to the science. Is there really a difference, and a difference for this kind of person? If it's not clear the way you want it to be in terms of separating the sexes, I'm wondering why it's clear for your attempt to force those states who are choosing not to do this? You're now saying you must.
Again, that question is not presented in this case, and for this case, the factual dispute is irrelevant.
Mr. Mupen, do you think that the spending clause should inform our analysis here?
I don't think this court should invoke the spending clause in
Why
this case.
not?
For two reasons. One, we think that the statute and the regs clearly do not permit the claim.
I understand that.
And then the second is how the spending clause applies in the context of Title IX is, I think, a little more complicated than my friend suggested. It's not a clear statement requirement. I think if you look at some of these clear notice cases like Jackson and Geyser, I don't think you would say that those statutes had a clear statement.
It's a clear notice requirement.
Right, but how that applies is a little tricky, and I think in the case—
Why? I mean, your argument is that in 1974 and 1960, sex meant biology, and that there's not clear notice otherwise. Why isn't that the end of it?
Again, so I think the end of it is the statute clearly doesn't permit this claim. I'm just saying that I would be cautious about speaking about how the clear notice requirement applies, because it is not a clear statement requirement.
I understand that. You're not answering my question with
how would, so I guess what I'll
it's
say—
a clear notice requirement at minimum and a voluntary agreement. And sex at the time of the statute meant, as Bostock said, there's a good argument it's biology. And why wouldn't West Virginia be within its rights to say we didn't have clear notice otherwise?
The scope of the clear notice requirement is a tricky question. If you look at this court's cases, I suspect—
What's tricky about that?
I suspect Your Honor would think a lot of the cases where this court has found Title IX to apply, you would think there's not clear notice.
All right.
And so I think it's a tricky issue,
All
and
right.
I think it's a case that should be briefed, and I don't think it's an issue you need to
Okay,
solve in this case.
and then on the statute itself, it speaks of discrimination in program or activity. And in Davis, we explained that requires kind of a look at the whole of the institution, because the definition of program activity is the whole institution. And so that's less individual focused, it seems to me. Thoughts?
Well, I think that's true for the funding, but I don't think that's true in terms of how the discrimination provision works. If you discriminate or exclude in one part of the school, I don't think you could justify that by saying, well, all the rest of the school, we treat everyone fairly. I think those cases you're talking about, as long as you're receiving funding somewhere, the whole school's activities are covered.
Okay. And so it really boils down to the living accommodations provision, which Congress anticipated there would be sex-separated living accommodations being permissible, the Javits Amendment, and then the regulations that are long-standing and then therefore entitled to some serious consideration.
Well, no. So, Your Honor asked why we run the similarly situated argument. Take, for example—
No, don't bring that back up.
Well, locker rooms and showers aren't covered by any of the things you just identified. Not the living facilities provision, not the Javits Amendment. None of those things covered locker rooms and showers. So unless you use a similarly situated requirement, you would have to say that Title IX bans single-sex locker rooms and showers.
Okay, all right. If that's your view, then let's talk about the similarly situated. I guess I have to. What about the hypothetical I posed earlier that when it comes to high school performance, girls are sure a lot better than boys. And so we're only going to have remedial classes for boys and girls aren't free to attend.
So I don't think those differences are based on inherent biological differences.
Well, let's say I've got really good science. I mean, it's all about the science, right? I got the science. You're finding the hypothetical.
I'm not finding the hypothetical, Your Honor. I think what I would say, Your Honor, is that this court has held in cases like VMI that in general, classification based on sex is impermissible because in general, men and women are similarly situated. Where that's not true is for the sorts of real, enduring, obvious differences that this court talked about in cases like VMI, the differences in reproductive biology. I don't think the sort of pseudoscience you're suggesting has been baked.
Well, it's not pseudo, it's good science.
That's pseudoscience to say boys' brain development happens at a different stage than girls' does.
Well, with all respect, I don't think there's any science anywhere that has suggested that these sort of intellectual differences are traceable to biological differences. And I don't think the statute
with
should be read
respect,
to
I don't
cover
think you're a PhD in this stuff. And neither, I know I'm not, but I'm asking to deal with a hypothetical.
And so I guess what I would say about that, Your Honor, is—
I mean, the statute says no discrimination on the basis of sex. And you're saying, it's okay when they're not similarly situated. And I'm giving you, you're worried about locker rooms. Great. I appreciate that. But I'm worried about that math remedial class or the chess club or whatever.
Right. And so look, let me put it this way. The general rule is you have to treat men and women the same. And
I would have thought that's what the statute says.
And I think you have to be very careful about recognizing an exception. And so when you recognize an exception for what's similarly situated, I think you should tether it to the sorts of long recognized differences that would have been recognized at the time the statute was enacted. At the time the statute was enacted, no one would have doubted that it said it didn't require.
Oh, I think at the time the statute was enacted, 1964, there are a lot of people who thought boys are better at certain things than girls at others that we don't believe anymore.
Not based on inherent biological difference.
I think that maybe in 1964 they did.
And if they did, they didn't have any basis for it. Whereas for
I'm giving you a hypothetical where I have the science to prove it, and you're saying it's still not good enough.
I guess if you're asking me a hypothetical where the science existed in 1972 and everyone agreed with it, then it might be a different inquiry. That really is a hypothetical because there wasn't.
Do we have to, I think these are very, very hard questions. I started with the math question before. But do we have to, because of the Javits Amendment, because the other side has conceded that Title IX permits sex-separated sports, can we avoid your whole similarly situated argument that you run? Because I don't really like it that much either.
Absolutely. That's why when I stood up here, the first thing I said was the easiest way out of this case on this claim is to say that the regs permit sex separation. They don't dispute
Save locker rooms and all that.
Right. The only reason I went into it is I was nervous that any sort of suggestion that there isn't a similarly situated requirement could lead to results that I don't think the court would actually stand up to, like locker rooms and showers. And so I think I have no problem if the court doesn't take a position on it.
Okay, and I'll say, I said I don't like the argument. At first blush, I don't like it. I'm not trying to prejudice anyone making that argument later, but I think it opens a huge can of worms that maybe we don't need to get into here because the Javits Amendment and the concessions.
That's right. As long as you don't cut it off the other way, I think that's perfectly fine.
Thank you, counsel. Justice Thomas? Justice Lee? Justice Sotomayor? Justice Kagan?
Mr. Mupon, you talked about you are litigating this case the opposite way among states that do not prohibit trans women and girls from participating in sports teams. Is that correct?
Yes.
So, and you said, and I appreciate this, that we should not address that question. Are there arguments that do suggest what the answer is on that question that we should be careful about? Or do you think that they're really self-contained boxes?
I think they're generally distinct, and what I could confidently say is the argument that I identified at the outset and with Justice Barrett just now, if you just say that the regs mean sex doesn't mean circulating testosterone, and therefore you're not required to allow boys to play on girls' team regardless of their circulating testosterone level, that argument would not influence the outcome of those other cases one way or the other.
Are there any arguments that would influence the outcome one way or the other?
I don't think so. Maybe if you engage in discussion about what the regs meant with respect to things like equal opportunity, that might be the sort of issue where it might have implications for the other case.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
I just want to be crystal clear about that. If we say sex in Title IX is biological sex, and then we get to the next case, the California case or whatever it is, how would California still prevail if we've said that here?
I think the argument the other side would make would be that the regs don't prohibit them from accommodating transgender individuals. Even though the regs permit separation based on sex, they also don't forbid accommodation of transgender individuals. The argument they would make. And they would say it doesn't matter that you're allowing some boys who have a biological advantage to play on the girls.
What's the argument you're currently making in opposition to that?
That the justification for separating on the basis of sex is the biological difference. And so you're undermining the justification for the separation.
Right. And so we start with the separation. I think what you're saying is once you separate boys and girls teams, which everyone does, and it may be even required in my view, to have equal girls teams, then California really doesn't have an argument if we say that sex in Title IX means biological sex, which may be okay. I just want to make sure I know what we're doing.
Look, Your Honor, obviously, we don't think they can argue that, but I'm confident that California would stand up here and say that even if you ruled the way I just urged, they should be able to argue the opposite by saying essentially that they're allowed to accommodate on the basis of gender identity, even though the regs mean sex and sex means biological sex. That's the argument they would make. Whether that argument's right or wrong is for another case, but I don't think if you adopt the argument I'm making here today, their hands are going to be tied.
Okay. And then on this premise that has been conceded, I just want to make sure I understand your view. My understanding is that it's sex-separated sports teams, so long as they're equal opportunity for girls and boys, are perfectly constitutionally permissible. Is that not your understanding?
Yes. Per the arguments in both cases.
I mean, it's conceded, but it's conceded because it's obvious.
Right, because there are obvious biological differences between men and women, and that's why.
Well, the why people may debate, but it's obvious, it's conceded, and so too Title IX, because of the Javits Amendment, at least, even if not Title IX originally.
Well, I would say even without the Javits Amendment, because importantly, the Javits Amendment is only about intercollegiate. So.
And it's been interpreted in the regs, though, to go to high school, and no one's ever challenged that part. That's the part, okay.
Right.
But that also, sex-separated sports teams are perfectly permissible under Title IX, at least with the Javits Amendment, and probably without, correct?
That's right.
And that's conceded, but that's, it's conceded again because everyone accepts that. It has accepted that for a long time, so long as the opportunities for boys and girls, men and women are equal.
That's right. And I think what the other side in this case is trying to do is say, yeah, that's fine, but they're being excluded. And the problem with that is they're not being excluded from participating on the boys' team. They're choosing not to participate on the boys' team. Now, for understandable reasons, given their gender identity, but the state is not excluding them from the boys' team. And Justice Sotomayor, this explains the confusion in the Fourth Circuit's opinion, because I agree with you. It is very strange that the Fourth Circuit.
Okay, we got to go back. Sorry. You can, finish that up.
Yes.
Sorry.
The reason why the Fourth Circuit found that there was a viable Title IX claim, even though they said that there was a factual dispute, is because they bought into this notion that because the transgender boy doesn't want to play on the girls' team, doesn't want to play on the boys' team and can't play on the girls' team, they're excluded. That's true even if they have a physical advantage. And so the court said, we don't care about the physical advantage, it's still a Title IX violation. And that's clearly wrong. That's a misinterpretation of the statute. And the error in it is that they're not being excluded from the boys' team. They're choosing not to participate on the boys' team.
Sorry, one more. Bostock does not control here because, fill in the blank.
Because the law doesn't classify on the basis of transgender status. It classifies on the basis of sex, biological sex. Just like in Scrimeti, the law there classified on the basis of age and medical treatment. Here, the law classifies on the basis of biological sex. The person's gender identity is wholly irrelevant to how the law applies.
Thank you.
Justice Barrett? Justice Jackson?
But they are being prevented from playing on the team that matches their gender identity, correct?
That's the effect. So let me use your example from earlier. You said there is a cisgender woman, she could play on the team she wants.
Right.
There's a boy who identifies as a girl, he can't play on the team he wants. Take that same boy and switch his gender identity, but say he still wanted to play on the girls' team. Say he was a very unathletic boy. He likewise couldn't play on the team. So it's not the gender identity that's keeping him off the girls' team, it's his biological sex. His gender identity is wholly irrelevant to it. Now, I agree with you, there's a very significant disparate impact on transgender individuals by this law because they're the boys who are most likely to want to play.
Have we said that Title IX never covers that kind of disparate impact in terms of its discriminatory effect?
Well, it certainly doesn't cover disparate. First of all, I don't think Title IX covers disparate impact, period, because it uses.
But in terms of its discriminatory effect, I'm just trying to understand it. Is there something to this notion that that differential treatment in effect in this way could be something that Title IX cares about?
I don't think Title IX covers disparate impact even on the basis of sex. That certainly doesn't cover disparate impact on the basis of gender identity.
Okay.
Thank you, counsel. Mr. Block?
Mr. Chief Justice, and may it please the court. BPJ signed up for school sports because she was an 11-year-old girl starting a new middle school, who wanted to meet people, make new friends, and be part of a team. West Virginia argues that to protect these opportunities for cisgender girls, it has to deny them to BPJ. But Title IX and the Equal Protection Clause protect everyone. And if the evidence shows there are no relevant physiological differences between BPJ and other girls, then there's no basis to exclude her. In thinking through the Title IX claim in particular, it's important to distinguish between how Title IX operates as a general matter and how it operates outside the context of athletics. And I'm glad that we're doing that this morning. Instead of focusing on athletics, West Virginia argues more generally that this court's reasoning in Bostock does not apply to Title IX. To distinguish Title VII from Title IX, West Virginia argues that Title IX protects groups instead of individuals and applies only when sex is the sole cause of adverse treatment. That approach takes a wrecking ball to the text of Title IX and the structure of this court's anti-discrimination precedents. It would dilute Title IX's protections for everyone, not just transgender students, and not just in the context of sports. West Virginia's law treats BPJ differently from other girls on the basis of sex, and it treats her worse in a way that harms her. Outside the context of athletics, that's all BPJ would need to establish a Title IX violation. But the Javits Amendment provides extra breathing room for reasonable regulations that take into account sex-based differences in athletics to provide equal athletic opportunity for everyone. West Virginia's exclusion of BPJ does not fall within that framework. Unlike the exclusion of a cisgender boy, excluding BPJ doesn't advance any interest in ensuring overall fairness and safety. And unlike the case of a cisgender boy, excluding BPJ from the girls' teams excludes her from all athletic opportunity while stigmatizing and separating her from her peers. I welcome the court's questions.
Doesn't your claim ultimately depend on the existence of sex-segregated sports?
Yeah, no, I don't think so, Your Honor. I think this is similar to Morales-Santana, where the claim was an equal protection claim.
Well, I mean, let's say there were no Title IX requirement for sex-segregated sports.
Yeah, well, if there were no Title IX requirement, and well, I don't think Title IX requires sex-segregated sports.
Well, permits.
If there were no Title IX and all the sports were co-ed, then she wouldn't be subjected to disparate treatment on the basis of sex. So I think the claim is the discrimination, and it's perfectly possible to.
So doesn't that suggest that you're a subcategory of the sex of the relevant class of female athletes? Isn't that your point?
Yes, well, for the equal protection claim.
Well, but you're not, my point is that you're challenging a category that does not exist in the statute, but is dependent upon the existence of a category in the statute that you're not challenging.
Well, I wouldn't put it that way. I would put it the way as there's a classification that we think is valid as applied to most people, but is invalid as applied to a discrete subset of those people. But I don't think the success of that equal protection claim hinges as an a priori matter on the existence of girls' teams. There are lots of ways to remedy an equal protection violation.
But I think, given the way you phrased it, the question becomes a little different, because what it seems to me you have to establish is the basis for requiring an exception to the classification. You're not challenging the idea of having boys and girls separate sports. You're saying that you cannot exclude transgender girls from the definition of girls. And that's an entirely different question than the equal protection question.
I don't think we're arguing for an exception. I think we're bringing exactly the same argument in Caban. In Caban, the plaintiff wasn't saying this is valid for everyone, but I want an exception from it. In Caban, the plaintiff was saying this is valid for other fathers, but it's not valid as applies to me. So I just think it's an as applied equal protection claim. I understand the court might decide those claims don't exist, but I don't think it's a claim asking for an exception. It's a claim saying it's as applied to them, it's okay, as applied to me, it's not.
Counsel, how do you get to a Title IX violation? I know exactly how you get to an equal protection violation, okay? When if you accept that the regulation does, by its own terms, permit sex-based separate sports, does permit schools to do this. What in Title IX explicitly or even logically says that you have to give transgender
Thank you. I appreciate
girls the same opportunity? Because the regulation said, it's not just the statute, it's the regulation say, you can create separate sex teams.
No, thank you. I take the point. I think there's always been a tension between the underlying text of Title IX, which protects individuals, not groups, and the regulations, which are authorized by the Javits Amendment and have special leeway to make some group-based measurements. But if you look at the rationale for the regulations, Hugh, when it issued the regulations, said that we think that our group-based method, which otherwise would have been completely impermissible for Title IX, adequately protects the rights of individuals. Because if boys and girls as groups are being given equal sets of overall opportunity, then every individual in the group also has a set of equal opportunity to choose from.
Yeah, I think that's the problem. And, you know, you're absolutely right to worry about the wrecking ball, but I think we've kind of taken a wrecking ball to that. There's no solely in the statute, all right? We're talking about individuals, but Javits changed Title IX. And it said, you know, sports are different. And we've got these regulations that have been out there for 50 plus years. And, you know, normally Skidmore kind of comes in there. Forget about the spending clause, I guess. But maybe I'll ask you about that too. Well, why doesn't that make this case very different than Title VII?
Yeah, so I completely agree. The Javits Amendment is what makes this different from Title VII. And I'm very happy with however this decision comes out to have a decision that's focused specifically on the unique context of athletics as opposed to these broad arguments about Bostock applying to Title IX as a general matter. But I guess what I'd say is the regulations still require equal athletic opportunity. It's not a complete exception for sex-separated teams.
But Javits says it can be reasonable.
Yes.
And do you dispute that the Hugh regulation that's been on the books for 50 plus years is reasonable?
I think it is absolutely reasonable as applied to cisgender students. I think that as applied to transgender students, instead of providing them equal overall opportunity, it's a complete exclusion from the program. And so that's our argument, that it's reasonable as applied in the context of cisgender people, but interpreting the regulations to authorize this sort of categorical exclusion that doesn't give BPJ an equal set of opportunities to choose from would be an unreasonable way to implement Title IX.
Gotcha.
It's unreasonable as to all transgender students.
No, I think it's a combination. I think so. A reasonableness test, I think that requires some sort of ends means fit. And I think that exists when it comes to cisgender students. I think what makes BPJ's case differently from a cisgender student is two things. First, she doesn't have any of the physiological distinctions that justify the sex separation in the first place. And second of all, the harm to her is of a material different kind. It's one thing to say, we're not gonna let boys play volleyball because they have all these other sports to choose from. Or we're not gonna let girls play football because they have all these other sports to choose from. It's another thing to say, you don't get any sports.
But in that argument, does it matter whether BPJ has a competitive advantage or not?
Yes, we think it does. And I appreciate the opportunity to clarify that we don't have any objection to vacating the grant of summary judgment in our favor. We did our best to defend the judgment below, but our argument before the Fourth Circuit for summary judgment was that there wasn't a genuine disputed fact about whether she had an advantage. The Fourth Circuit, sua sponte, granted summary judgment to us based on the theory that that fact wasn't material. That's never been our argument in this case.
So your argument depends on depends on her not having a competitive advantage because she's not been through male puberty.
And not just not been through male puberty, but also gone through a female hormonal puberty with all the physiological changes accompanying it.
But that the argument goes away if those facts go away.
Yes, absolutely. Which is at the beginning of the argument, Justice Kagan, you talked about this could be resolved based on a legal principle or based on the facts. And I really do want to make a pitch for the resolving it based on the facts because, look, if they're right about the facts, then we should lose. And the irony is that in order to win summary judgment in this posture, when there's a disputed question of fact below, is they can only win in this posture if we're right about the facts and there aren't any advantages. And I don't think there's any need at this juncture for this court to issue that broad a holding when, according to them, once the evidence comes in below, we're not going to get past summary judgment. I mean,
You're not suggesting that we decide the factual question.
no. I'm suggesting that the case be allowed to be decided on remand on the factual question, which I think, like, this is an important issue. It may affect the whole country, and the court wants to get it right. And I don't think the best way to get it right is to rely on, cherry pick studies or assertions in amicus briefs. I think the way to get it right is to let all the facts they're trying to put in the record actually be put in the record. And then we'll have the facts in front of us and maybe they'll make the issue go away. But I think that's unnecessary to intervene at this instance with a sweeping legal conclusion to something that might actually be a narrow factual dispute.
Counsel, can you explain whether or why your theory would allow a cisgender boy who just couldn't make the boys' team? I mean, he doesn't have an equal opportunity. He can't play. There's no team he can play on. And let's say that his athletic ability can be shown that he has no competitive advantage and he wants to be on the girls' team. Why can't he on your theory?
I appreciate the question. I think I just want to be clear about what we think the justification for the separate teams is. We don't think the boys' team is for better athletes and you have a backup team for athletes that aren't as good. I think the purpose of the teams is to control for the variable of sex-based advantages so that talented women athletes have all the same opportunities as talented male athletes. But also, untalented male athletes should be compared to untalented women athletes. So they're not being separated based on how good you are, right? The whole point is to allow female athletes to have all the same opportunities as men by controlling for the sex-based differential that comes through puberty. And so that's why I don't think that the claim is the same there. I think that's what's happened here is by virtue of her medical care, BPJ has already effectively controlled for those sex-based advantages. And so she is completely in the position that she would have been if her birth assigned sex had been female. As opposed to a cisgender boy who's just not very good at sports. And if his birth assigned sex were female, maybe he'd be even worse. I don't know. But again, the purpose is to control for the variable of sex to provide equality, not to have a good team and a team for people that can't cut it. Now, I'm happy to address.
Can I ask a question on the law, on Title IX? I mean, I hate that a kid who wants to play sports might not be able to play sports. Hate that. But it's kind of a zero-sum game for a lot of teams. And someone who tries out and makes it, who is a transgender girl, will bump from the starting lineup, from playing time, from the team, from the all-league, and those things matter to people big time, will bump someone else. And so one way to resolve that, as you say, is the facts, try to figure out, is there really a competitive advantage? I think we're going to get a lot of scientific uncertainty about that, a lot of debate about that, a lot of different district courts. The other way on the law, one way on the law is, okay, well, sex in Title IX and in Javits meant biological sex, and it's up to Congress to adjust that going forward if they want, given, as you say, and your co-counsel said earlier, people are learning more about this and maybe there really is no advantage. Well, if that's true, and some states are operating under that basis, that's the way to go. But for now, at least the law says biological sex. And I think we have to recognize on both sides the zero sum. It's not like, just to add another person to the team. That's not how sports works. It's someone else is going to get disadvantaged. So I just want you to address that.
I'm happy to, and I guess I have three answers. The first is I completely understand that many parts of sports are zero sum, but This law isn't limited to zero-sum opportunities. So BPJ played on the cross-country team where there were no cuts. She came in near the back. It wasn't
But I'm sorry to interrupt, but you wouldn't have a different rule if she was finishing in the top 5.
No, but it wasn't a zero-sum.
Or if they had cuts.
But what I'm saying is
In this particular case, but usually with teams, I don't mean to, just don't want to get out of that. Usually with teams, they're cuts.
Yes.
Those mean a lot to people. There's starting lineups. Those mean a lot to people. There's who gets a college recruit. That means a lot to people.
Yes. I just want to say that there still are some areas where there are win-win solutions. I think even being able to be on practices with a team consistent with your gender identity instead of your sex assigned at birth can be enormously important. So I think some scenarios are zero-sum, but not everything having to do with sports is. And I do think that one of the vices of this law is that it sweeps so broadly that even win-win solutions are taken off the table. In terms of aspects where it's zero-sum, no one likes to lose, and no one likes to not make the team. And people often don't make the team. The cisgender girls don't make the team when competing against other cisgender girls all the time. And the question, I think, is whether it's an unfair advantage to not make the team because a transgender girl participated. And if there is no sex-based biological distinction there, then I think it's an unfortunate situation, but I think it's the unfortunate situation that comes with having a zero-sum game, not inherent unfairness. Then the third thing is, I think however the court resolves this case, I really urge the court not to do it based on a definition of sex argument. We are not disputing in this case that West Virginia can have its definition of sex. Our argument is it's using this definition to inflict discrimination and deny equal athletic opportunity, but we are not saying their definition of sex is wrong. However, I don't think it follows that Title IX created some national definition of sex that preempted states' ability to say, actually, we are most concerned about discrimination that happens through gender roles.
Can I ask you something? That's a very important point here, I think, for what happens in the future, what you just said. Do you think sex in Title IX can reasonably be interpreted to allow different states to take different understandings of that in their sports leagues?
I do, because I don't.
Why is that? That's real important, I think, going forward.
Right. Because I don't think the purpose of Title IX is to have an accurate definition of sex. I think the purpose is to make sure that sex isn't being used to discriminate by denying opportunities. Just as I don't think we need to define race in order to enforce Title VI. So I think I wouldn't look to whether or not it's accurate to classify, BPJ as male or female. I think the question is she being denied an opportunity because of that classification? But obviously sex can mean more than just
So if we didn't want to prevent a different state from making a different choice from West Virginia, what should we not say, or what should we say to prevent that from happening?
Well, I wrote down the answer to that when you asked Mr. Mupin. I have two things. I wrote, don't give definition of sex. And I also said I wouldn't decide this by assuming that Title IX provides a right to single-sex teams. In the regulations, single-sex teams are optional, they're not mandatory, and in addition to that, we're talking about the regulations, but on the ground, the way this plays out in practice is you have a 1979 policy statement, a sub-regulatory document that has a complicated test for determining when a sex-separated team is or is not required. And so I think that both because I think saying there's a right to a sex-separated team would predetermine some of the questions in that other case. That's one reason why I don't think you should do that. But second, I think the more the court gets into questions that are handled in these complex regulatory documents, I think the more I'd be worried about this court accidentally saying something about how Title IX works that doesn't actually map on to how it is actually playing out on the ground.
Title IX prohibits discrimination on the basis of sex. It's a statutory term. It must mean something. You're arguing that here there's discrimination on the basis of sex. And how can we decide that question without knowing what sex means in Title IX. I mean, it could mean biological sex, it could mean gender identity, it could mean whatever a state wants to define it to mean, but it has to mean something. How can we decide that without knowing what the statutory term means?
Well, I think there are a whole range of sex-based characteristics that can give rise to discrimination. I think if someone said, I'm going to discriminate against anyone who acts in a feminine manner, like anyone with limp wrists, I don't care who they are, but I'm going to discriminate against them. Like, I think that would be sex discrimination. It would be sort of gender presentation. But I wouldn't say that's not covered by Title IX. And so I'm not saying that biological differences aren't part of sex, but I'm saying that sex also has broader connotations, and there's no reason to keep that out of the statute. And I'm certainly not saying that sex means gender identity. I just want to be very clear about that. I don't think that, just as I would say this, our argument is that there's a group of people who are assigned male at birth, for whom being placed on the boys' team is harmful, right? We happen to have a word for those people. It is transgender girls. But I don't think that means that we're elevating gender identity to be the new definition of sex. Just as in Phillips versus Martin Marietta, there's a subset of women, who are harmed by the policy. Not all women, but there's a subset of women who had young children. And there's a name for them, it's mothers. But that doesn't mean that we're replacing the word sex with mothers. I think
How do you respond to or deal with the other side's characterization of that harm as just the disparate impact of this regulation? That really, it's not discrimination, I think they're saying, but it is just the downstream effect of the application of the classification that the Javits Amendment allows, and that's just the way it goes.
Yeah, so I guess I would say this. I think this court has dealt with the issue of things like constructive denials and constructive discharges in a variety of contexts. And under Title IX, an outright denial isn't required. Davis says a constructive denial it also counts. And whenever there's a question of constructive denials, the court applies a standard that's reasonable person in the plaintiff's position under all the circumstances. And they use that for constructive denials. You've used that for retaliation claims. And if you look at Burlington versus White, I think it's very on point here, because one of the points that Burlington versus White said is that there's some actions that aren't going to be harmful to most people, but they might be harmful to some people. So Burlington versus White used a mother with young children might find a change in her work schedule to be incredibly harmful, right? That doesn't mean that, we're arguing that, this is a disparate impact classification on people who have young children. It's a sex classification. The sex classification is just harming some people and not harming other people. So that's how we would view it. I think this is a facial sex classification any way you cut it. And
I'm sorry, you don't think we should have an operating definition of sex in Title IX? Now, I understand the idea that the question then becomes not whether or not there's discrimination on the basis of sex, but whether there's discrimination on the basis of whatever characteristic you think should be included in the definition of sex. Now, when it's used as a statutory term, I'm not sure you have that kind of flexibility. The question then would be instead, what does Congress think the word means?
Well, Your Honor, I guess I'd say I think Congress prohibited discrimination based on sex.
I'm sorry, go ahead.
Yeah, and so I don't think that, just as I don't think Congress adopted a definition of race, in Title VI in order to prohibit discrimination on the basis of race. I think I'm not trying to police the accuracy of the terminology that's being used. All I'm saying is that what's being prohibited is using this classification to discriminate, not.
So but without really knowing what the distinction is.
Well, I don't think the examples I've given about sex-based characteristics fall outside the common understanding of things that are related to sex.
Well, related to sex, I guess what you're saying is, and we do have to accept for your position that we're not dealing when Congress says sex, we're not dealing with biological sex. but we're dealing with other characteristics that people might associate with sex?
No, no, no. I think for this case, you can accept for the sake of this case that we're talking about what they've termed to be biological sex. I think that resolves this case. I was just talking about in addressing other potential cases.
So we don't have to say anything about the matter. You're willing for us to proceed on that assumption.
Exactly. Just like in Bostock, I think you can proceed for argument's sake without taking a definitive position here, because it might have downstream consequences in other cases that even the United States doesn't want the court to prejudge here. Now, I would like to say one quick thing on Justice Barrett's reference to separate classrooms. I mean, it is true, and the ACLU's litigated cases about theories that there's different brain sexes for women versus boys, and that's why you need separate classrooms. I think the instinct was completely correct that you can have a lot of scientific justifications for discrimination. That doesn't mean that the discrimination is allowed or immune from scrutiny. And in fact, some of the studies that are cited in the amicus brief say boys are naturally more aggressive, right? And favor competition more because that's in their DNA. So I do think even in these studies, the idea that you're completely, just basing it on pure biology and not on other generalizations doesn't quite hold up. I'd also, to the extent that we want to go back to Caban, I do want to just make a couple quick things clear. Caban was not a facial challenge. It wasn't. And neither was, some of the First Amendment cases they were talking about weren't equal protection First Amendment cases. They were commercial speech cases. Michael M. also wasn't a facial challenge. He wasn't saying I should have an exception because a prepubertal girl was involved. He was saying the statute is overbroad because in theory it could apply to a prepubertal girl. So I do think that some of the characterization of the cases doesn't hold up to our reading of them.
So how does a Caban type as applied intermediate scrutiny analysis work in your view? It is an underdeveloped area of the law. Is it enough for one person to show that she bucks the trend or not?
Yeah, I don't think so. I think I agree with my co-counsel that I think we're talking about a discrete, definable group that will reliably not serve the government's interest. And I don't think Nguyen is a counterpoint to that, because the whole point in Nguyen was that men who were not similarly situated had an opportunity to demonstrate that. There are three very easy methods of transmitting citizenship. And Nguyen emphasized that in order to do it, those were minimal burdens. And that is the key fact in Nguyen that distinguishes it from this case. This is a categorical ban, and Nguyen and Caban and all the court's cases distinguish between categorical bans and more narrow procedural requirements that do treat men and women differently, but still provide the opportunity for demonstrating that you're not similarly situated.
I think a hard question that Ms. Hartnett got, maybe the hardest question on these lines, was if we recognize these sorts of as-applied challenges, doesn't that effectively turn intermediate scrutiny into strict scrutiny? Right. What would your answer be to that? Would it be any different, or
no,
do you want to elaborate?
I think the answer is it absolutely wouldn't. You still are only looking for a substantial relationship, which means that you can have these sorts of requirements where there are a lot of under Caban and under Lair. There's still a lot of fathers that are out of luck that they actually probably do have a good relationship with their kid, but they didn't fill out the right paperwork. They didn't do this, they didn't do that. And heightened scrutiny doesn't require that they be excused from those procedural burdens. So I do think that heightened scrutiny allows you to have procedural requirements that people have to go through, and those can be enforced. Strict scrutiny does not allow that. But that's different from saying that if the complete rationale for a classification just doesn't apply to you, that there's no equal protection claim you can bring. And some of it's complicated to talk about the difference between facial and as applied post-CASA, because I think a lot of the things that we called facial challenges now would be viewed as overbreadth challenges, right? Where someone is trying to say the law is so overbroad in general, it has to all be struck down. And we have that for First Amendment. I don't think we have that anymore for most equal protection claims. And so I think taking this facial as applied framework from before CASA, where we allowed these facial attacks on statutes, and then just transporting it into as applied cases post CASA doesn't necessarily work. I think some of the terminology might need to be rethought. And so, again, that's another reason why there's not a lot of precedent in this area, as several of you all have acknowledged. And that's another reason why I don't think this should be the case that makes that precedent when it's unnecessary to do so.
Thank you, counsel. Justice Thomas, Justice Alito, Justice Sotomayor.
Would you address a little bit the quantum of certainty or uncertainty that would have to exist in the science? Your co-counsel or the counsel in the other case said that if it's 50%, the state loses. But I'm always hesitant about these percentage cases because it's never qualitative. It's never quantitative, it's qualitative. So what do you think the qualitative standard is?
Well, I mean, to be clear, I don't actually think there's uncertainty in the case of someone who's had puberty blockers and then gender affirming hormones. Our position is there's zero uncertainty. It's actually clearly in our favor. So but in general, I think it's hard to give, a quantitative answer to that. I think part of heightened scrutiny involves taking all of these factors into account. This court, has said on several occasions that heightened scrutiny can accommodate deference. And I honestly think it's a case-by-case decision that also looks at how harmful the classification is, how burdensome it is. I don't think you just look at the accuracy of the classification and add a number value for how certain we are that it's accurate. I think many other factors come into play.
Justice Kagan? Yep. Justice Gorsuch? Justice Jackson? Thank you, counsel. Rebuttal, Mr. Williams.
I think you've now heard respondent abandon the Fourth Circuit's logic on Title IX, and I think in many ways that makes this court's task that much easier. Congress authorized regulations allowing sex-separated athletics. West Virginia's definition of sex tracks the ordinary meaning in 1972 and 1974 and the regulatory framework that Congress endorsed. I think, Mr. Chief Justice, your question really highlighted how BPJ's approach unmoors the statute and the regulation under Title IX on the basis of sex. BPJ's test in turn begins to look more towards other characteristics that aren't on the basis of biological sex. And I think that's not consistent with what we see there. I also think the answer to Justice Barrett's question reflected how under BPJ's theory, this really isn't about competitive advantage, that really what this does turn on is gender identity, because BPJ continues to maintain that a cisgender boy who continues to not have those same biological advantages would nevertheless still be kept off of the girls' sports team. So if you endorse that philosophy, that would require the court to hold that longstanding Title IX athletic regulations are unlawful. It would eliminate sex-separated athletics entirely, and I think it would defeat Title IX's core purpose of ensuring equal athletic opportunity for both sexes. On the equal protection side of the house, the question is whether the classification is substantially related to an important governmental interest. And I think that BPJ ultimately wants to rewrite the classification to be something that it is not. Biological sex substantially relates to athletic performance. That's exactly why, in fact, Title IX regulations authorize sex-separated teams in the first place. Respondent's test effectively ratchets up the intermediate scrutiny standard into a perfect fit, best disposition case that this court has repeatedly said is not the standard under intermediate scrutiny cases. That is the standard for strict scrutiny cases. You have heard it several times today. Justice Sotomayor, you asked about deference. I think this court has also repeatedly recognized that in areas of evolving science and medicine, especially involving children, legislatures have the primary responsibility for weighing competing evidence and making the policy judgments. I think the court just recently said that in Scrimeti, but I certainly don't think that case stands alone in recognizing that, especially when you have competing balances of harms, Justice Kavanaugh, when you're weighing these sorts of zero-sum games, that's a choice, that's a policy judgment that ultimately rests in the hands of the legislature. In the end, this court has, quote, recognized physical differences between men and women. They are enduring, and inherent differences between men and women are cause for celebration. That is all that West Virginia's law does here. It should be upheld. Thank you.
Thank you, counsel. The case is submitted. We will hear argument this morning in case 25332, Trump versus Slaughter. General Sauer.
Mr. Chief Justice, and may it please the court. In SELA law, this court held that the president's power to remove and thus supervise those who wield executive power on his behalf follows from the text of Article 2, was settled by the first Congress, and has been confirmed by precedent, including at least 9 decisions of this court from Ex parte Hennon through Trump against United States. Humphrey's executor stands as an indefensible outlier from that line of authority. It's holding that federal agencies can exercise quasi-legislative and quasi-judicial powers that form no part of the executive power has not withstood the test of time. That holding was gutted and refurbished in Morrison, but this court correctly rejected the refurbished version as providing an amorphous test with no limiting principle. Respondent now proposes a third update to Humphreys, which this court has already rejected as making no logical or constitutional sense. Humphreys must be overruled. It has become a decaying husk with bold and particularly dangerous pretensions. It was grievously wrong when decided, and cases from Morrison to Trump have thoroughly eroded its foundations. The court has repudiated Humphrey's reasoning and confined it to its facts, but it continues to generate confusion in the lower courts, and it continues to tempt Congress to erect, at the heart of our government, a headless fourth branch, insulated from political accountability and democratic control. As Justice Thomas wrote in SELA law, Humphreys poses a direct threat to our constitutional structure and, as a result, the liberty of the American people. And as SELA law held, the modern expansion of the federal bureaucracy sharpens the court's duty to ensure that the executive branch is overseen by a president accountable to the people. I welcome the court's questions.
General Sauer, could you give us one example of a permissible restriction on the authority to remove a principal officer?
We don't believe there are permissible restrictions on principal officers of the United States who exercise the executive power. Now, there may be separate issues relating to
let's say
particular historical pedigrees.
In this case, in a multi-body agency such as the FTC, is there any permissible restriction?
No, this court in Trump against United States held that the president's power to remove officers wielding the executive power is conclusive and preclusive.
How far do you go with that? Can it be arbitrary, completely arbitrary?
It is conclusive and preclusive, so any review of arguably bad reasons for the president to remove an executive officer would be subject to the political process. It would not be subject to judicial review, and certainly not subject to statutes regulating that.
I think there are a lot of agencies in the federal government where it's hard to parse whether it's an executive function they're engaged in or a legislative function. We obviously have the Perlmutter case that they're holding where you're dealing with the Library of Congress, which half of it's a library, half of it's things like the copyright. What are we supposed to do with that, if you're correct?
Well, Mr. Chief Justice, in Free Enterprise Fund, this court, I think, very aptly stated that the vast and varied nature of the federal government is a reason not to make general pronouncements on issues that haven't been briefed and argued. There are certainly situations where there are tough line drawing problems. You raised the Perlmutter case as one that may raise arguments of that nature, but by and large, the sort of insight that goes from Morrison to FCC against Arlington and to SELA law recognizes that these multi-member agencies that are exercising what this court has repeatedly recognized as quintessential executive powers, like the FTC, rulemaking, adjudication, investigation, seeking of civil enforcement power, litigation, seeking civil enforcement powers, or civil enforcement remedies, and so forth. Those are not close cases.
Yeah, I mean, I appreciate your point about not deciding cases that aren't before us, and I meant the Perlmutter case as an example, but I'm not sure you answered the question. Is this a severance issue? Do we so the agency is okay so long as half of it survives in one branch and half in the other, and if so, who gets to decide that?
For the vast majority of these agencies, I think SELA law pointed out there's maybe about 24 executive agencies that are multi-member structure and have removal authority. I think the logic of this court adopted it for severability in Free Enterprise Fund and SELA law, and Collins indicates that in the vast majority of cases, there would be an excision just of the removal authority. Now, if there are agencies that kind of straddle the line between legislative and executive, that might present harder severability conflicts.
Why is that severability the issue? Meaning, if you think they're wielding power that is inappropriate, why don't we sever that power?
I think those very arguments.
Instead of the removal power.
Well, for example, consider an agency like the FTC, which is before the court, virtually all of its powers. I can't think of a power that exercises.
But most of those powers were part of Humphreys. This court, even in Sheila Law and all of the cases you've mentioned since, have said that Humphreys is controlling law. You're asking us to overturn a case that has been around for nearly 100 years, correct?
90 years, I believe.
90 years. What other cases have we overturned that have had a pedigree of 100 years?
Penoyer against Neff was overruled by Schaefer against Heitner on its 100th birthday.
That was an economic case. What other case?
For example, Erie overruled a Swifty Tyson 96 years later. Those are two examples. There's at least 13
But which other case has fundamentally altered the structure of government? For over 100 years, actually since 1887, we've had multi-member boards, and that's the entire government structure.
The distortion of the structure of government, respectfully, that Humphrey, the philosophy of
aren't you asking us to distort it a different way?
I think we're
neither the king, nor parliament, nor prime ministers, England at the time of the founding, ever had a unqualified removal power. You're asking us to say that at a time, the founding, when the Constitution doesn't speak about this at all, where there was robust debate over this issue among legal scholars at the time, that we ourselves has said repeatedly in Humphreys and other cases, Wiener, even in Myers, that those cases you mentioned did not establish this absolute power of the president. You're asking us to destroy the structure of government and to take away from Congress its ability to protect its idea that the government is better structured with some agencies that are independent.
I think we're asking the court to return to the dominant line of authority that started in Ex parte Hennen in 1839, when this court said that it's a settled and well understood construction of the Constitution. The president alone can remove executive officials. That was reaffirmed in Parsons, for example, where it described it as settled beyond the power of alteration. Again, in Shurtleff, similar language. Myers says the same thing. Free Enterprise Fund, Collins, Seal of Law, Trump against the United States, and even Humphrey's executor itself paid lip service to this principle. Humphreys described this power as unrestricted and illimitable. And in order to get out of that rule, which the court has recognized in those 9 decisions is going back to 1789.
You still haven't answered my question. Where else have we so fundamentally altered the structure of government?
I think what the fundamental alteration of the structure of the government was ushered in by Humphreys, and then the Congress kind of took Humphreys and ran with it in the building of the monstrous administrative state and the proliferation of independent agencies that are insulated from
Independent
democratic
agencies
control.
have been around since the founding, the Sinking Fund, the War Commission. We've had independent agencies throughout our history. So this is not a modern contrivance.
We disagree with that, as in our brief, we disagree with that characterization of those agencies. The Sinking Fund Commission, for example, was composed of 3 officers who were cabinet
And we have an
secretaries.
amicus that
clearly
shows
removable.
us how the president's will could have been thwarted by that structure. We have an amicus brief that shows us how that the president's will by that structure could have been thwarted.
These kinds of historical examples, I think, have been considered in this court's cases from Free Enterprise Fund and Seal of Law and so forth.
So what do we
There's
do
been a
with
lively debate
Morrison?
about that, and the
What
court
do
has
we
come-
do with Morrison and Wiener and Perkins?
Well, Morrison, for example, I think is a really critical precedent here, because what Morrison did is it repudiated the entire logic that supported the holding of Humphrey's executor. It repudiated correctly the idea that there are these quasi-judicial and quasi-legislative powers that are outside the executive power, and yet they're wandering around the executive
Yet
branch.
you
and not in-
answered the Chief Justice by saying that maybe we just need to look at each agency individually. So we can't leave that area. By the way, your logic, you're putting at risk. By this, you're saying there's uncertainty. I think the uncertainty in the lower courts was not over Humphrey's executor. It has been over the court's most recent decisions, not because of Humphrey's executor. But you're putting at risk the independence of the tax court, of the federal claims court, Article I courts. You're putting at risk the civil service. I don't see how your logic could be limited.
As to the non-Article 3 courts, we haven't challenged the removal restriction as
Not
the
yet.
non-Article 3 court in this
Not
case.
yet. Not yet.
And we recognize that there are some line drawing issues as to those that came up in cases like Freitag and Ortiz. Again, those aren't presented here. Those aren't briefed here. and
Not
court
yet.
There's
presents-
a difference, I suppose, between Humphreys and Weiner, right? In terms of whether you overrule one or overrule the other, in terms of the consequences with respect to modern agencies. What the War Commission in Weiner, if you think that that's more like something like the Court of Appeals or the Armed Forces or the Tax Court or all those others, strikes me that Humphreys may be the issue, and that doesn't mean that Weiner falls with it or that the other agencies fall with it as well.
The piece of, we have a footnote about this in our brief, footnote 1, and we invite the court to overrule Weiner as well. Part of Weiner we think has been overruled by Braidwood, which is Weiner, interpreted, found a removal restriction that was not in the plain text of the statute, and that contradicts case law from Shurtleff until Braidwood. The other aspect of Weiner that we think is destructive is the phrase, the philosophy of Humphrey's executor. That philosophy of Humphrey's executor seems to have a very firm hold on Congress and a firm hold on the lower courts, and that's why there's been a proliferation of litigation about
There's
this.
one thing about, and I'll be brief, there's one thing about philosophy and there's another thing about holdings. Certainly the holdings of Humphrey's executor doesn't necessarily support Weiner to its fullest extent.
We agree with that.
General Sauer, can I ask you about the Federal Reserve? The other side says that your position would undermine the independence of the Federal Reserve, and they have concerns about that, and I share those concerns. So how would you distinguish the Federal Reserve from agencies such as the Federal Trade Commission?
We recognize and acknowledge what this court said in the Wilcox-Harris stay opinion, which is that the Federal Reserve is a quasi-private, uniquely structured entity that follows a distinct historical tradition of the first and second banks of the United States. There's two adjectives there, an adjective and an adverb, unique and distinct. The Federal Reserve has been described as sui generis. Any issues of removal restrictions as a member of the Federal Reserve would raise their own set of unique, distinct issues, as this court said in Wilcox against Harris. We have not challenged those, either in this case or any other case. And so it's not before the court.
But I think the question, General, did you want to? I think the question that these questions go to, right, is if you take your logic at face value, it seems to include a great many things. If I were to say, your fundamental proposition in your briefs is that the vesting clause, how many times do you say in your brief, gives the executive power, all of it, to the president? And so if you believe that, the fact that you can say, well, this has a history and that has a tradition, doesn't much go to the rationale that you are asking this court to accept. So once you're down this road, it's a little bit hard to see how you stop. And I think that that's one question. I mean, there's another question about whether you should start at all. But one question is, if you accept that proposition, which is the fundamental proposition of your brief, it does not seem as though there's a stopping point.
Yeah, I think it's a proposition of our brief, but those are obviously quotes from these courts' opinions. So it isn't that we have gone down this road. I think the court has been down this road. The country has been down this road since the decision of 1789. Again, Ex parte Hennon describes this as settled beyond doubt. Again, Parsons, which anticipates all the analysis of Myers, says the very same thing. This is beyond question that there's this removal power. And keep in mind, that's 1897. It's well after the bitter interbranch disputes about the Tenure of Office Act. It's after Congress started engaging this proliferation of restrictions on the removal of inferior officers.
Well, let me ask you how you would justify and how you would justify it consistent with the proposition that all executive power is vested in the president. Let's start with Article 1 courts. How would you justify keeping those courts?
Well, those courts, the determination would have to be made on a court-by-court basis, so to speak, as to whether or not they're engaging in the executive power. There may be tough line drawing questions there.
I mean, I thought that one of the things that we've said, again, in many, many cases, is that even though they're engaging in adjudicative functions, they have to be executive by their nature.
There's a dispute about this. I think basically lurking beneath the surface in the discussions in Ortiz, if they are indeed exercising executive functions, then the logic of this logic would apply.
Go ahead, please. No, go ahead.
I'll go. Is it a possibility, let's say you have an agency that is, I don't know, pick a number, 85% is judicial, some of the judicial entities that have been talked about in the briefs. And a smaller percentage is some executive function that they do, whether it's issuing rules or whatever. Is there a principle that you would sever out the smaller little tail on the dog and allow the judicial functions to go on?
Quite possibly, that would be I think a unique severability question that would be distinct from the merits. So if there was an agency that kind of straddles the line between two branches, and that may raise a different severability question. But for the mine run of these multi-member executive agencies, they're clearly exercising executive power. They're doing stuff that the NLRB does, that the MSPB does.
So how about those two? So you are here saying the NLRB goes down, the MSPB goes down, notwithstanding that they do all their work, or almost all their work, in judicial type proceedings.
I wouldn't say goes down. I would say they were restored to democratic accountability and the constitutional structure. But we have contended on the
current versions of those agencies goes down.
We have challenged those in this court, NLRB and MSPB, and there are others. This court in Sailor Law. I mean, there's various lists out there.
How about inferior officers?
We haven't challenged any restrictions on inferior officers.
Why wouldn't that also have to go?
That would certainly, restrictions on inferior officers of the United States would be problematic because, of course, Myers is involved in inferior officer.
Right.
The logic of Myers extends to inferior officers.
And obviously, there are all kinds of inferior officers wielding executive power all over the place, yeah?
There are many.
Yeah, so it seems as though executive officers. How about employees?
Again, we haven't challenged the restrictions on.
I know you haven't challenged it. It's really, the question is, where does this lead? What does it take you to, given what your primary rationale is? Employees are wielding executive power all over the place. And yet we've had civil service laws that give them substantial protection from removal for over a century. How about those?
Well, we do not challenge.
I know what you don't challenge. You're missing the point.
Well, then let me point the court to, if I could, to 7511B, of the civil service laws, the CSRA that we cite in our brief. That is a series of exceptions in it that provides no judicial relief at all to classes of employees, they're called. Now, some of those employees are clearly officers, some aren't, but for example, presidentially appointed officers, Senate confirmed officials, those who exercise substantial policymaking or have confidential responsibilities, and members of the CIA, for employees of the CIA and the Foreign Service. So there's already been the political branches have in many ways already addressed issues with employees. Now, this court obviously dealt with the employee issue in Lucia, and there was a dispute about that, various, proposed lines between employee and inferior officer.
Well, can I ask you
the court didn't decide those.
Can I ask you the same question, or maybe just a very similar question in a different way? you've been asked about a number of different agencies. A few of them are likely to come before us in the near future because of actions that the president has taken. Others, as you point out, have not been featured in litigation of which I'm aware up to this point. So suppose we were to decide this case in your favor without reaching some of the agencies that have been mentioned, like the tax court and the claims court and the Court of Appeals for the Armed Forces, to name the three. Suppose we were to decide the case in your favor, but we did not want to address those other agencies. On what ground, one way or the other, to express a view that would affect those agencies either, as I said, one way or the other? On what would you propose that we say so as to reserve decision on those agencies that may not come before us in the near future or perhaps at any time in the future?
I would, I think, use the language that the court used in Free Enterprise Fund when it said we do not decide the status of lesser functionaries. It pointed out that the dissent in that case had itself pointed out that the federal bureaucracy is vast, and it said we don't want to decide, given the size and variety of the federal government, that discourages general pronouncements on matters that are not briefed and argued. Now, as to, for example, non-Article 3 courts, I'm not even aware of litigation about those removal restrictions for any of those.
But you're not getting our logic has consequences. Once you use a particular kind of argument to justify one thing, you can't turn your back on that kind of argument if it also justifies another thing in the exact same way. And so, you know, putting a footnote in an opinion saying we don't decide X, Y, and Z because it's not before us doesn't do much good if the entire logic of the opinion drives you there.
I'm not sure that's true when it comes to non-Article 3 courts, because there the question would be, what are they doing? Is it judicial power or executive power? That's a totally different set of questions.
But
Those are hard questions.
But I think Justice Kagan's point is that you're asking us to ask that question. And so we have to understand, you're asking us to ask the question with respect to each agency, what are they doing? That's the necessary result of the argument that you're making in this case. And I guess my point is, one way to avoid these difficult line drawing problems would be to let Congress decide. I mean, I sort of thought that we have Article 1, which I think you agree gives Congress some authority to set up these agencies, to determine their structure, to create the offices that we're talking about. So it seems to me that that greater power, we should at least think about whether it should include the power to determine the term of office, the extent to which people can be removed. And I appreciate that Article 2 has some language in it that you're pointing to, but as Justice Sotomayor pointed out, the Constitution does not speak specifically to removal. You're asking us to infer this based on the Constitution structure. And I don't know why we'd make that inference when the power to create agencies and set everything up lies with Congress.
I agree with very much of what you said, and so did James Madison. So he made the point in the decision of 1789 that Congress has authority to create the office and give it, set its emoluments and structure that office. But once Congress has done that, its power there stops.
Is that because of your democratic accountability? I'm trying to understand why you think that Congress is somehow less democratically accountable for the way in which it constructs these agencies and determines the term of office of the officers. You seem to think that there's something about the president that requires him to control everything as a matter of democratic accountability, when on the other side we have Congress saying we'd like these particular agencies and officers to be independent of presidential control for the good of the people. We're exercising our Article 1 authority to protect the people by creating this independent structure. And I don't understand why it is that the thought that the president gets to control everything can outweigh Congress's clear authority and duty to protect the people in this way.
Congress has a broad authority in structuring the federal government, but what it lacks authority to do is to create these headless agencies, agencies who have no boss and are not answerable to the voters.
Why?
Confer on
Why?
them
Why does it lack the Constitution does not say that Congress cannot create an independent agency. So what is it about your argument that requires us to reach that result?
We disagree with that. We think the text of the Constitution confers the executive power, all of it, on the president. As Madison argued compellingly in the decision of 1789, the power to remove is an aspect of the executive power. Further, the text of the Constitution includes the take care clause. The take care clause, as the court has said virtually every time it's discussed this.
The text of the Constitution includes the necessary and proper clause, which gives Congress the authority to determine, set up, et cetera, these agencies to protect the interests of the people. So we have a conflict, I guess, and I'm just wondering why the president's interests in the way that you described them win.
You can answer the question.
It is not proper under the necessary and proper clause for Congress to peel away executive power from the president and give it to someone who's not answerable to the voters.
Thank you. Justice Thomas? Justice Alito?
Let me follow up on two things that have come up thus far. It certainly is an interesting argument. It's an interesting constitutional argument. It's an interesting political science argument about the advantages and disadvantages of allowing Congress to impose removal restrictions on executive branch officers. When would you say the court crossed that bridge? And what have we said about that bridge in recent decisions?
Recently, the court, and in many decisions, the court has pointed out that the framers of the Constitution were not trying to prioritize efficiency or convenience. They were deliberately creating a separation of powers where the branches would check each other, and that's why the court should have sharpened rather than blunted review of encroachments by Congress that involve peeling away executive
Well, I mean,
power.
there's an argument that the Constitution doesn't say anything about the president's removal authority, and therefore Congress should have free reign in that era, on that question. When did the court cross that bridge?
I think the court, if you're saying cross that bridge, I mean, when did the court adopt that view?
When did the court say that, no, Congress doesn't have plenary power to impose removal restrictions on executive branch officers?
No later than Ex parte Hennon in 1839, when the court said that, referring to the decision of 1789, that this is the settled and well understood construction of the Constitution, that the president alone has the removal power.
How about Myers?
Myers was also very clear on that in 1926. And in fact, Humphrey's executor itself paid lip service to it, even though its heart was far from it.
It's been suggested that if we were to rule in your favor about the Federal Trade Commission, put aside these other agencies, just about the Federal Trade Commission, which is the issue that's before us, the entire structure of the government would fall. You want to take a minute to address that?
The court in, I think, Free Enterprise Fund or Seal Law talked about these kind of predictions of doom, and the sky did not fall when the removal restrictions were removed from the CPSC and the PCAOB. So also if the FTC, the MSPB, the NLRB are made subject to political process and the political discipline of being accountable to the president, the sky will not fall. In fact, our entire government will move towards accountability to the people.
Thank you.
Justice Sotomayor?
Counsel Myers, which you rely on, was signed by a number of judges. One of them was Justice Sutherland, and he was the author of Humphrey's executor. So 4 out of the 9 justices who signed on to Myers signed on to Humphrey's. So you're thinking, or you're arguing, that the reasoning of the more current justices on this court have more purchase than the views of renowned jurists like Holmes and Brandeis, who dissented in Myers, of people like Justice Story, who disagreed with this proposition. You're suggesting that we have a better view than either Congress or all of those previous justices about what absolute executive power means. That's basically your argument. All those justices in the past have been wrong. And the current ones are right, or at least the current ones of the Shigella law majority.
I'd say two things in response to that. I think the court was correct in the following decisions: Ex parte Hennon, Parsons, Shurtleff, Myers.
Those all
Selah.
involved different and distinguishable situations. Now, with respect to the one component of government that you're not speaking about, when the FTC was created, as has been the case with most of these independent agencies like the Federal Reserve, particularly there, but not that much lesser with the FTC, Congress emphasized the importance of independency and the prestige that that independence would give to the decisions of agencies who are going to subject the public to rules and regulations of which there might be burdens. And that independence is being taken out or undercut completely. Why are you so sure that Congress would have preferred to have the independence narrowed than not to have the agency at all? Some of my colleagues have suggested in prior cases that we shouldn't be engaged in the severability actions at all. But here you are arguing that, no, we should be doing that. Why? Are you going to be consistent?
The prestige, I would say two things in response to that. The prestige of independency is not a constitutional value. The constitutional value is the separation of powers and the vesting of all the executive power in the presidents. That is the
according to the laws that Congress makes. And that's the point Justice Jackson was emphasizing. What you're saying is the president can do more than what the law permits.
I think I would repeat what I said before. There's a strong line of precedent recognizing that the text and structure of the Constitution confer on the president the exclusive and illimitable power to remove executive officers. And as a result of that, Humphrey should be overruled.
Justice Kagan?
General, would you agree with me? And I hope you will agree with me, because this seems to be the one thing on which everybody can agree. That if there's one thing we know about the founders, it's that they wanted powers separated. They wanted the executive, the legislative, the judicial. They didn't want them all in one place. They wanted them separated across the government, across the different branches. Easy enough to agree with, right?
I agree with an important caveat that the court stated in Selah law, that the one, exception to all this division was the presidency itself, where the framers consciously adopted a unified and energetic executive.
Well, that's not a caveat. That's like the not X to my X. Because what I was saying was, and maybe you knew where this was going, so you had to have this caveat, which is really a fundamental contradiction. But the idea is that the president was supposed to do the executing. But he wasn't supposed to do the legislating, and he wasn't supposed to do the judging. And here's my next proposition, which I think you have to agree with, because we just look around the government and it's obviously true. Some people think it's a real distortion from what the founders thought, but these, what you think of as executive branch agencies, including independent agencies, right? They do a lot of legislating, and they do a lot of judging. And you listed it a bunch of times. You said, this is obviously executive power. Why is it obviously executive power? Because they're doing a lot of rulemaking, and they're doing a lot of adjudications leading to enforcement. And those are, although we've said that this is executive power in some sense, but they're legislative functions. That's what rulemaking is. They're adjudicative functions. And isn't it problematic, given what we know about the founders' vision, that what this is going to amount to at the end of the day is putting not only all executive power in the president, but an incredible amount of legislative / rulemaking power and judging in the president's hands?
I disagree. I got off I started disagreeing very early in that question, and I think I can pinpoint it this way. the mere fact this court held, I think every justice agreed in FCC against Arlington, it's been reasserted. It was the vision of Morrison. It was recognized in Morrison. It was reasserted again in Steele law. The mere fact that things that some of these agencies do have the form of rulemaking or adjudication does not make that legislating or judging for constitutional purposes. That is execution.
Yeah,
and as the
but
court
we
said-
can all admit that for whether you want to call it for constitutional purposes, that in a real world kind of way, that's what they're doing. Now, some people think that we should never have gone down that road, but that's what we're doing. So let me put the proposition in a sort of different way. Here's been the bargain over the last century, and I think it has been a bargain. Congress has given these agencies a lot of work to do that is not traditionally executive work, that is more along the lines of make rules when we issue broad delegations, and do lots of adjudications that set the rules for industries and entire bodies of governance, right? And they've given all of that power to these agencies, largely with it in mind that the agencies are not under the control of a single person, of the president, but that indeed Congress has a great deal of influence over them too. And if you take away a half of this bargain, you end up with just massive, uncontrolled, unchecked power in the hands of the president. And it's really hard to affect both sides of this bargain because it's already been done. So the result of what you want is that the president is going to have massive, unchecked, uncontrolled power, not only to do traditional execution, but to make law through legislative and adjudicative frameworks.
The president is going to have all the executive power, which is what the Constitution dictates. And the way you framed it there, I think, makes the separation of powers problems in the alternative view here even worse, because you have just described these rulemakings and adjudications as really judging and legislating. If they really were that, which this court has unanimously said they must not be, they cannot be. But if they were that, then Congress is not just affecting the executive, it's creating junior varsity legislatures, which would be unconstitutional under Justice Scalia's dissent in Mistretta. It's peeling away adjudicative authority, the judicial power from Article III courts.
I understand that as a formal argument, and obviously formal arguments play a significant role in this area, but they shouldn't blind us to the real world realities of what our decisions do. And the real world reality of this one is that when you put all of these agencies under complete presidential control, given what Congress has already done and will not be able to take back with respect to the powers that have been delegated to the agencies, what you are left with is a president that maybe, your first sentence to me, this is the kind of president you want, but a president with control over everything, including over much of the lawmaking that happens in this country.
He would have control over the executive branch, which he must and does have under our Constitution. And again, if that's really legislating, then there's a separate constitutional problem that the legislative power has also been taken away from Congress. Now, this court has not adopted that in a series of decisions, including Morrison, including FCC against Arlington, including Steele law. The court has correctly recognized that all this stuff that agencies like the FTC is doing is an exercise of the executive power. That is fundamental to our separation of powers, which is the bastion of individual liberty in our constitutional structure.
Thank you, General.
Justice Gorsuch?
General, let me suggest to you that perhaps Congress has delegated some legislative power to these agencies. Let's just hypothesize that. And let's hypothesize, too, that this court has taken a hands-off approach to that problem through something called the intelligible principle doctrine, which has grown increasingly toothless with time. Is the answer perhaps to reinvigorate the intelligible principle doctrine and recognize that Congress cannot delegate its legislative authority? Is the water warm, General?
Sorry, what was the last? I couldn't hear the last bit.
Is the water warm?
Is the water warm? Suffice to say, let me say one thing in response to that. The it is much easier to cure. Obviously, members of this court have debated the scope of the non-delegation doctrine. The challenge of finding the right standard there is something we've discussed in the past. Here, though, this wolf comes as a wolf, right? I mean, the restriction on executive power is right there in the statute. It's easy to remedy by excising the removal restriction. In the
There are a
past
lot of
cases.
wolves around here, General. That one thing our framers knew is that every political actor seeks to enhance its own power. We all know that to be true from our own experiences. And this court, as part of this bargain, has allowed these agencies to exercise both executive and legislative. Justice Sutherland, whose name hasn't been invoked around here in quite a while, his language about quasi-legislative and quasi-judicial and quasi-this powers. And this court has allowed that for a very long time. But if we're not going to allow it any longer, I take the point that this has allowed a bargain where a lot of legislative power has moved into these agencies. But if they're now going to be controlled by the president, it seems to me all the more imperative to do something about it.
I agree with that, and I can't address all the wolves in the world, but this wolf, when it comes to constitutional structure, is Fenris, the most dangerous wolf in the history of Norse mythology.
And let me ask you about the judicial power. To the extent we're worried about the tax court or the court of claims, maybe despite what people think, maybe some of them might be, I don't know, but maybe they're Article 3 courts and the removal restrictions are impermissible. Thoughts?
There definitely could be arguments of that. I'm not taking a position on the validity or non-validity of any of those, which are not presented here, but certainly commentators have argued that things like the federal magistrate judges and the bankruptcy courts seem to be real adjuncts to Article 3 courts, and the argument might be made of that nature. There are line drawing problems there. We haven't addressed them here. I don't have the federal government's concerted answer to that, but certainly those line drawing problems would go to whether what is going on is judicial power or executive power. And if it is executive power,
The adjudication of private rights is different, we have said, than the adjudication of public rights.
And again, yes, those would implicate all those line drawing problems.
Justice Kavanaugh?
Response to Justice Sotomayor's question, you have Taft and Scalia, right? It's not too shabby.
I think those are outstanding jurists, and with respect to Justice Scalia in particular, one of the greatest jurists in the history of the court.
I thought your two exceptions that you've had a lot of questions about, but I thought the two exceptions, the categories were one, the Federal Reserve, based on history and tradition and function, and the other were the non-Article 3 courts, which starts in Marbury. Marbury itself discusses this. Taft discusses Marbury at length in Myers on this exact point of non-Article 3 courts being different. Taft leaves that open, right, in Myers. And so for Court of Federal Claims, Tax Court, the DC local courts, you mentioned this at page 23 of your brief, it would seem to me that Marbury itself says that is a line that distinguishes the non-Article 3 courts from the position that you're taking here. I know you may not agree with that, but is that a principled, sensible line we could draw?
Certainly it is something that the court could look at. I don't want to take a position on them. To be clear, I am not taking a position on whether that line is valid, but certainly there are arguments that could be made and debated in an appropriate case about where those lines should be drawn. And you do, I think, correctly reference both Myers and Marbury itself as teeing up some of those issues.
There's been debate about Marbury. Was that about DC or was that about judicial office? But I read it to be some of both, so for what that's worth. Why did no president challenge this structure from 1935 to 2025? We've had a lot of presidents who've had very strong views of Article 2, yet for 90 years it stood not directly challenged. Why do you think that is?
It'd be speculative to answer that. I mean, one reason might be that presidents are fairly comfortable with taking away tough political decisions. So as the court has said in multiple cases, I believe one president cannot bind the hands of its successors, and the president there's a kind of responsibility that goes with the authority here. The president sometimes may have a political incentive to allow tough decisions to be outsourced, so to speak, to agencies that he doesn't have direct control over. However, our constitutional structure dictates that the president cannot do so. He cannot bind the hands of its successors, or the encroached upon branch cannot consent to the encroachment, and therefore disrupt our constitutional structure.
One thing you've said, but I want to make it crystal clear, that overruling or narrowing Humphrey's executor would not threaten the existence of these agencies, but only would alter how the heads of those agencies can be removed, correct?
Correct. They'd be politically accountable to the president. And this court has, in 3 different decisions, addressed these kinds of broader implications, severability arguments, and come down there.
The way we've done it is to sever the removal restriction, not to destroy the agency, correct?
That's exactly right.
On stare decisis, you used the word dangerous, I think, in your opening about the independent agencies. One of the things we consider are the not only how wrong it was and reliance interests, but the real world impacts. And I think just give you a little bit to explain why you use the word dangerous when talking about independent agencies, if I heard that correctly.
And maybe to return to the exchange I had with Justice Kagan, the real world consequences here are human beings exercising enormous governmental authority with a great deal of control over individuals and business, small and large businesses and so forth, who ultimately do not answer to the president. That's a power vacuum. The president is answerable to the voters. They have no boss. And regardless of what happens, when there's a power vacuum, somebody's going to come into that power vacuum. So is it Congress that many commentators have noted actually exercise substantial control over these independent agencies through budgetary functions and through oversight functions? Is it industries engaging in industry capture of the agencies? The point is that power vacuum should not exist in our constitutional structure because, as Madison said, there's a line of accountability, a chain of dependence that runs from the officers to the president, and he's answerable to the community, which is the voters every 4 years.
I want to return to what Justice Kagan and Justice Gorsuch were talking about with you in terms of the bargain. And I think broad delegations to unaccountable independent agencies raise enormous constitutional and real world problems for individual liberty, as you just mentioned. I've obviously said that many times in prior opinions. I thought one aspect of that we've taken great steps to correct has been the major questions doctrine over the last several years to rein in what Justice Kagan was talking about, these broad delegations, to make sure that we are not just being casual about assuming that Congress has delegated major questions of political or economic significance to independent agencies or to any agencies for that matter. You want to speak to the major questions doctrine and how that fits into your answer?
Suffice to say that the major questions doctrine is not a substitute for the president's removal power. It may have done some work in backstopping the fact that we do have these independent agencies without a political discipline, but the president's removal power is what is dictated by the Constitution, that the president must have the power to control, and that these agencies, the one who has the power to remove is the one who is the person that they have to fear and obey.
Sorry to prolong this, but on your second question presented, I just want to touch on that quickly. This is about the reinstatement argument that you make. I have some real doubts about that argument. We don't need to reach it, of course, if we agree with you on the first question. I have some doubts about that because that really would be an end run around the exceptions you had identified earlier for the Federal Reserve or for the non-Article 3 courts. In other words, you could just remove those people, and so long as you continue to pay their salary, you wouldn't have to reinstatement. That strikes me as really destroying the categories that you had identified as potential exceptions. So I'm concerned about your reinstatement argument on question 2, and just want to give you a chance to address that.
Maybe I could just say 2 things. I think that this court in its Wilcox-Harris stay opinion said something very telling. It's not binding on this issue, but it's very persuasive when it talks about how when it comes to the balancing of harms, the injury to the government from being forced to take back into the fold an executive officer that the president's really already ejected from the fold outweighs the interest of even a wrongfully removed officer, as I read that sentence, wrongfully removed officer from continuing to exercise their statutory authority.
Don't you have a problem again here with Marbury on recognizing mandamus? I mean, I know a lawyer never wants to hear you have a problem with Marbury, but I think you have a problem with Marbury.
I think the fact that it's a judicial officer there doesn't raise all these separation
Well, what's the, I mean, the other side says that's completely gerrymandered answer to the, I mean, yeah, but what's the principle on page, what is 43?
The principle, I think, is the separation of powers, right? Because these removals of the executive branch, if you're removing a judicial officer, it just doesn't raise all these issues. And that's why the answer to that concern when it comes to Article 3 courts is not, oh, the president doesn't have removal power. It's that, are these Article 1 or are these Article 3? If they're in Article 2. If they're in Article 2, the president has control. If they're in Article 1, then it may look very different.
Thank you.
Justice Barrett?
So, General Sauer, you argue that the removal power comes from the vesting clause. And I understand why you make that argument, because that would be the broadest authority, because it would give, that would be the full unitary executive theory. But there are other theories of where the power could be located. For example, if it was part of the take care clause, then it might be more limited, because it might apply only or give removal authority only over those officers who exercise significant discretion. Or it might be an adjunct to the power of appointment, which would mean that inferior officers didn't come within it. And I don't read our cases to this point to really be very specific. They mention all three, and they could be mutually reinforcing. Is there any reason for us to be specific about it in this case?
I think the court ought to adopt, as I read the cases, virtually every time the court has decided this, certainly in Seal Law and Free Enterprise Fund, but also going back to the 19th century cases, the court looks to both the vesting clause and the take care clause. And then in other cases, it also refers to the appointments clause and how the power to remove also flows to the power to appoint. So you have three kind of mutually reinforcing textual bases to place what, again, the court's decisions from ex parte Hennon through Humber's executor decided as a settled beyond doubt, exclusive and illimitable power of removal. So I think the text of the Constitution supports what you've referred to as the strong theory, and that's, I think, repeated again and again in this court's decisions, where it started with the vesting clause. And of course, it's the logic of Madison's statements on the floor of Congress in the decision of 1789.
Well, let's see, I know that obviously, I understand that's your first line position, and I do think that you could go back through the cases and find that, and I agree with you that we mentioned the vesting clause. I agree with you, it comes up in the decision of 1789, et cetera. But what I'm asking is there any reason that we have to? Because it seems to me that they're very hard questions. Justice Kagan in particular was pushing you on them about what the limits of your logic would be. And it seems to me that, and there's some dispute among this in the amicus briefs and the scholarship about which portion of Article 2, or if it's in the appointments clause, would be the source of this authority. And is there any reason we have to decide that here, given that it might be relevant to some of the harder questions about limiting principles?
I don't dispute that there might be narrower grounds on which the court could rule, but we'd encourage the court to adhere to the logic of all those decisions. Again, I've discussed 9 decisions from 1839 to 2024 that talks about this removal power as exclusive and illimitable, conclusive and preclusive, and so forth. I mean, that really is the line of this jurisprudence. It's a compelling logic that Madison successfully advocated on the floor of the first Congress, and we would—
So we have to do vesting clause.
We think the vesting clause provides at least the clearest textual basis for it. I mean, when Madison said, for example, the power of overseeing and controlling those who execute the laws is the quintessential executive power, that's the logic of it. Could the court devise a holding that based solely on the appointments clause? That's possible,
I wasn't proposing devising that holding. I was just proposing not being very specific about it, which I think some of our prior decisions have been. But let me move on. And actually, this is a question I truly don't know the answer to, and I just thought of it during the argument as we were talking about bargains. So both Justice Gorsuch and Justice Kagan were asking you about the bargain that Congress has made in creating these independent agencies. And I was struck by, I remember Justice Gorsuch brought up in the tariffs argument the fact that that tariff statute had a legislative veto originally. I don't know whether the original 1935 FTC Act from Humphreys did or did not. But I guess the question that I have is that part of the bargain, because legislative vetoes were pretty ubiquitous throughout the 20th century. And of course, we held them unconstitutional in Chadha. And if you had a legislative veto, even if Congress wasn't exerting itself the authority to fire the head of one of a member, multi-member board, it could override decisions that the agency made. But I think I gather your point, part of your response to Justice Jackson about why these agencies are different is it's not like they're answering to Congress either. You know, Congress creates them and it might put the removal restriction on them, and that might limit the president's authority, but they're not answering to either the president or to Congress. But when the legislative veto was in place, there was some measure of congressional control that is perhaps more significant than budgetary restrictions. I just wondered if you could speak to that.
Two things. INS against Chadha correctly recognized that there was legislative
I wasn't
control.
questioning Chadha.
Yeah, and Chadha, I think, very powerfully explains that that's terrible. That is a huge separation of powers problem when Congress is attached a string to its delegation to control what executive officers are doing. And then the historical point that in Chadha, by the time of Chadha, that had been in place, legislative vetoes had been in place since 1932, over 50 years. There were 196 statutes with 295 legislative vetoes, and this court said they're unconstitutional. And the fact that Congress likes this encroachment power so much sharpens rather than blunts the court's review.
But that's not quite the question that I had. I guess what I was wondering is, do you think it's part of the reason Congress was willing to infuse agencies with a lot of the broad powers? Justice Kagan was pointing out, they now exercise a lot of rulemaking power. There's a lot of adjudicatory power. And I'm not questioning Chadha. I think Chadha, rightly, as you said, made the separation of powers point that Congress can't retain this power for itself. But I guess what I'm saying is, having lost that check, maybe these independent agencies have become something that Congress didn't intend or anticipate even at the point that it set it up, which is the point that Justice Gorsuch made in the tariff argument with respect to IEPA.
May I just say this? I believe the FTC Act, I'm not aware of it having a legislative veto at any point in its history. I could be wrong about that. But as Chadha points out, legislative vetoes started coming in vogue in 1932, and the FTC Act goes back to 1913. So I'm not sure if that's part of the dynamic.
Let me ask you a question about stare decisis. How should we think about reliance interests when it comes to reliance interests in government structure? You know, Justice Sotomayor was pushing you about, had we ever overruled a case that was this old? And you gave lots of examples, and frankly, examples that came, I mean, Erie kind of came out of nowhere in overruling Swift, right? And here I would say there's been an eroding of Humphrey's executor over the years. But I think what Justice Sotomayor was really trying to get is not at, was there as an age gap, but this kind of decision. And I'm not asking you whether there's been another analogous decision, but I think when we think about stare decisis interests, this kind of structural interest, which is really the interest that's been identified on the reliance side. Can you think of a case that talks about how the reliance factor of stare decisis plays in here?
I think Justice Gorsuch's opinion for the plurality in Ramos addresses this when he talks about how you're weighing, here you're weighing an injury to the constitutional structure. That's not a valid reliance interest. The relevant reliance interest is the reliance of the American people in separation of powers and defending our liberties. If you look at actually like human reliance interests, like, entering into marriage, starting a small business, and so forth, you don't see a lot of people making, decisions in reliance on the fact that there are, multi-member agency commissions have removal restrictions. The only actor here who's arguably relying is Congress, and Congress's act of reliance is itself the violation of the separation of powers. And where that's the case, this supposed congressional reliance interest should be given little or no weight in our view. And then, I think I'll say that.
Justice Jackson?
So I guess I really don't understand why the agencies aren't answering to Congress. Congress established them and can eliminate them. Congress funds them and can stop. So to the extent that we're concerned that there's some sort of entity that is out of control and has no control, I guess I don't understand that argument.
We would say the constitutional actor on the hypothetical who is controlling these agencies is Congress, and that is a huge separation of powers problem.
No, I understand. I'm just talking about as a practical matter. Part of your argument seemed to revolve around this notion that there's some kind of thing happening with the independent agency, that the reason why the president needs to control it is because they don't answer to anybody. And what I guess I don't understand is why they don't answer to Congress, which establishes the law that they are bound to follow and determines whether these agencies exist, funds these agencies, all of those things, it would seem to me, would be methods or mechanisms of control.
The Constitution requires clear lines of political accountability. So if Congress is sort of informally actually controlling these agencies through like oversight.
Not
hearings.
informally, we have a statute, but let me ask you another question. I guess I have a very different view of the dangers and real world consequences of your position than what you explored with Justice Kavanaugh. My understanding was that independent agencies exist because Congress has decided that some issues, some matters, some areas should be handled in this way by nonpartisan experts. That Congress is saying that expertise matters with respect to aspects of the economy and transportation and the various independent agencies that we have. So having a president come in and fire all the scientists and the doctors and the economists and the PhDs and replacing them with loyalists and people who don't know anything is actually not in the best interest of the citizens of the United States. This is what I think Congress's policy decision is when it says that these certain agencies we're not going to make directly accountable to the president. So I think there's a pretty significant danger that Congress has actually identified and cares about when it determines that these issues should not be in presidential control. So can you speak to me about the danger of allowing in these various areas the president to actually control the Transportation Board and potentially the Federal Reserve and all these other independent agencies?
I think the court said it well in Free Enterprise Fund when it said that we can have a government that functions without rule by functionaries. We can have a government that benefits from expertise without being ruled by experts.
No, we can have, but I'm asking you about Congress's choice, Congress's decision that in these particular areas, we would like to have independence. We don't want the president controlling. I guess what I don't understand from your overarching argument is why that determination of Congress, which makes perfect sense given its duty to protect the people of the United States, why that is subjugated to a concern about the president not being able to control everything. I mean, I appreciate there's a conflict between the two, but one would think under our constitutional design, given the history of the monarchy and the concerns that the framers had about a president controlling everything, that in the clash between those two, Congress's view that we should be able to have independence with respect to certain issues should take precedence.
The constitutional design sets up 3 branches of government. It forbids Congress from controlling what the executive branch does, and it also forbids Congress from shaving away the president's control.
And what I'm positing is that Congress's decision here is not shaving away the president's control. You cast it as that, and I appreciate that, but instead, what Congress is doing is saying we'd like to have independence, nonpartisan experts working on certain issues for the good of the American people. And I understand that the president would rather control them, but it's not really his decision in the overall scheme of things, I say. Why am I wrong about that?
Under the constitutional design,
it is the president's decision as to how the government is structured and who should be doing what.
No, that is largely Congress's decision with certain exceptions. Congress cannot violate the separation of powers and threaten all of our liberties in the way that it structures the government, and it has done so here.
One last question. I appreciate the effort to try to make this not seem as big a deal as it might be by focusing only on the FTC and saying this is really just about what happens and we'll cross the bridge of the other agencies when we get to it. But can you just give us a sense, because I'm sure you must know this, of what other agencies there are that have the kind of removal protections that are at issue here? There's some, what, 24?
That's what Seal Law said. That's probably a good accounting. And obviously we have challenged 4 of them in this court, and we're challenging a handful of others.
But you could challenge the National Labor Relations Board, the Nuclear Regulatory Commission, the Commission on Civil Rights, potentially the Sentencing Commission, the Occupational Safety and Health Review Commission, the Consumer Product Safety Commission. All of these have that kind of structure.
I don't know if all of those are on the list. Certainly some of them are. And some of them, and many of these agencies we are litigating, including in this court.
Thank you.
Thank you, counsel. Mr. Agarwal.
Mr. Chief Justice, and may it please the court. The president's constitutional duty to execute the law does not give him the power to violate that law with impunity. But petitioners claim that the president was free to fire Commissioner Slaughter without cause in violation of the FTC Act as authoritatively construed by this court. And they urge, even if that firing was illegal, there is nothing that any court anywhere at any time could do to remedy that violation. The district court correctly rejected both arguments, and its judgment should be affirmed. On the merits, multi-member commissions with members enjoying some kind of removal protection have been part of our story since 1790. So if petitioners are right, all three branches of government have been wrong from the start. Congress and prior presidents have been wrong to jointly create early founding era commissions and more than 24 traditional independent agencies since 1887. And this court was wrong to repeatedly bless those laws and to unanimously uphold the exact same removal provision at issue here in Humphrey's Executor almost a century ago. Reasonable people can and do disagree about first principles, but any abstract theory that would wipe away so much history and precedent should be a non-starter. At a minimum, petitioners would need an airtight theory to justify the radical change that they now seek, and they don't have one. No tool of interpretation clearly supports the president's assertion of an unrestricted and indefeasible authority to fire the heads of traditional independent agencies like the Federal Elections Commission and the Nuclear Regulatory Commission. Plus, petitioners' theory cannot be reconciled with their own apparent position on the Federal Reserve and Article I courts. Finally, stare decisis militates against overruling a century of precedent at this late date. The political branches are more than up to the task of finding reasonable legislative solutions that strike an appropriate balance. That kind of legislative solution is far preferable than abandoning a foundational precedent on which so much of modern governance is based. I welcome the court's questions.
Was Humphrey's Executor an executive branch case?
It was an executive branch case, Justice Thomas, insofar as the FTC is an entity that is not operating under the auspices of Articles 1 and 3, but it is also a case in which Congress and the president coming together have determined that it's not part of a traditional executive department. And
did the court in Humphrey's Executor distinguish it from its earlier precedent in Myers?
The court, yes, absolutely distinguished the FTC from its earlier precedent in Myers.
Wasn't that distinction based on its function more as a quasi-legislative, quasi-judicial agency as opposed to an executive branch agency?
It was based in part on functions, Justice Thomas, but it was also based on the placement of the agency and the considered determination of Congress and the president together that this was the kind of agency that should be insulated from presidential at-will removal.
Now, you rely on the reliance into interests and started in the reliance interests of Congress and reliance interests, I guess, of others of the agency heads on the structure of this agency for so many years. What is it, 70 years, you say?
The FTC is 111 years old.
But from Humphrey's Executor?
90 years.
How would you have applied that in the overruling of Swift v. Tyson, your reliance interests?
Yeah, so Swift v. Tyson deals with a completely different kind of situation with respect to the Erie Doctrine.
So there was no reliance interest?
So reliance interest with respect to choice of law determinations. Yeah. I haven't thought through that systematically, Justice Thomas, to tell you the truth. I do think that there is a reliance interest here that is both immense and undeniable, and that is the fact that Congress and the president have determined that there are certain statutory authorities, not constitutional authorities, statutory authorities that the executive branch would never have in the absence of congressional legislation that Congress and prior presidents thought should not be under the sole control of just one person. And that reliance interest would be completely destroyed by retroactively destroying the independence of traditional
So this is,
agencies.
I don't know what a traditional executive administrative agency is, but could Congress limit the removal authority of the president in a newly created executive branch agency? Let's say, for example, a few years ago, EPA became an executive branch agency. It was more of an administrative agency, a sub-cabinet. Could it, in doing that, limit the removal authority of the president, of the head of the EPA or Homeland Security?
I think it is within the realm of possibility, Justice Thomas, and I don't think that the court ex ante should adopt any kind of categorical rule precluding that.
No, I'm trying to, again, the SG was asked about the logic of his argument. What's the logic of yours? How far does it carry you? If this is an executive branch agency, and your distinction is this is a multi-member agency, why doesn't the logic take you to a single head agency also?
So you're asking whether a single-headed agency could be converted into?
No, I haven't gotten there yet, but that would be the next step in order to make them removable, to make them the heads of the agency or the principals removable.
Mm-hmm. So there are constraints. One of the constraints is that the creation of the agency and the insulation from presidential control cannot interfere with the president's conclusive and preclusive constitutional
But you
authorities.
still haven't told me, why can't tomorrow morning Congress decide that the Secretary of Congress should be removable and it should limit the president's authority to remove the Secretary of Commerce?
That would be squarely foreclosed by this court's decision in Seala Law as we understand it. And that is to say, this court in Seala Law held that there is a particular serious threat to individual liberty that is posed by single-headed agencies that wield significant executive power.
Could Congress convert all these departments into multi-member commissions? The Commerce, EPA, Department of Homeland Security, Department of State, convert them all into multi-member commissions and make them removable only for cause?
No, I think, Justice Kavanaugh, that we're looking at three buckets here. In one bucket, including the Department of State, you would have departments that under no conceivable circumstance could practicably be converted to a multi-member commission because they are wielding so many of the president's conclusive and preclusive constitutional authorities. But that is a relatively small bucket. Let's say Department of State,
Justice and Defense.
Justice, Defense, Homeland Security, probably.
Are you saying, though, that they're limited by practical concerns or constitutional concerns?
Constitutional concerns, and then practical concerns will come up as well.
Well, let's put aside the practical concerns. I'd like to understand just the answer to Justice Kavanaugh, why tomorrow Congress couldn't transform every cabinet official into a multi-member group. What's the constitutional problem with that, I think is what my colleague was getting at.
Absolutely. And the constitutional problem, in our view, is that Congress cannot limit the president's authority over officers who are wielding the president's conclusive and preclusive constitutional powers. And that is a line that goes all the way back to Marbury v. Madison. It's a through line through this court's jurisprudence, including Justice Jackson's.
The FTC has the authority to enter foreign agreements, right? I mean, how do you decide what's conclusive and preclusive?
It does not have the authority to enter into foreign agreements on its own, Justice Barrett. The statute expressly provides that the Secretary of State's approval is required before any kind of agreement is executed. And the Secretary of State, of course, is subject to the president's plenary removal power.
You talked about sorry.
I just want to make sure I understand because it's fairly basic. I mean, are there some cabinet departments that you say Congress could just take over? Department of Veterans Affairs, Department of Education, they think, well, we experts can do a better job of it. And so we're going to say there is now an agency, the Agency for Education, and it will be run by, whether it's a multi-member group or not. We think it's important for Congress to have greater control over education. So We're creating this new agency, and its authorities will be everything that the current Department of Education has, except it will be run by a commission, and they can only be removed for cause. Is that all right?
Yeah, I think that it is probably within the realm of possibility for agencies, yes, Chief Justice Roberts, and the constraint historically has been that these types of determinations have been made through a process of political accommodation between Congress and the president, and over the course of more than 200 years, we have not seen.
Well, I'm sorry to interrupt, but sometimes that accommodation is greater than in other times. I mean, we have situations, let's say, where the Congress, both houses are controlled by one party and the president is of the same party, and they may decide that the government would be structured better than by taking over these entities. And so which departments could Congress impose a multi-member commission instead of a secretary?
Yeah, so if you're asking about which ones could be converted today, I think it's probably a pretty small universe in terms of the numbers that could be wholesale transformed as they are currently constituted. Why? Because it appears that the vast majority of executive departments wield at least some powers that this court would deem to be conclusive and preclusive, including under the standard that this court enunciated.
Well, how are those? I'm sorry, keep going.
Including under the analysis that this court set out just last term in Trump v. United States, where at pages 620 to 621, the court explained that the president does have a conclusive and preclusive authority with respect to certain criminal investigations and prosecutions, and that informed the court's determination about whether the acting attorney general was subject to at-will presidential removal. It turns out that the vast majority of these executive departments do have some kind of criminal investigative authority, including armed law enforcement agents authorized to make arrests. Now, that's a significant bucket. You probably have
Every agency in the government today has armed police officers, their own police force. Is that really the test of what's conclusive and preclusive?
So we're not saying
it rhymes, but I don't know what it means.
Justice Gorsuch, I think you're making a good point insofar as you're saying there's insofar as Your Honor's point is that there's a lot of what these agencies do that would not be deemed conclusive and preclusive, and we absolutely acknowledge that. And
so the answer to the Chief Justice's question is tomorrow we could have the Labor Commission, the Education Commission, the Environmental Commission, rather than Departments of Interior and so forth.
So I don't know that you could do it tomorrow because, like I said, for the vast majority of agencies, there are at least some conclusive.
So what's the percentage then?
So I don't want to pretend, Justice Gorsuch,
I want to know where the threshold of preclusive and conclusive comes in.
Yes, and so what we would say is that if the
agent, is it a mere scintilla?
I think that's what I think you would have a separation of powers problem if an agency, even if it's a vast agency wielding a broad panoply of powers, if one of those powers is the president's conclusive and preclusive authority, and the officers who are exercising that power are insulated.
So long as one person in the agency is exercising conclusive and whatever that means, that's enough.
So it's enough to have a separation of power, and I wouldn't just say person, I would say a principal officer. It's enough to generate a separation of powers problem, and what is the remedy for that problem, I think is an analytically more difficult question.
What's the difference?
It strikes me, Mr. Agarwal, as I listen to this, if you go back to, let's say, the Education Department with the Chief Justice, which the Chief Justice raised, that the more realistic danger here is that we'll have an education department as authorized by Congress, by law, that won't have any employees in it.
I think you're absolutely right, Justice Kagan, that there are competing dangers here, and it makes a whole lot of sense to us to weigh the real world dangers that we know are a virtual certainty that would result from adopting petitioner's constitutional theory, and to contrast those with purely hypothetical risks that have never materialized over the course of American history. And even in the unlikely event that Congress tomorrow was to try to start taking cabinet departments that have been around for a long time and to convert them wholesale into multi-member agencies, which they have never tried to do before. But even if they tried to do that, of course, that would be subject to a presidential.
Well, I think if there's one thing history shows is that we can't anticipate what might happen. And so we might be able to predict what is likely to happen in the very short term, but we don't know. I mean, if we decide this case in your favor now, we don't know what a Congress in 15 or 20 or 30 years might do. We might be able to predict what's likely in the short term. So, I mean, this is going to have longer term implications.
So absolutely, but let me make 2 points on that. First, there is currently no constraint there's currently no case that has ever held that Congress cannot give for-cause removal protections to principal officers serving to a single layer of for-cause removal protection for principal officers serving on a multi-member commission. And nevertheless, notwithstanding the absence of any such precedent throughout American history, we have not seen an epidemic of these problems. In fact, we haven't seen this problem materializing at all. But let me make one other point about the real-world danger that is imminent right now that we know will happen. And that is that if petitioners get their way, everything is on the chopping block. And we're not just talking about the FTC. Opposing counsel said, we're not challenging right now the Federal Reserve. We're not challenging Article I courts, but there is absolutely no principled basis for carving those very important institutions out of their rule.
Well, you're right that the Solicitor General was pressed quite legitimately about things like the tax court and the claims court, et cetera, et cetera. But I don't know that you can make the argument that the logic of his argument is going to cause these allegedly revolutionary results without being prepared to explain more concretely than you have the limits of your own argument. I mean, I could go down the list with you of the cabinet officers and ask you whether you think they could be headed by a multi-member commission whose members are not subject to at-will removal by the president. Should we do that? How about Veterans Affairs? How about Interior, Labor, EPA, Commerce, Education? What am I missing?
Agriculture.
Agriculture.
Mr. Agrawal, are you prepared?
Well, there was a question there.
Yes, so I don't want to pretend to greater certainty than I have about the full gamut of statutory authorities vested in all those other departments. I will say that based on a very quick preliminary analysis, it appeared to us that the vast majority of executive departments wield at least some of the conclusive and preclusive authorities that this court has recognized in the past, including criminal, investigative, and prosecutorial authorities, and also authorities implicating national security and foreign relations. Now, that is not to say, Justice Alito, I think you're absolutely right to say for a lot of those, you could probably take those out. And at that point, there's going to be a fair question about whether Congress and the president acting together could determine at some point that there is a need for a multi-member body of experts to preside over certain government functions. And what I would say is, I don't think that you should categorically rule out that possibility as a matter of constitutional law. And I can't sit here today and tell you that there's a distinction of constitutional proportions, for example, between the Department of Labor and the National Labor Relations.
Well, how about the post office at the time of Myers? How does your exclusive and preclusive theory account for Myers? How can it be that the postmaster at that time exercised exclusive Article II power, but a federal trade commissioner does not?
So I would say three things about that. First, the conclusive and preclusive standard does not have to be the sole and exclusive limiting factor. Second, there is a provision that Justice Barrett referred to in the colloquy with opposing counsel about the take care clause. And it is conceivable that at least in some circumstances, the take care clause might itself, not always, but sometimes impose a conclusive and preclusive standard, for example, with respect to officers like the postmaster and Myers who are deemed to possess purely executive functions, as this court unanimously and Humphrey's executor, and then again in Wiener unanimously characterized the functions of the postmaster and Myers as purely and obviously just executive. So that's a second constraint.
When you answered Justice Alito about the agencies exercising investigative power, and thus there would be a question whether they could be made independent multi-member commissions, don't a lot of the now independent agencies also exercise that kind of investigative power? At least from my experience, it's very hard to get into the weeds of this particular powers exercised by the FTC and distinguish it from some of the powers exercised by some of the other cabinet agencies that we traditionally think of as executive, or the FCC or the SEC. All of those seem to the FERC, NLRB, when you get into them all. So what's your answer to that?
So my answer is the criminal investigative authority is different. And certainly a lot of these agencies have civil investigative authority, including the FTC. As we understand this court's precedent just from last term in Trump v. United States, criminal investigations and prosecutions are in a different category, at least as a general matter. And if the logical import of that analysis is that is that there are certain functions that cannot be wielded even by traditional independent agencies, then so be it. That's the law of the land.
That's right. I'm sorry. Go ahead, please. Go ahead.
Go ahead.
All right. I understand conclusive and preclusive entirely as we used it when you're speaking about executive power. Can the president control what's done in his departments? I get that. And a criminal prosecution is a good example. I do not understand it as you use it. Why isn't it just as conclusive and preclusive to decide whether to bring charges under the FTCA Act against somebody? Civil versus criminal. It's a conclusive and preclusive decision about enforcement decision of the power of the federal government against individuals across the country.
So there's a legal answer and there's an historical answer, and they might blend, Justice Gorsuch. And the legal answer is that we don't have any controlling authority that has ever held that civil enforcement as a categorical matter is the kind of thing that can never be vested in a multi-member agency that enjoys a modicum of insulation from political pressure. And we know that, for example, from this court's unanimous decision in Humphrey's Executor, where you had that kind of civil enforcement taking place, and a unanimous court, including all 4 justices from Myers, said that's okay. And the kind of civil enforcement that was going on there, you had complaints being issued, you had cease and desist orders.
Cease and desist orders, but not lawsuits in court. They had to go to court. And I'm just curious, though. Fine, I accept your point. It's a good point about Humphreys. But why isn't that conclusive and preclusive decision whether to use the federal government's full power in a prosecution where you can seek fines and incur all of the penalties that are associated with violating the FTC Act?
So I think part of the answer is historical and part of the answer is functional. And on the historical part, we have had all kinds of civil enforcement of federal statutes taking place, including just private statutes that authorize private attorney generals, as this court has recognized in many, many cases. So we have a long, long history and tradition of private actors wielding kind of enforcing civilly federal statutes. Now, I take the point that civil enforcement on behalf of the government of the United States.
That's not the executive power, but criminal actions is the executive power.
I would not say
that's what you're asking us to.
No, I would not put it that way. I would not say it's not executive. And in fact, in SEALA
so it
law,
is executive?
In SEALA law, this court said it's not only executive, it's quintessentially executive. And that's okay, because agencies like the FTC also engage in adjudicative activities, and that would be deemed quintessentially judicial. And nevertheless, they're not subject to plenary removal on the part of the judiciary. They engage in rulemaking that could be considered quintessentially legislative, and nevertheless, they're not subject to plenary control on the part of the legislature. The issue is not whether it's executive in some sense. The issue is whether it's constitutionally committed to the president's sole and exclusive discretion. And as a matter of history and precedent, we haven't gotten there yet.
So even some quintessentially executive functions, in your view, are not vested in the president of the United States?
Yeah, I would not say that. I would not put it in this. I would not say that they're. Yes, I would say they're not.
You have to say yes to that based on what you've just given
They're not
us.
Constitutionally committed to the person of the president and to his sole and exclusive discretion.
Didn't we
Yes.
suggest as much in Humphreys? I mean, didn't we have some lines in Humphreys that say, to the extent that it exercises any executive function as distinguished from executive power in the constitutional sense, it does so to discharge, it does so in the discharge and effectuation of its quasi-legislative or quasi-judicial powers. So I thought that in Humphreys, we recognized this idea that you could have an agency that's exercising legislative or judicial powers still engaging in some executive function, and that doesn't make it an executive agency.
That is exactly right. And on top of that, we have a lot of agencies over a long period of time engaging in all manner of civil enforcement of federal statutes. And yet we do not have a single example of any case from this court in more than 2 centuries that has ever held that a single layer of for-cause removal protection cannot apply to a principal officer of an agency wielding that kind of civil enforcement function.
And so I think that's like your real point. In other words, you're not asking for some sort of conclusive or preclusive rule. That's not your burden in this situation. You are just saying that the way the law has been interpreted by the court here, the existence of Humphreys and Congress's reliance on these kinds of multi-member agencies for something like 90 years plus, that's the background rule. And so now it's up to the government and the Solicitor General to come in to suggest that there's a constitutional problem with that.
That is absolutely right. We have a 111-year-old statute that was enacted by the people's elected representatives. It was signed into law by a president of the United States. It was unanimously affirmed by this court, and it's been followed by every single president since 1935 until the present. We don't need an abstract theory to tell us that the FTC Act is okay. It's the other side that needs to give you a really compelling theory to explain why, in our view, 200 plus years of precedent and history need to be abandoned. But in any event, even according to by their own acknowledgement, we're talking about the modern era of traditional independent agencies, which spans more than half the life of the Republic.
Can I ask you about some other limits of your argument? So most of the independent agencies by statute must include members of both major political parties. Is that a constitutional requirement?
I don't think so.
Could Congress create independent agencies with, let's say, 10 or 15 or 20-year terms?
I do think at some point, Justice Kavanaugh, that if there is not sufficient mechanisms of adequate presidential supervision, that you could have a problem. My advice to the court.
This is important.
Yeah.
Why? You got to have a theory on that.
Yeah, absolutely. So there is a take care clause in Article 2, Section 3, and we don't dispute that the activities of these agencies are operating within the purview of the executive branch, and they should be subject to constitutionally appropriate presidential
So do they have to turn over with each new president then?
So in the case of the FTC, I don't think you want to.
And if they don't have to turn over with each new president, what's the difference between 7 years and 20 years, constitutionally speaking?
I think our position is that the FTC, no matter what kind of rule that you articulate, would be okay because we have the staggered terms and presidents have the opportunity as a practical matter to influence the composition of the FTC. You start to get into more difficult line drawing problems if you imagine hypothetical scenarios where presidents, you have longer terms and maybe fewer officers, and maybe presidents in that circumstance don't have.
What about the chair? Usually the chair has been removable at will as chair by presidents, but that's been a matter of statute for most of these. Is that constitutionally required?
No. And we know that from Humphrey's executor, actually, because at the time of Humphrey's executor, the chair of the FTC was not removable by the president. And now it was in the Reorganization Act that took place some 15 years later, the president now has that designation.
So I think putting those three together, your position would allow Congress to create independent agencies, maybe converting some of the existing executive agencies into independent agencies with no political balance requirement, with a long term, say 10 or more years, and with the chairs not subject to removal as chair. So you can imagine a situation, and I just want to give you a chance to deal with the hard hypothetical, when both houses of Congress and president are controlled by the same party, them creating a lot of these independent agencies with or extending some of the current independent agencies into these kinds of situations so as to thwart future presidents of the opposite party. And to Justice Barrett's point, I don't think we can just say, oh, that hasn't happened, so it'll never happen.
Absolutely. And I don't think that you should articulate a rule that categorically rules out the possibility that some statute in the future might not provide for adequate tools of presidential supervision.
But what would be the theory? I mean, that's what I'm getting at. There's, just picking something out of thin air. What is the theory?
One textual basis in the Constitution for that would be the Take Care Clause of Article 2, Section 3, which does require the president to take care that the laws be faithfully executed. And this court could hold that that requires that the president have constitutionally adequate means of supervision, such as those that are adverted to in Part 3C2 of CLA law that discusses exactly the types of considerations to which Your Honor is referring, the designation of the chair, the staggered terms provision, and the opportunity to influence the composition of the commission, budgetary tools. All of those the FTC has, and so we're on the right side of the line wherever you draw that line. But I guess the bigger point is that historically, this is a problem. This is a problem that has been resolved through a process of political accommodation. And there's no reason to believe that that process, which has been adequate for a very long time, will not be adequate in the future. But if it is, the court can keep open the possibility that there will be time enough to decide on new constitutional rules.
How do you answer the accountability theme, which I think is the theme of the other side, is that independent agencies are not accountable to the people. They're not elected, as Congress and the president are, and are exercising massive power over individual liberty and billion-dollar industries, whether it's the FCC or the FTC or whatever it might be?
May I answer?
Sure.
It is an entirely legitimate concern, but there are countervailing accountability and liberty concerns on the other side. And so, for example, you have an amicus brief that is submitted by the Reporters Committee for Freedom of the Press in this very case that talks about real dangers to freedom of the press, to individual liberty, to free speech rights that would result from saying that agencies like the FCC are all of a sudden subject to at-will presidential removal. And they discuss the history, just as one example, this precious First Amendment right that could in every meaningful sense be jeopardized if we abandon long-standing history and retroactively invalidate the independence of independent agencies. The last thing I would say, if I may, Justice Kavanaugh, in response to that point on political accountability, is that I think it would be a really unfortunate way to vindicate the principle of democratic accountability for this court to effectively invalidate. We're not talking about 1 or 5 or 10 or even 15. We're talking about more than 24 traditional independent agencies that have been established by statutes enacted by the people's elected representatives and signed into law, all of them by democratically elected presidents. If it is really true that these kinds of for-cause removal protections, which after all authorize the president to fire commissioners just for good cause, if they really pose this fundamental threat to the republic, petitioners could take their argument across the street and Congress could solve the problem tomorrow. They're not willing to do that.
Thank you. Thank you, counsel. You mentioned Humphrey's executor quite a bit, and also CEDA law. And the one thing CEDA law made pretty clear, I think, is that Humphrey's executor is just a dried husk of whatever people used to think it was, because in the opinion itself, it described the powers of the agency it was talking about, and they're vanishingly insignificant, has nothing to do with what the FTC looks like today. And yet it seems to be your primary authority. It was addressing an agency that had very little, if any, executive power. And that may be why they were able to attract such a broad support on the court at the time. I mean, putting Humphrey's executor aside, what's your next good case?
We have 2 other cases in which the court has had occasion to assess the constitutionality of a single layer of for-cause removal protection applicable to a multi-member commission. And those 2 cases are Weiner v. United States and Free Enterprise Fund. In both of those cases, the court unanimously concluded that a single layer of for-cause removal protection does not offend the separation of powers, even with respect to significant executive authority.
Situation involving adjudicative authority that the court did not say in deciding Humphreys was at issue.
A couple of responses to that, Mr. Chief Justice. First, petitioner's theory is based on the assumption that anytime you have an officer who is acting outside the auspices of Articles 1 and 3, no matter what kind of function they are discharging, what they are doing, quote, is and must be deemed an exercise of the executive power. And if that is true, that sweeps in the commissioners of the War Claims Commission. It sweeps in the Federal Reserve. It sweeps in the Court of Appeals for the Armed Forces. Their constitutional theory cannot be distinguished on that basis.
Well, what about regarding them, as I think Justice Gorsuch was discussing at one time, as adjuncts to the judicial authority, which would be something that would cover the court, would think in Wiener?
If this is a viable distinction to say that there are certain functions that are being performed that are of an adjudicatory nature and that some kind of exception should be carved out for that, then why not for the FTC, which after all does exercise adjudicative powers? Indeed, as this court explained in Axon Enterprise v. FTC, the FTC...
Well, sure. Go ahead.
The FTC stands in the shoes of the district court. In such cases, it's doing exactly the type of thing that district courts do. It's finding facts and reaching conclusions of law.
Yeah, but it does a lot of stuff in addition to that Wiener, the court in Wiener did not do. And many of these other entities that you've been talking about with exercise judicial responsibilities might properly be considered adjuncts to the judicial power in Article 3 as opposed to purely executive power, which was not at issue in Humphreys or Wiener.
Two responses to that, Mr. Chief Justice.
Sure.
In Wiener, the Claims Commission members were making final and unreviewable determinations with respect to claims for compensation, and they were getting no judicial review. That was final determination, but the more important point is that in Free Enterprise Fund, there was all manner of executive authority that was being wielded by we're not talking about the 1935 FTC, we're talking about the 2010 Securities and Exchange Commission and the 2010 Public Company Accounting and Oversight Board. This court characterized the board's functions as involving enormous power to regulate an entire industry. Nobody would say that that was not executive, and nevertheless, the court unanimously concluded that a single layer of for-cause removal protection, exactly what we have here, is constitutionally permissible. On top of that, we don't again have a single case that has ever struck down the kind of removal protection that we have here in more than 200 years.
Thank you. Justice Thomas?
You used, when I asked you, or when a number of us asked you about making some of currently the executive branch cabinet level agencies multi-member agencies, you resorted to the functionality of the current agencies such as Commerce as precluding that, or at least as being a basis for not doing that. Now, moving the other direction, could you functionally, you say that from a functional standpoint, the FTC is not an executive branch agency, and you listed some of its functions. Could Congress convert the FTC to a single member head with the same protections? Because it engaged in discharging the exact same functions.
No, under this court's precedent.
No, could they, under the logic of your argument?
No, we accept CLA law as not only the law of the land, but as being correct.
So what's the limitation? Your argument was functionality before, not necessarily precedent. And I'm interested in why would the FTC functionally be any different as a single member head than it is as a multi-member agency?
It is because CLA law is correct, not just because it's precedent, but because it's correct to hold that there is a particular danger to individual liberty that is posed by the single director, highly anomalous circumstance that had no foothold in history and tradition, and that vested a massive quantum of power in one person who was not directly accountable to the president.
I don't understand why that's any different from a multi-member agency.
For all the reasons, Justice Thomas, that this court explicated in CLA law itself, and in particular in parts 3C1 and 3C2 of the decision, where the court talked about basically two categories of considerations. One is the foothold in history and tradition, and the second is whether the configuration of the agency poses a problem for structural separation of powers principles. And in both of those, the court explained, and elsewhere throughout the opinion, the implications for individual liberty of taking massive amounts of governmental power and putting them in the hands of one person who's not accountable to the president, as opposed to where you have the multi-member structure. As a practical matter, there needs to be consensus, there needs to be deliberation, there's a safety valve in terms of dissenting opinions can be issued, and that can provide an alert to the public that something is going on. So there's a whole variety of reasons why single-member agencies have been distinguished from multi-member commissions, and we think that precedent is correct and should be adhered to. And on that point, Justice Thomas, I guess I would say one more thing, and that is I think it is a big difference between our position and the position of the petitioners, that we are asking the court to adhere to all of its precedents and to give effect to the collective wisdom and experience of all three branches of government. On the other hand, petitioners are asking you to abandon precedent after precedent after precedent. A lot of precedents would go south if their constitutional theory is correct, and a whole lot of history and dozens of institutions that have been around for a long time, that have withstood the test of time, that embody a distillation of human wisdom and experience, all of those would go south.
Justice Alito? To follow up on Justice Thomas's question, suppose that the FTC did not have that the members, the commissioners did not serve 7-year terms, staggered 7-year terms. Suppose there was not the requirement that no more than 4 be members of a single political party. Suppose that they served very short terms. Why does it matter that it's a multi-member body as opposed to a single-member body in itself? What is significant about that?
The significance is the distinction for purposes of individual liberty, the threat that is posed to individual liberty by single-headed agencies that are not accountable to the president. That, as I understand it, Justice Alito, is the logic of this court's decision in seal of law, and we recognize that intelligent people of goodwill can disagree about that.
Seal of law didn't have to decide the question that's before us here. I mean, suppose that there were 2 FTC commissioners and they served 1-year terms. And you would say, well, that's okay, but there's a difference between that and an agency that's headed by a single member.
Making the terms shorter, in my view, would not raise constitutional concerns, because that would only increase presidential opportunities to influence the composition of the agency. Reducing the number of commissioners might be a different type of situation. I'm not aware of any 2-headed agency that has ever been created in the modern era or throughout American history.
Well, okay, what we're looking for are conceptual explanations for the distinctions you're drawing. But let me move on to something else. Suppose the Department of Justice were split into 2 parts. One part has the authority to enforce the criminal laws, and the other part has the authority to enforce civil laws. Could the civil component, could Congress put at the head of the civil component a multi-member commission with removal protection?
Justice Alito, there is the logically antecedent question with respect to any removal protection of whether Congress has constitutionally enumerated authority to enact the protection in the first place. And as has been suggested in prior colloquies, the relevant source of constitutional authority would appear to be the necessary and proper clause in terms of attaching removal restrictions to a federal office that is created by Congress. I don't think it's obvious that you would comply with all the strictures of the necessary and proper clause ex ante. And so it's not obvious that Congress could do that. And what we know for sure is that Congress has never tried to do that.
Well, I know you keep answering it hasn't been done and it's not going to be done in the future, but I want to understand the limits of the principle that you're asking us to accept. So you cannot say, no, that would not be permitted for this reason.
Well,
the best you can say is that it might not be necessary and proper.
If you wanted, that is one source of limiting principle for sure. But also, our argument is predicated in part on a long historical tradition pertaining to what are
I
called—
understand the historical argument. That wasn't what my question was getting at. All of the civil enforcement laws, all of the civil laws that are now enforced by the Department of Justice were enacted by Congress under one of its enumerated powers. Let's assume that they were all constitutional. So the question is whether it would be necessary and proper to the enforcement of those given the understanding of necessary and proper, to entrust that to a multi-member commission as opposed to a single officer like the Attorney General? That would be the question.
I don't think so. And what I was trying to get at before is not just that there's an historical tradition, it's that the historical tradition we're invoking is for what are called traditional multi-member regulatory commissions. And those historically have never involved purely executive civil enforcement. They involve a blend of lawmaking, adjudicatory, and enforcement actions where the enforcement authority is deemed to be reasonably ancillary to the other functions. So the kind of hypothetical that you're positing, Justice Alito, I think it's an absolutely legitimate concern, but the historical tradition that we are drawing on for purposes of our constitutional liquidation argument would not require you to affirm the constitutionality of that kind of highly unusual structure that, as far as I know, has never been attempted before.
On the question of giving the members of a multi-member commission longer terms of office. So here we have 7 years. What if it were increased to 10 years? What if it were increased to 15 years and so forth? And the principle that you would have us apply is whether that longer term of office preserved adequate presidential supervision. Is that your answer to the question?
That is one potential limiting principle.
We would have to, in each of those, in every case in which that would be involved, we would have to determine, do I think this preserves adequate presidential supervision?
Our primary submission to you, Justice Alito, would be that it would not be the burden of the court to develop ahead of time heavy-handed constitutional rules that would try to make constitutional distinctions between, say, a 7-year term and a 9-year term or an 11-year term. Those don't appear to us to be distinctions of constitutional proportions. Members of the Federal Reserve do have substantially longer terms than, say, FTC commissioners, and nevertheless, petitioners don't seem to have a problem with members of the Federal Reserve enjoying statutory removal protections. But our position is that the court should recognize that these are really difficult line drawing problems, and the way that that has historically been resolved is through the political process, and the political process is up to the task of dealing with this problem.
But you wouldn't say that we leave it complete. Would you say we leave it completely to the political process? So that at no point in the extension of these terms would we say, oh, there's a problem. I thought you were saying there is a test. And it is whether there's adequate presidential supervision. And if that were challenged, we would have to decide. We would have to exercise our judgment about how much presidential supervision is necessary to satisfy constitutional requirements.
Absolutely. The court should not relinquish its authority to establish judicially enforceable outer boundaries in this context. I just don't think that you're going to have to do that anytime soon, and you might never have to do it, but you should absolutely not relinquish your authority to do it. And there could be hypothetical scenarios in the future in which there's an arrangement that just palpably does not guarantee adequate presidential supervision, but that hypothetical risk, again, has to be measured against the real world chaos and disruption that will be caused by taking—
Okay, one other question about where your argument would lead. So to go back to this issue of the various departments and whether it would be permissible for Congress to convert them into agencies headed by multi-member commissioners, by multi-member commissions with the members protected from plenary presidential removal authority. The test would be whether some limit on permissible, limit on exclusive and preclusive activities was exceeded.
Our primary—
Do they go to, if they're exercising any power that is exclusively and conclusively the president's are they exercising too much of that? That would be the test in going through these departments?
No, I think if they're exercising any power that is conclusive and preclusive, then you have a separation of powers problem. That's the solution to which is not necessarily to strike down the entire agency or even to eliminate the for-cause removal provision. It creates an analytically distinct issue about how you remedy that violation. But I think any conclusive and preclusive power that is vested in an agency that is not sufficiently accountable to the president is a problem.
Okay, I thought you had answered, in answer to a prior question, you said a mere scintilla would not be enough, but now you say a mere scintilla would be enough to cause a problem.
I may have misspoken before, Justice Alito, and if I did, I apologize, but our position is that if a multi-member agency is vested with the president's conclusive and preclusive powers, and it is insulated from at-will presidential supervision, that is a separation of powers problem.
It does 200 things, and one of the 200 things involves the exercise of an exclusive and conclusive presidential power. That would be too much.
That would be too much with respect to that power, but maybe the solution to that is to sever out that power and not to strike down the entire agency.
Thank you.
Justice Sotomayor?
Counsel, Sheila law involved the CFCP, and it relied very heavily on, focused very heavily on the novelty of the CFPB structure and the fact that it was a historical anomaly, correct?
Absolutely. It was an anomalous structure that was deemed to pose a significant threat to individual liberty.
All right. That's not the case here because we have a precedent of longstanding that says this is okay. The chief asked a question about whether the additional powers the FTC has gathered create a different situation. As I see it, and as the judge in the district court outlined very clearly, most of the original powers of the FTC when Humphrey's estate was decided are the same powers of today, correct?
That is correct.
And there is one power that I've identified that might be different, and that the FTC cease and desist orders have now binding effect immediately, correct?
I believe that's correct.
So I think your point in response to Justice Alito is, if there's a power that the FTC is wielding now that trenches inappropriately, the answer is not to do away with the for-cause removal, but to eliminate that power, that individual power, correct?
Correct, and an authority that is cited by petitioners in their reply brief, Barr v. AAPC, supports that proposition.
And so that should be the answer if there's been a difference in the powers or an expansion of the powers inappropriately.
That is our position. Yes, the parties have not briefed severability at the merit stage of this case, and in the event that the court wants to reach that question, you might consider either supplemental briefing or remanding to the district court to decide that issue in the first instance.
Thank you, counsel.
Justice Kagan?
Mr. Eckerwall, it seemed to me that when you were talking to Justice Alito, you had more to say about this question of comparative risks and how we should balance the two kinds of risks and what we should be thinking about now. So I wanted to give you a chance to say that. But and within whatever you want to say about that topic, I was wondering if you could comment. A lot of these hypotheticals have been about, what if Congress structured an independent agency like this or like that? I mean, most of these independent agencies, Justice Sotomayor is right that the CFPB was anomalous in this respect, but basically, like, the vast majority of them all use the exact same structure, or if not exact, near exact same structure. There are little variations, but they're all set up with bipartisanship. They're all set up with a chair that does have some greater control and that is more controllable by the president. They're all basically set up the same way. So all of these hypotheticals about what if Congress did this, I'm wondering if you could comment in your discussion of comparative risks about how we actually why it is that we actually have just never seen that.
I think it's because the political branches have learned from experience, and experience is the great teacher. There's an insightful discussion of the history and tradition surrounding traditional independent agencies and the separate opinion in the PHH case that has been cited extensively by the parties, and that explains that the structure that the political branches have come up with honors and gives effect to our constitutional values, as we explain on the very first page of our brief. We think that the political branches have done a good job of learning.
I mean, the political branch is Congress, which is made up of both Democrats and Republicans, who are aware that neither Democrats nor Republicans will control the government forever and are structuring these systems with that in mind.
I think that is exactly right, Justice Kagan, that there's an appreciation and an understanding that folks in power today may not be in power tomorrow, and you want a structure that will be able to withstand the test of time. The other kind of interesting thing about this is that it's not just Congress. It's Congress acting together with the president every single time. In the case of the FTC Act, the act has been amended time and time and time again since this court's decision in Humphrey's executor. Presidents are signing all of those bills into law. They are supporting the FTC in a myriad of ways. They too have read the vesting clause of Article 2, and they too believe in preserving executive power. It is simply implausible to say that presidents have been supporting these traditional independent agencies now for more than a century and a half. And even from the first Congress, George Washington signing into law the Sinking Fund Commission, the Revolutionary War Debts Commission, the Mint Commission. It is absolutely implausible to say for the entirety of American history, presidents of the United States have been complicit in giving up a vital executive power that is, according to petitioners, indispensable to their constitutional duty. The better answer by far is to say that presidents have understood and appreciated that vital interests of the American people can be served by having constraints on the exercise of power. That is a really important part of our constitutional tradition, and that is what petitioners are putting at risk.
You mentioned some of the early history, and I think I want to give you a little bit of a chance to talk about that because we haven't. You know, when I was a young lawyer and this unitary executive theory really got its start and got its legs, there was a pretty simple version of the history, and that drove a lot of the early discussion of the unitary executive, what was wrong with Humphrey's executor. What have the historians been telling us more recently about that sort of early understanding of the history? And you know, like bring us up to date here a little bit about where the history is with respect to these issues.
There's an insightful discussion of this in an essay authored by Professor Nelson that we have cited in our brief and that cites recent historical scholarship. And there is also many amicus briefs that have been submitted in this case, which basically affirm that there is a rich body of recent, including post-CLA law historical scholarship that supports the conclusion that the history surrounding this issue is at a minimum contestable, and that there is a whole lot of history actually that supports the proposition that the first president of the United States and the first Congress did not believe that the president always and everywhere had to have an absolute, illimitable, indefeasible power to fire every single head of any kind of commission exercising any significant governmental authority. We know that from the first Congress and the Sinking Fund Commission, the Revolutionary War Debt Commission, the Mint Commission, and I think there are some 10 other commissions, for example, that are discussed in Professor Norse's amicus brief, just by way of example. I think that's another virtue of our position, that we're asking the court to give effect not just to the decision of 1789, but also to the decision of 1790. The other side's not doing that. They want you to give a maximalist interpretation to, for example, the decision of 1789, which we agree settled the question of whether the Senate should be able to interfere with presidential removals. But everything else, as Professor Nelson explains, as many other scholars have ably explained, is highly contestable at a minimum. There's actually a lot of historical evidence that goes the other way. That is all the more reason for this court to be cautious in developing heavy-handed constitutional rules that, one, don't have a clear basis in constitutional text. We absolutely accept this court's precedents that interpret the vesting clause of Article 2 to establish a general default presidential removal power, but it cannot be said the constitutional text clearly delineates the boundaries between the president's power and Congress's power with respect to removal. Then when you add to that a growing body of historical scholarship indicating that original understanding from the time of the first Congress and the first president was that significant governmental authority absolutely could be vested in commissions that were not subject to plenary presidential control, that every single member was not subject to presidential control. And in fact, in a lot of respects, as the scholars have explained, those early commissions were actually substantially more independent than modern day administrative agencies. For some of them, the president couldn't even appoint. He couldn't even decide who would be on the commission, as for example, with respect to the Sinking Fund Commission, where you had the Chief Justice and the Vice President were by operation of law installed on those commissions. So those commissions were in a lot of respects much more independent than modern day traditional independent agencies.
Justice Gorsuch?
Just want to explore just for a brief minute, I hope, your scintilla of conclusive and preclusive power theory. You agree, I assume, the president is vested with all the executive power.
Yes.
You agree that he has a duty to faithfully execute all the laws,
Yes.
civil and criminal.
We agree that the Constitution imposes on the president a duty to faithfully execute the laws.
All the
Absolutely.
laws.
Well,
Is there some laws he doesn't have to? That'd be news to our friends across the street.
the take care clause is a duty, and it is also a power, but the text of the clause does not provide that the president must have at-will presidential.
I didn't ask that. This is, does he have a duty to faithfully execute all the laws?
We know from
Yes or no?
I would say no in the sense
No.
in the sense that let me. There's two different questions, and I want to make sure that I'm answering the question.
The question is, does the president have a duty to faithfully execute all the laws? The answer is no. Why?
So he can't break the law for sure, for sure. Does he have to be vested with statutory authority to actually directly enforce, or to exercise?
I'm not asking whether he has to bring the indictment. I'm asking whether he has a duty to faithfully execute the laws.
I think the president does not, under both history and tradition, have to have plenary power of supervision. But in the case of the FTC, he does have some power of supervision, including if there's a demonstrable, palpable violation of law, the president could absolutely fire a commissioner of the FTC under the plain language of the statute.
So the answer is no, I guess. But you say that he has to have direct supervision and removal authority for someone who has conclusive and exclusive authority to bring criminal prosecutions, right?
That is our understanding of this court's decision in Trump v. United States.
That's your understanding?
Yes.
But not civil?
That's right. And to go back to earlier.
And then just to be clear, so that means if the government wants to bring a misdemeanor, that person has to be reportable to the president. But if the government wants to bring ruinous fines and penalties and injunctions, that person doesn't.
I don't know the scope of this court's holding in Trump v. United States.
I'm asking you for your theory, because it's a very interesting theory. You're building off of two words from Trump versus United States and putting a gloss on it that I'm not familiar with. I'd understood the executive power, and he has conclusive and preclusive authority of that. But this line, I don't know where it comes from. And I'm wondering, I'll be honest, I'll put my cards on the table. Maybe it's a recognition that Humphrey's executor was poorly reasoned, and that there is no such thing in our constitutional order as a fourth branch of government that's quasi-judicial and quasi-legislative. Maybe you're trying to backfill it with a better new theory that itself recognizes that we've got a problem.
The theory that we are referring to, Justice Gorsuch, as we understand it, is not just based on this court's recent decision in Trump v. United States. It goes all the way back to Marbury v. Madison. And Marbury does not use the term conclusive and preclusive, but it absolutely says—
And neither does Humphrey's. It uses quasi things.
It talks about the distinction between authorities that are vested in the president and the president's powers in the constitutional sense, and executive power in the constitutional sense. And it actually cites Marbury v. Madison for that.
Oh, sure, I would hope it would.
For that proposition. Yeah. And Marbury itself distinguishes in the context of removability of federal offices.
I guess I'm just wondering, are we going to get, if we take your theory to backfill Humphrey's and go down this road, how are we supposed to decide which powers are exclusive and for your purposes, as you understand it, not as I understand it from Trump v. United States, but as you understand it, what powers are going to fall in and what going to fall out? Are we going to have just as much litigation over that as anything else we might do in this case?
I don't think so. We've had this modern era of traditional independent agencies for a long time. We haven't had any precedent ever striking them down. And this court has not been, as far as I know, overwhelmed with difficult questions of line drawing. In fact, from 1935 to 2025, we had pretty much unanimity among courts that traditional independent agencies are fine. To go back to
We haven't had a lot of litigation over Humphreys and its limits and its boundaries. And I mean, seal of law, you invoke it as a great decision. We've had a lot of litigation.
We do invoke seal of law as a great decision.
We're always going to have litigation of this separation of powers, aren't we?
There will always be litigation, absolutely. But the point is that this court's precedents affirming Congress's authority to work with presidents to create traditional independent agencies has not generated any significant problems, still less insurmountable problems.
Thank you.
Justice Kavanaugh?
Try to tick through a few questions here. On Justice Alito's questions, you said independent agencies do rulemaking, enforcement, and some adjudicatory powers as well, but so do the traditional cabinet agencies do all of that too, or at least most of them do. So I'm not sure that helps you distinguish the independent agencies from the traditional executive agencies on the earlier questions, but I'll just leave that. You said you agree with, I think you said you agree with all the court's precedents.
Yes.
That includes everything in Myers.
We agree with the holding of Myers.
Do you agree with the opinion in Myers?
No, and a lot of the reasoning in Myers went too far, and that was part of what the court decided in Humphreys.
On the text of Article 2, we haven't talked a lot about the theory by which you get to the other side's position from the text. The first 15 words, the executive power shall be vested in a president of the United States of America. For the president to exercise that power, he needs subordinates. For him to, and he needs to be able to supervise and direct the subordinates, and to supervise and direct, he must be able to remove those officers at will. This is the theory. Otherwise, and this is what I want to get your answer to, otherwise a subordinate could ignore the president's supervision and direction without fear, and the president could do nothing about it. You agree that's the implication of your theory, correct?
That the subordinate could disregard the president's instruction, and that in some circumstances, the president could do nothing about it. Yes, in some circumstances, but not under the FTC Act in the modern era of traditional independent agencies. If there was anything like malfeasance, if there was neglect of duty, so that would be associated with law breaking, as Professor Manners discusses in her amicus brief on the INM standard.
But generally, if the president says, I wish you'd pursue a more aggressive enforcement policy, and the head of the agency says, I'm not going to do that, there's nothing the president can do about that, right?
If it's just a matter of enforcement priority, that's right. And
or I would want you to issue a new rule in a particular way that does a particular thing, because I think as president, it would be better for the American people. And the agency head says, I disagree with that. I'm not going to do that. You agree that that's okay under your theory.
That is okay under our theory. That's the judgment of Congress and the president. And as was pointed out in Ray Aiken, and as we've explained in our brief, this court's precedents don't stand for the proposition, Justice Kavanaugh, that we have to have those arrangements. They just stand for the proposition that the people's elected representatives in Congress and their democratically elected president in appropriate circumstances can come together and decide that vital interests of the American people, including preservation of liberty, and I don't think we should forget about that, including that can be effectuated by having these multi-member commissions.
Two real world questions. You've mentioned many times you can just go to Congress to fix this. Well, once the power is taken away from the president, it's very hard to get it back in the legislative process. Kind of the flip side of what we were talking about in the tariffs case. Because the Congress, the real world of this is the independent agencies shift power from the presidency to the Congress. Everyone recognizes that. The Congress has more control over the independent agencies than they do over the executive agencies. So Congress doesn't want to give that up. It's hard for the president to get new legislation passed that would, for example, convert an independent agency into an executive agency. Do you have an answer to that I think just leave it to Congress ignores the reality of the legislative process and Congress's desire to keep that power that they have had, that most people have recognized over the independent agencies. That's a theory out there. I just want to get your response to that.
Yeah, I have two responses to it. One is that I don't think it's an accurate characterization of what's going on to say that Congress is aggrandizing its own power at the expense of the executive. I think, in fact, exactly the opposite. And a lot of these agencies—
That famous quote, "The independent agencies are ours," by a leading member of Congress, that was just—
I will give you an example from the FTC Act itself. The operative provision from the very first version of the Act provides that this Act is all about defining unfair methods of competition in commerce, full stop. How do you know what is an unfair method of competition in commerce? The statute doesn't say. It delegates that congressionally, constitutionally enumerated authority to an agency that the president has all kinds of supervision and influence over. And what is happening—
But much less than the executive agency. I understand your point there. I think I got it. Your brief refers to regulatory stability being a virtue served by the current overarching regime. I don't think a lot of the regulated parties really think stability has been a virtue of the regime because it goes back and forth when the agencies shift power. And so I think, unaccountable instability would be what they might say. So can you address why you think, and this is relevant to the stare decisis factors, I think, why you think regulatory stability is actually occurring at a lot of these independent agencies?
Yeah, absolutely. So two things. One is that part of the logic of that comes from this court's decision just last term in the Chevron case, where the court said you can have a lot of regulatory instability if every single time a new administration comes into office, all of a sudden everything can change. Now, that is a problem on steroids if petitioners get their view, because you don't even have to wait for the administration to change. The president could just on a whim decide tomorrow that everything the agency has been doing is wrong. Public reliance on stability presupposes that this is the whole point of the staggered terms requirement that this court explained in detail in Humphrey's Executor, that the whole point of this structure is to guarantee a modicum of stability that private regulated entities can depend upon, and that is jeopardized by at-will presidential removal.
Two more quickly. Hopefully you've used the phrase chaos and disruption if you lose, and don't strike down the entire agency. I think you used that phrase. I don't think that's what would happen if you lost, and I think you would agree with what I'm about to say, which is if you lose on the merits, the proper remedy is simply to sever the for-cause removal provision, not to get rid of the FTC. Do you agree with that?
I agree with part of it, but not all of it. The remedy is not to get rid of the FTC, but I think there's an analytically difficult question about whether the proper remedy would be to sever the for-cause removal provision, as opposed to, depending on the nature of the ruling, maybe one isolated power that is deemed to be quintessentially executive and that generates the separation of powers problem.
Okay, last, sorry about the length of this, but this is important. Last, you said Congress, as a tradition, they won't depart from it, but the last 10 years, we've seen two examples of first a single-headed independent agency and separately a double for-cause removal provision. So I don't think the idea that Congress is just following the model that it's used before is really sustainable in the face of those two experiments that we've seen in the last 10 years. That's just a comment from your point about, oh, there's a model and they just follow the model.
It is not an absolute rule, and there may be times when the political branches depart from an established model, and when they do so in constitutionally problematic ways, what we know from recent history is that this court will be there and there will be time enough to decide those questions.
All right, thank you for your answers.
Justice Barrett?
I want to just ask a quick question about history. Justice Kagan was asking you about new scholarship that historians have identified, which you say shows that independent agencies has a longer pedigree than maybe some thought originally. But do you concede that the first statutory, anything that looks like a statutory removal restriction, like the inefficiency, neglect, malfeasance, appeared in 1887 with the ICC?
I don't know if it's the first, to be honest with you, Justice Kagan, Justice Barrett, I'm sorry. But what I would say is that as to the early commissions, I think that factor actually cuts the other way, because there was no provision authorizing presidential removal for some commissioners. That's our point. You had commissioners like the Chief Justice and the Vice President who were appointed by statute, and the president couldn't remove them under any circumstances.
But they were 2 of 5, and it could remove, he had unchallenged authority to remove the other 3 who served on that commission. I mean, and there's silence. I mean, there's not the inclusion of statutory removal restrictions. You didn't really see that until the ICC.
They were understood at the time to be, for the officers like the Chief Justice and the Vice President on the Sinking Fund Commission, for example, to be completely insulated from presidential removal. And it wouldn't make any sense for the president to be able to remove them from the commission. That was not the understanding at the time, as has been ably set out by many historians. But here's the bigger point, is that those commissions are in a lot of ways much more independent than modern day independent agencies. And petitioner's theory is based on the idea that any time these commissions are exercising significant governmental authority, every single commission member must be subject to at-will presidential removal. And in that respect, their theory cannot be squared with founding era
But
practice.
counsel, the sinking fund had the Secretary of State, Treasury, and the AG, and there's no dispute, even under your theory, that the president could fire those three. So sure, the Chief Justice and the Vice President, but he could very easily take control over the fund. Also, we distinguish that in Collins. I mean, it seems to me that these early examples had very, very limited authority. I mean, the Mint, or the Revolutionary War Debt Commission, there were no statutory removal restrictions, and all it did was settle accounts between the United States and individual states after the war. I mean, there's nothing that looks like the FTC at the time of Humphreys, or certainly not today. You have to concede at least that.
Yes, and two responses to that. I think it's a fair observation. But first, for the Sinking Fund Commission, for example, maybe it didn't wield the broad panoply of authorities of the FTC. That's fair enough. But Alexander Hamilton thought that it was absolutely indispensable to the health of the national economy, and that this was about managing the public debt. And he thought that it would implicate the nation's stability going forward. That's why they thought this governmental function should be vested in this multi-member commission. So it was not something that was deemed to be insignificant by any stretch of the imagination. But one more point on the difference between the 3 members and the 2 members. We have real world evidence. This is not an abstract thing. We have real world evidence of Chief Justice Jay, I believe it was, who could make the dispositive vote difference in terms of the Sinking Fund Commission of when they make a decision that the president's cabinet supports, when they make a decision that they don't. And so the fact that there are some members of the commission who are conceitedly not removable at will by the president, that just makes our point that the first president of the United States and the first Congress emphatically rejected the constitutional theory on which petitioner's position is predicated.
Counsel, let me say, let's say, just assume that I disagree with you about the history. Let's assume that I think, I'll grant you for this purpose that the decision of 1789, if you just took it in isolation, maybe not as conclusive as Myers thought it was. I'll just grant you that for purposes of this question. But let's say that I think the liquidation argument throughout the 19th century shows that by the time of the end of the 19th century, up until we get to the ICC, and the emergence of what starts to look like the more modern independent agency, that the government has the better of the argument. But let's say that in 1887, after the ICC, and then after the FTC, and then after Humphreys, when there was more of the explosion of independent agencies, that let's just assume, again, for this purpose, that at that point, yes, you do have precedents like Humphreys. Humphreys clearly is a good case for you. Do you still lose? If I think as of 1887, it was liquidated, it was settled, but then we did have cases and congressional practices that veered from that unbroken line.
No, we don't lose. We don't lose on the merits, and we certainly don't lose on stare decisis. So on the merits, the doctrine of constitutional liquidation by historical practice absolutely can apply based on the last 150 years of history.
But counsel, if it had the first, I mean, in the assumptions that I've asked you to make, it was liquidated as of 1887. So you think liquidation can kind of get a new restart, like kickstart in 1887?
That is not just my view. That is the view of this court in cases like, I believe, NLRB, Canning, and Chiafalo. And I would also direct the court's attention to United States versus Curtis Wright Export Corporation, where the court said, you have 150 years of historical practice. That's enough.
Okay.
Justice Jackson?
Really quickly on your exchange with Justice Gorsuch, your hesitancy to respond to his take care question, I'm wondering whether that has to do with the fact that prosecutorial discretion exists and that the idea can't be, I think, that the executive has to always enforce all the laws, right?
I think that's right, and the very authorities that petitioners cite in the reply brief actually stand for that proposition. In cases like United States v. Texas and the Heckler v. Cheney case, the court went out of its way to expressly and unambiguously affirm Congress's authority to regulate prosecutorial discretion by statute.
Let me ask you about Justice Kagan's invitation to expound upon comparative risks. I don't know if we got back to that, but before you do that, let me just also focus in on Justice Kavanaugh's question about losing on the merits and the extent to which the answer would be just striking down the 4-clause removal protections. I mean, I appreciate that, but doesn't that create pretty significant risks with respect to the missions of the various agencies? I mean, it's not just we don't have 4-clause removal and the agency continues. That would then, I think, open the door for the president to come in, each new president, and clean house in terms of all of the individuals who are running that agency, notwithstanding their expertise and knowledge and experience and the things that they are doing to promote the mission of the agency. And presumably the president could install whoever he wanted in those positions. And that, I think, creates risks. So why don't you talk about the comparative risks of your formulation or understanding of the different constitutional dynamics and what the government says should happen in this situation?
Sure, there are real world risks that are palpable that we know can materialize very quickly if petitioners get their way. And think about it in terms of commissions like the Federal Elections Commission. Would anyone want those sensitive election-related determinations to be under the plenary control of a political actor? Think about the Nuclear Regulatory Commission. Can't Congress and the president come together and say those types of technical determinations that could have massive implications for the public in all kinds of ways should be made by a multi-member body of experts? And if there's any kind of problem with the way those commissions are working, they can be changed by the political branches in a heartbeat. And presidents, as far as we know, are not even trying to change them. It's not like they're coming to this court and telling you, we have a big problem, we've been lobbying Congress, and Congress is just, to Justice Kavanaugh's earlier point, they're just not going along with it, and they're not doing the right thing. Presidents are not even trying to go to Congress to get these 4-clause
because presidents have accepted that there could be both an understanding of Congress and the presidency, that it is in the best interest of the American people to have certain kinds of issues handled by experts who, and I think you were in your colloquy with Justice Kagan, you identified the fact that these boards are not only experts, but they're also nonpartisan. So the seats are actually distributed in such a way that we are presumably eliminating political influence because we're trying to get to science and data and actual facts related to how these decisions are made. And so the real risk, I think, of allowing these kinds of decisions to be made by the president, of saying everybody can just be removed when I come in, is that we're going to get away from those very important policy considerations.
You will get away from those policy considerations, and it will create opportunities for all kinds of problems that Congress and prior presidents wanted to avoid, risks that flow inevitably, just given human nature, the realities of the world that we live in, risks associated with extreme concentrations of power in the hands of one person.
Can you talk about the FTC? This is my final question. Why would Congress have thought it important to make this agency in particular independent?
I think in large part because Congress had tried it, experimented with alternatives in the past. They didn't just do this on a whim. They tried to legislate on their own, and they determined that it was not practicable for Congress to exercise its own constitutionally enumerated authority to regulate commerce by, for example, specifying ex ante all the different things that would constitute unfair methods of competition. And so what they wanted was an expert agency that could take on that task and that would be insulated from political pressure, not just emanating from the president, but emanating from Congress too. Congress is giving away its own power to some extent.
So your point is that they were doing something important for the interests of the American people, not with an effort to try to strip the executive of any authority or anything like that, but to fulfill its own Article I obligations to legislate in the best interest of the American people.
Absolutely. And in a lot of ways, they're giving the president more power than he had before, because the president wouldn't have the authority to determine what are unfair methods of competition all on his own. And that's what will be the practical result of accepting petitioner's theory, that tomorrow you'll have a situation where the president can come in and unilaterally decide. This is a quintessentially lawmaking function. Unilaterally decide what constitutes an unfair method of competition, what constitutes an unfair trade practice. If that was going to be the law, why wouldn't Congress just reserve that power to itself?
Thank you.
Thank you, counsel. Rebuttal, General Sauer.
Thank you, Mr. Chief Justice. 2 quick points. On the sort of parade of horribles argument that's being made, I think it's very telling that Mr. Agarwal, one of the last things he said is that the FEC has to remain independent. But of course, the FEC does not have statutory removal restrictions. And under Braidwood, the president already has the power to remove the commissioners of the FEC. Therefore, the notion that like this is the end of the world, it's going to change the structure of our government. The lead counterexample that's given is one that's already been decided by this court's cases. Justice Barrett, regarding the question of historical liquidation, we think the case that you ought to look at is Powell against McCormick. It's very analogous to the sort of historical, what happened in history here. In that case, Congress, from the time of the founding until the Reconstruction Congress after the Civil War, had interpreted the Constitution to not allow it to refuse to seat a member of Congress other than the reasons that are set forth explicitly in the Constitution, the Qualifications Clause. The Reconstruction Congress changed that and decided not to seat a couple of former members who had too close ties to the Confederacy. And after that, for the next 100 years or so, Congress then started exercising that power, not often, but intermittently exercising the power to refuse to seat other members. And this court said in Powell against McCormick, what is decisive there in that point of constitutional interpretation is the liquidation that occurred in the 19th century, not the subsequent, again, very lengthy tenure of practice of Congress refusing to do that. And therefore, it held that Congress lacked the power to refuse to seat the congressman in that case. We think that's very, very compelling here. I think it's very telling that in this particular case, early on, Mr. Agarwal said twice that it is within the realm of possibility that Congress could take, not sure how many, but a significant number of cabinet level agencies and convert them into multi-member agency commissions outside the government's control. How many of them it could do is really a creature of not a question, a constitutional question on his view. It's a question of statutory accident. Are there conclusive and conclusive powers in the organic statute there? If there are, maybe they could be excised. And obviously the devil's in the details here, because if those conclusive and preclusive powers are fairly broad, as the colloquy about civil enforcement powers illustrates, if they're fairly broad, then basically we would win this case and virtually every other case, because almost all the agencies, cabinet level or independent agencies, are going to have civil enforcement powers in most cases and so forth. But if they're narrow, then we have a situation where Congress could reconstruct virtually the entire executive branch outside the president's control. And that is not even a Republican form of government. But that is the logic of the position that's being advanced here. That is the parade of horribles the court ought to consider. And that contrasts dramatically with what, for example, Madison said when he talked about the great principle of unity and responsibility, the chain of dependence that runs from the lowest to the middle grade to the highest to the president. And the president is accountable to the community, which is the voters. In short, Humphrey's executor is a decaying husk with bold pretensions. It has a powerful hold on the minds of some people within our constitutional system. It certainly seems to have a powerful hold on the minds of lower court decisions. The lower courts and their decisions. The court should overrule Humphrey's executor explicitly and restore the separation of powers to our government.
Thank you, counsel. The case is submitted.